संजय हाँ कर लो दिया पेपर लो दिया भाई क्या है सर मैं जान दो उनको मामू नीचे बैठे मामू को लग नीचे बैठे मामू को मामला नहीं चलेगा आपके हैंडराइटिंग एक्चुअली मैंने देखा सर मुझे जबरदस्त है कौन सा पेन है वर्कर सर इसमें जो आपकी हैंडराइटिंग है कैसे वो पेन है मालूम नहीं सर बहुत कम से कम 10 साल पहले गिफ्ट का सब यूज कर रहा ओह 10 साल देंगे छोड़ दी मुझे कौन सर कहां हाई कोर्ट सर मामू जन साहब डाला क्या उन्होंने डाला क्या कुछ जॉब डाला क्या नहीं क्या मालूम नहीं सर चलो देख लेंगे हां मतलब नहीं हाँ एक बैग ले लो जी दो बैग नहीं बैग हमारा आज आपसे ले लीजिए बैग का सर मेरा टारगेट पड़ा है सर
not submission.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್, ದಯವಿಟ್ಟು ಸ್ವಲ್ಪ ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ, ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
Alone on submission. Alone on submission. List number 1. Submission. Submission. Dissection. Answer on submission is there. Submission may not. And list. List one. Serial number. Not on submission. List one. Serial number 52. Withdraw the case.
ಡಿಸ್ಕನೆಕ್ಷನ್ ಗೆ ನಾವು 2910 ಅಂತ ಕೊಟ್ಟಿದ್ರೆ 2911 ಅಂತ
ಆಗ್ಬೇಕಾ?
ಸಾರಿ
ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗ್ಬೇಕಾ?
ಅಲ್ಲ ಅಲ್ಲ ತಾವು 2910 ಗೆ ಅಂತ ಕೊಟ್ಟಿದ್ದ 11 ಅಂತ ಮಾಡಿದಾರೆ ಸರ್ ಬೈ ಮಿಸ್ಟೇಕ್
ಆಗ್ಬಿಟ್ಟಿದ್ಯಾ?
ಹೌದು ದಟ್ಸ್ ವೈ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ದಟ್ಸ್ ವೈ ಟೂ ಮ್ಯಾಟರ್ಸ್
Lords, with your lordship's kind permission.
ಅಲ್ಲ ಒಂದು ಅಲ್ಲ ಇದರಲ್ಲಿ ಒಂದು ಮಾತ್ರ 230 ಅದು there is a threat of disconnection my lord otherwise I won't have moved both matters
Serve on the other side.
sorry yes it is served sorry
Execution petitions have been filed by the
230.
claimants at 2:30.
Lords, with your lordship's kind permission.
Cooperative society election matters.
ಇಬ್ರು ಹೇಳಿದ್ರಿ, ಒಂದ್ ನಿಮಿಷ.
Sorry.
Cooperative society election matters, my lord. Election has been concluded. End of the list, my lord. There are 3 matters.
Disposed.
Yes, ma'am. And one matter for tomorrow for settlement, my lords. GMRES parties are settling. Please.
With your lordship's kind permission, one tender matter, my lords, at 2:30, my lords. Highly obliged.
Regulation of service next week, my lord.
Lords, one matter for 230. Connected matters are listed at 32 and 33 today. One matter went before the additional registrar general for dispensation. 230.
My lord on submission, my lord.
2:30 election.
Election,
ನಿಮ್ಗೆ ಯಾಕೆ 2:30
election completed by lot, it is
ಸರ್ಕಾರಕ್ಕೆ.
listed for a ARJ for waiting the service.
ವೇಟಿಂಗ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆಯಾ?
Waiting list ಇದೆ.
ವೇಟಿಂಗ್ ಲಿಸ್ಟ್ ಅಂತ ಹೊಡಕ.
No, no, connected matter ಅಲ್ಲಿ my colleague Sadiq is appeared. We intimated them, please.
So, petition working as a guest lecturer, sir, 2:30 PM urgency.
Serial number 80, my lord.
Adjournment. ಆಯ್ತು ಕರೆದ್ಬಿಡೋಣ ಬಿಡಿ adjournment.
My
My
name
lord
is shown, my lord, I am not appearing for the warehouse, my lord. My name is shown, my lord. Serial number.
We'll see.
That's one tender matter,
Please.
2:30.
ಯಾಕೆ? ಟೆಂಡರ್ ಅಂದ ತಕ್ಷಣ 2:30 ನಾ? But
My lord, on small permission.
one moment. Wherever government is there, if copy is not served to the government, ಅಲ್ಲಿ AG's office ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳಿದ್ರೆ ಯಾವ್ದ್ರಲ್ಲೂ ಎಂಟ್ರಿ ಮಾಡ್ಕೊಡಲ್ಲ. ಇಲ್ಲಿ whoever appears, AGA ಇದ್ರೆ HCGP ಇದ್ರೆ ಅವ್ರ ಕೈಗೆ ಕಾಪಿ ಬಂದು ಕೊಟ್ಟಿ ಅವ್ರು ನೋಡ್ಕೊಂಡಿದ್ರೆ ಮಾತ್ರ ಕೊಡ್ತೀನಿ. Tell all your colleagues who have moved at 2:30, unless copies are served here, if the government is a party, I will not grant entry order from today.
My lordship permission, my lord, sir. On matter for revival and extension of the interim order.
Revival
ಅದೇನಾಗಿತ್ತು CBI murder case CBI referee further petition. My lordship granted the interim order. And
CBI refer ಮಾಡಕ.
ಮಾಡ್ಲಿಕ್ಕೆ ಅಂತ interim order was granted for the trial. It was not reached last time. By inward interim order is not extended. 2:30. Please.
My lord, on submission.
Adjournment ಬೇಡ ಆಮೇಲೆ ಮಾಡು.
Influctuous ಆಗಿದೆ 72.
ಎಷ್ಟು?
72, 72.
72. Learned counsel for the petitioner submits that the petition is rendered infructuous due to efflux of time.
Please.
Submission is placed on record per disposed as having become infructuous, both.
Malords, one adjournment, Malords.
ನಿಮ್ದು infructuous ಆಗಿದೆ.
Serial number 158, Malords.
Wait, ಅಲ್ಲಿವರೆಗೆ ಹೋಗೋದೇ ಇಲ್ವ ನಾನು? We'll see.
Your lordship's one memo with your lordship
One
permission.
moment, madam. Madam, one moment.
It is a case of regularization. Your lordship covered by judgment.
ಕೊಡಿ ಬರುತ್ತೆ. Next week ಹಾಕೋಣ ಇವಾಗ.
Lordship, serial number 140 and 145, 146, Lordship disposed of on Monday. First appellate authority disposed on delay, on the ground of delay. This is under GST Act.
ಗೊತ್ತು 107.
Ah.
Appeal ಅಲ್ವಾ?
Please, squarely covered.
We'll squarely take it later. ಆಮೇಲೆ ತಗೊಂಡು ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ.
ಮತ್ತೆ ಇರಿ. Yes.
Lord's kind permission, one clarification. I give 3 memos, my lords.
ಆಯ್ತು.
ಅದರಲ್ಲಿ ಒಂದು contesting right was given, but he did not file nomination. I filed a memo for withdrawal. I'll intimate the court officer. That may be dismissed as withdrawn. Please.
Even if you are not there, we will do it. Don't worry.
Please.
Yes. Madam. Call the case. Yes, madam.
My lordship, on small permission.
Your lordship, we want to move a memo. It's an old matter where the petitioner has obtained a stay order and is refraining from paying any cross subsidy surcharge to the state. It is causing severe losses. Your
We'll take it on. You take it. Memo idena. We'll list it on Tuesday.
Grateful, your lordship.
Yes.
My lordship, serial number 52, list 1, we will withdraw the case, my lordship.
Thank you, sir. Yes, 52.
52, sir. List 1.
The petitioner seeks leave of the court to withdraw the petition disposed as withdrawn. Next.
Noted. Thank you, my lord.
Thank you. Thank you. Yes.
Next matter, serial number 1. BC Gnanaya Swami.
Petitioner
ಏನ್ ಕೇಸ್ ಇಲ್ಲ 1980 2024
17 pension rules 17 clearly
ರೆಗ್ಯುಲೇಷನ್ 17 ಪ್ರಕಾರ ಟ್ರೈನಿಂಗ್ ಪೀರಿಯಡ್ ಹ್ಯಾಸ್ ಟು ಬಿ
ಬರುತ್ತೆ ಸರ್.
ಬರುತ್ತೆ ಇಲ್ಲ ಅಂತ ಹೇಳಿಲ್ಲ. ಯಾವಾಗ ಕೇಳ್ತಿರೋದ್ ನೀವು?
ನೋಟಿಸ್ ಕೊಡಿ ಅವರಿಗೆ. ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 and 3
ಕೊಡ್ತೀನಿ.
2 and 3 ಭಾಗ್ಯಶ್ರೀ 1 and 2 ಭಾಗ್ಯಶ್ರೀ ಬಿಕ್ಕಣ್ಣವ್ರ.
3 MB ಕಣ್ವಿ.
ಭಾಗ್ಯಶ್ರೀ ಬಿಕ್ಕಣ್ಣವ್ರ.
1 and 2 ಆಯ್ತು. 3 ಯಾರು?
3 ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ.
ಅದೇ MB ಕಣ್ವಿ or ಮೃತ್ಯುಂಜಯ ಟಾಟಾ ಬಂಗಿ ಅಂತ ಹಾಕಿ.
Please.
3 and 4. Yes.
Please.
Copy.
Please.
You see. ಅದು ನಾನು ಹೇಳ್ದೆ ಹೋದ್ರು petitioner to serve set of papers upon the aforesaid council.
Number 2, K. Anand Kumar.
And for the petitioner, my lord, the land of the.
ಯಾರ್ಯಾರು ರೆಸ್ಪಾಂಡ್?
So I take notice.
1 to 6.
ಸ್ಟೇಟಿಗೆ ನೀವಿದ್ದೀರಾ? ಇವ್ರು ಯಾರಿಗೆ?
State one, AG.
ಕಲ್ಸುರ್ಮಠ್ ಪ್ಲೇಸ್. ಕಲ್ಸುರ್ಮಠ್ ಇಲ್ವಾ? ಸರಿ.
1 to 7 and 9 to 12, my lords.
1 to 7
and 9 to 12. 8 is the PDO.
1 to 7, 9 to 12 state.
Yes.
Emergent notice to their PDO.
PDO, Raibag.
Emergent notice to the 8th respondent.
Stay.
ಏನ್ stay? ಈಗ
Still, by Aristotle, my lord, he was a position, my lord.
petitioner is in possession as on today. The possession shall not be disturbed till the next date of hearing.
Please.
If already executed.
He is in possession as on today.
Please,
It will not be disturbed.
Now he is in
In the event the petitioner is already dispossessed, it shall remain subject to the result of the petition.
Bill number 3, Shiv Sai Patil.
This connected matters interim stays. This connected matters interim stay has been granted, my lord.
ನೋಡಿ ಗೊತ್ತಿಲ್ಲ. 3 to 6 tag the petition along with so and so same order. ಇದು ಇಲ್ಲಿದೆ same order. Next.
My lord.
Serial
Serial
number
number.
4, Shiv Sai Patil.
ಇನ್ಯಾವುದಿದೆ ಶಿವ?
Please.
ಸೀರಿಯಲ್ ನಂಬರ್ ಯಾವುದು ಇನ್ಯಾವುದು?
3, 4, 5, 6 and 9.
3, 4, 5, 6 and 9.
Same.
And then it's fine. No,
Please.
yes. Next.
Take notice for state.
Number 7,
Connected matters on 511, my lord.
List on 511.
Please.
511. All right. Tag this petition, list them all on 511.
Bill number
Next.
7, Sangram Kulkarni.
Release of pension.
Please, my lords. 1 to 4 government.
1 to 4.
Government.
1 to 4 so and so. AGN, HCGP.
AGA.
Service matter.
Pension.
Oh. GM, the actually service
Yes.
is release of pension.
Pension.
HCGP is directed to accept notice for the respondent. Madam, secure instructions. Yes.
Other respondents notice.
Huh?
5 to 6 notice, my lords. 5, 6, 7.
Institutions ತಾನೆ?
No, my lords, private parties.
ಆಯ್ತು, so and so. ಇದಲ್ಲ, sorry madam, it's not institution. Correct. ನಿಮ್ಮ AG ಏನ?
AGM.
Learned AG is directed to accept notice for the respondent 1 to 4, 5 and 6 emergent notice.
5, 6, 7.
5, 6, 7 emergent notice.
Please.
Bill number 8,
This is learned HCGP is directed to accept notice for the respondents 1, 2. 1, 2, 3, 4. One matra, learned HCGP 1, BS Kamte for all the remaining.
My lords, I may be permitted to take notice on the standing counsel appearing for 2 to 7.
Kamte ಅವರು standing counsel ಅಲ್ಲೇ ಇದ್ದಾರೆ. Yes. Learned counsel BS Kamte is directed to accept notice for respondents 2 to 7. Pension. Yes.
My lords, one
List the
submission.
matter on.
My lords, the name of the Sunil S. Desai may be deleted, your lordship. Please.
Registry to delete the name of Sunil Desai is appearing for the petitioner first ಮಾಡಿ. ಆಮೇಲೆ learned HCGP 1, 2 to 7, BS Kamte, list the matter on 19th November.
Bill number 10, Rinalini Patil.
Government. Yes, Ramesh. Inclusion of villages.
Yes. I will direct take notes. 1 and
Learned,
2. 1 and 2.
AGA accepts notice for 1, 2.
1 and 2. That's
1 and 2.
Please, ma'am.
Emergent notice to respondents 3 and 4 returnable by the 19th. List on 19th.
Please.
11, HR Kambiya.
ಅದೇ 107.
Matter is arising out of income tax act, issue the same.
Issue stay.
ಅಲ್ಲ stay ಅಲ್ಲ. ಇವ್ರಿಗೆ ತಿರುಮಲೇಶ್ accept notice for R1
Council M. Tirumalesh
issue is identical ಮಲ್ಲ.
is directed to
Only-
accept notice for respondents.
ಅಲ್ಲಿ GST ಇದೆ, ಇಲ್ಲಿ IT ಇದೆ ಅಷ್ಟೇ. 69 days ಮೇಲೆ
ಆಯ್ತು, ಅವ್ರು ಬರ್ಲಿ. Learned
4th November ಬರ್ತಾ ಇದ್ದಾರೆ.
ಬರ್ತಾ ಇದ್ದಾರಾ? ಹೇಳಿದಾರ ನಿಮ್ಗೆ?
ಅಲ್ಲ ಅದರ್
List the matter on 4th November. M. Tirumalesh is directed to accept notice for the respondents. Petitioner to serve set of papers upon the council.
permission 140, 141, 146 same
Tag.
identical. On Monday your lordship dispose.
Tag along with dispose ಆಗಿದೆಯಾ?
ಇವನ್ ಮಾಡಿದ್ರಲ್ಲ ಇದು 4th ಬರ್ಲಿ. ನಾ serial lordship disposed on Monday, similar terms and conditions ಮಾಡಬೇಕು.
ಆಯ್ತು. ಅವ್ರು ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು?
AG ಗವರ್ನಮೆಂಟ್.
ಅವ್ರಿಗೆ ಹೇಳಿ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಿ, ನಾಳೆ ಅವ್ರಿಗೆ ತೊಂದರೆ ಆಗುತ್ತೆ.
I'll take.
ಅಲ್ಲ ಕವರ್ಡ್ ಅದು ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ.
ಆಯ್ತು. ಅದು
ಹೆಸರು ಮತ್ತೆ ಹನುಮಾರೆಡ್ಡಿ ಅವರೇ,
Please.
you ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ.
ಆಯ್ತು.
Don't only if it is covered actually according to me.
Yes.
But you look into it and tell.
ಸರ್ ಕಾಪೀಸ್ ಇದು ಜಡ್ಜ್ಮೆಂಟ್ ಕಾಪಿನೂ ಕೊಡ್ತೇನೆ, ನಂಬರ್ ಮಂಡೇ ಆಗಿದ್ದು ಕೊಡ್ತೀನಿ.
ಅದ್ ನೋಡಿ ಡಿಸ್ಪೋಸ್ ಅಂತ ತಗೊಂಡಿರ್ತೀನಿ. ಸಾಯಂಕಾಲ ಅಕಸ್ಮಾತ್ ತೊಂದ್ರೆ ಇದ್ರೆ ನನಗೆ ಹೇಳಿ. ಮತ್ತೆ ಹಾಕಿ.
Lord, only kind request, Monday dispose ಆಗಿದ್ದು 31st ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ನನ್ನ ಬ್ಯಾಂಕ್ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಆಗಿದೆ, ನಾನು ಟ್ಯಾಕ್ಸ್ ಕಟ್ಟಬೇಕು.
ರಿಲೀಸ್ ಆಗಿಲ್ವಾ?
ಇವತ್ತು ಪ್ಲೀಸ್
ನಂಬರ್ಸ್ ಕೊಡಿ, ಯಾವ್ದದು ನಂಬರ್ಸ್? ಅದಲ್ಲ ರಿಲೀಸ್ ಆಗಿಲ್ದೇ ಇರೋದು ನಂಬರ್.
ರಿಲೀಸ್ ಆಗ್ಲಾರ್ದು ಅದೇ
ನೋಡಿ ಮೇಡಮ್. ಎಸ್, ನೆಕ್ಸ್ಟ್
ಪ್ಲೀಸ್.
ಡಿಸ್ಪೋಸ್.
Number 12, Prithviraj P. Termini.
ಸಸ್ಪೆನ್ಷನ್ GST.
Please.
Why?
My lords,
ಪೇ ಮಾಡಿಲ್ಲ.
reply ಮಾಡಿಲ್ಲ, but my lords, it was sent through email. Email ಅಲ್ಲಿ ನಮ್ಗೆ ಗೊತ್ತಾಗಿಲ್ಲ.
ಆಯ್ತು, learned AGA is directly.
Notice is issued on last time your lordships heard it and
ಆಗಿದ್ಯಾ?
posted for fresh matter.
My lords, they have not appeal, my lords, I will the appeal provision, 107 appeal is there.
ಎಲ್ಲಿ ಅಪೀಲ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ತೀರಾ ನೀವು? ಡಿಲೇ ಆಗೋಗಿದೆಯಲ್ಲ ಈಗ.
And the issue is of 2023.
Correct. ಅದಕ್ಕೆ ಅಪೀಲ್ you will not accept.
Yes.
My lords, and my lords, it is in violation of principles of natural justice.
That's the argument. ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ ಬೇಕಾದ್ರೆ ನಾಳೆ ತಗೊಂತೀನಿ. Let him see.
Next week, first time.
Next week ಆಯ್ತು.
My lords.
ಫಸ್ಟ್ ಟೈಮ್ ಅಲ್ಲ, ನೋಟಿಸ್ ಆಗಿದೆ.
Notice ಆಗಿದೆ.
ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
ನೋಟಿಸ್ ಆಗಿಲ್ಲ.
Notice ಆಗಿದೆ.
ಆಗಿಲ್ಲ.
Shown name.
ನೋಟಿಸ್ ಆಗಿಲ್ಲಪ್ಪ. List learned AGA is directed to accept notice for the respondents. List the matter on 18th.
Yes.
Yes, next.
Bill number 13, K. Anand Kumar.
Yes.
The land of the petitioner.
Learned
Please, I'll
AGA
take note.
is directed to accept notice for the respondents.
1 to 5, 6 ತಹಸೀಲ್ದಾರ್ ಇದೆ.
6 ತಹಸೀಲ್ದಾರ್ ಗವರ್ಮೆಂಟ್ ಅಲ್ವಾ? ಮತ್ತೆ 1 to 6.
Please.
Learned AGA is directed to accept notice 20th.
Not to disturb position. Not to disturb.
ಸೇಮ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಮಾಡಿದ್ನಲ್ಲ, ಯಾವ್ದಲ್ಲ ಅನಂತ್ ಕುಮಾರ್ದ್ರಲ್ಲಿ?
ಎರಡನೇ.
ಎರಡನೇದ್ರಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ?
Please.
ಎಸ್.
14, Mahesh Padiya.
Appeal for the petitioners.
Award amount ಕೊಡಿ.
Connected matters will listed tomorrow.
Tag this petition along with so and so. List the matter to
1 to 3, my lord, SM Karwad may be directed to
1 to 3 SM Kalwad.
4 is government.
4 AGA. Yes. Next.
15, AC Chaklapi.
The petition in this case, notice issued by the respondent number 1 has been challenged, lords. The
Notice.
cause for a notice is the respondent number 2 has registered a crime in
KDB ಯಾರು?
PN Hatti ಇದ್ದಾರೆ.
ಇವ್ರು ಇದಾರಲ್ಲ ಮೇಡಮ್, ಇಲ್ವಾ? Senate Council Srimati
One
Sharmila
the
Patil
detainee.
is directed to accept notice for the first respondent KIDB.
Please.
Petitioner to serve set of papers upon the aforesaid council. Second respondent ಯಾರು?
He is a father of the present petitioner. He has filed a complaint before the concerned police officers.
So you serve your father in the house itself.
He is residing separately.
Hand summons though. Hand summons to the second respondent. List on 18th.
Till then.
Till then what, sir?
Not to precipitate the notice, lord.
What precipitations?
Notice has been issued within. They have to seek reply from myself.
Reply ಕೊಡಿ.
Already the cause for notice is they have registered the crime in concerned police officer. That crime has been stayed by this honorable court.
Crime stay ಆಗಿದೆಯಾ?
Yes, lord.
The respondent board shall not precipitate the matter till the next date on the score that the notice is now issued on registration of a crime, registration of crime in crime number 206 of 2024. The second respondent is the complainant. The learned counsel for the petitioner submits that the crime so registered in criminal petition 10 is stayed in criminal petition 103789 of 2024 in that 2024. ಅಷ್ಟೇ ಸರ್. Yes.
Please.
Not to precipitate ಬೆಳಗ್ಗೆ.
Please.
ಶುರುಲಿ ಹೇಳಿದ್ನಲ್ಲ.
16, Vidyavati and Photoshita.
Petitioner, my lord, Lokadalat order.
Respondent ಯಾರು ಇದ್ರು?
Please.
Ready?
Please.
Yes.
Please, my lord.
ಇದು ಗೌರಮ್ಮ ಜಡ್ಮೆಂಟ್ ಯಾರು ರಿಲೈ ಆಗ್ತಿರೋದು?
I have given your lordship.
You have relied? Yes. Okay.
I am relying the Bhargava.
Relying the Bhargava. Which is that Bhargava?
Please.
Bhargava Constructions ಕೊಡಿ.
Bhargava Construction and also Shantava in RS MSM.
ಕೊಡಿ.
There is a partition in the family. As per
What is the suit for?
they are seeking for suit.
What is the suit for?
Suit for declaration.
Declaration.
Oh.
That is settled in Lok Adalat?
Yes, my lord.
Not a
I am not a,
who are you?
I am not a party.
Who are you?
They are not a party.
I am,
Gotu, in relation, who are you?
Originally, your lordship, there is a 4 line of
I
ancestors, your
am the
lordship.
legal heirs of the original partition deed where.
Original partition deed legal heirs.
Houdu, because your lordship, I'm sorry, my lord, there is a partition in the year 1968 among the 4 branches. I belongs to one branch. The respondent is belongs to one branch, my lord. Total extent is 15 acres, 38 guntas, my lord. Among the 4, my lord, equal partition has been taken place, and other two members has executed a say deed in favor of me in the year 1974. 74. Thereafter, my lord, the name of the original owners and legal heirs are continued. And they filed a suit as per Annexure E in the year 2023, claiming entire 15 acres belongs to that family, my lord. That is the page number 137, my lord. 137, and total extent is included. And in that, my lord, they have filed a compromise petition as per Annexure F, and they partition entire extent of 15 acres. In the genealogy I have produced along with the suit, my lord, page number, along with the petition, page number 8 is the genealogy, my lord. In that, my lord, 4 parts are there, my lord.
4 parts, sir.
Sorry, it is partition in the 4 members, my lord. I belongs to member of the petitioner.
Which part?
Pujaraya, third one, third brother. Therefore, my lord, without making us a party, my property has been partitioned between the respondents.
Out of a compromise.
Yes, my lord, in the Lok Adalat.
This is all question of facts, your lordship, and
Exactly. Yes.
now, your lordship, they can.
23 ಎಲ್ಲಂತೂ ಹೋಗಕ್ಕಾಗಲ್ವಾ? ಮತ್ತೆ ಎಲ್ಲಿ ಹೋಗ್ಬೇಕು?
They have to file separate suit, your lordship.
Yes.
Because, your lordship, there's a 4 line of ancestors. Yes, it is admitted.
4 parts.
Please. Only mistake is, your lordship, my father name, grandfather name, their father name, grandfather name is similar.
Oh, ಅಷ್ಟೇನಾ ಮಿಸ್ಟೇಕ್?
ಅಲ್ಲ ಆಗಿರೋದು. So we have filed compromise petition with respect of our property. Now they're claiming their property by virtue of partition deed. They have to file declaration injunction. If at all my compromise is not binding.
You are relying on Gauramma.
Please, and there's no judgment just now. I found that there's a RFA judgment very clearly says that, your lordship, rule 23(3)(a) is only barred to the parties to the suit. Even Bhargav Construction judgment says that, your lordship, particularly who are party to the suit. The legal right of a stranger to the suit, he has to file separate suit. Yakandre now they cannot claim for possession also. There is a now.
I am in possession. I am cultivating the land, my lord.
Yes, according to me, your lordship, I am in the position and I am cultivating the land.
Your lordship, kindly see page number
No,
30.
the allegation is fraud and misrepresentation. You have left one part and taken away all the other.
No, partition has taken place very before, your lordship.
Correct. A declaration suit only you have entered into a compromise without.
My only contention is, your lordship, without they do not being the party, how can now say that this is binding on me? Now they have to file separate suit, your lordship.
Your lordship, kindly see page number 31.
The suit was on merit.
Please.
If the suit was on merit, it would have been a circumstance altogether different.
So one RFA judgment, your lordship, wherein just now I got.
Just now you got.
Where it says that, your lordship, if they are not a party, they have to file a separate suit. The operative position is.
Page.
Copy, please.
Para 72, 73.
It is also in favor of me.
74.
Please.
72, 73, 74. Not parties to the Lok Adalat.
Your lordship, serial, para number 69, page number 68. Sorry, your lordship. Wherein, your lordship, if I may be permitted to read. Therefore, upon considering the order
Suit can
23,
maintain a separate suit challenging the compromise.
if they are not a party to the suit, only contingent.
We'll see. We'll have to answer this.
It is in respect of compromise, my lord, under order 23, but it is in the Lok Adalat, it is favored, my lord. Your lordship kindly see for the Bhargava's case, my lord, rendered by the Supreme Court in the year 2018. 18 in para number 24. In our considered view, the aforesaid law laid down by this court binding on all the courts in the country by virtue of the mandate of Article 141 of the
ಅಯ್ಯೋ ಅದು ಗೊತ್ತು ಮೇಡಮ್, ಅದ್ಯಾಕೆ ಓದ್ತಾ ಇದ್ದೀರಾ? ಹೆಡ್ ನೋಟ್ ಓದ್ಬೇಡಿ.
The
ಸುಪ್ರೀಂ
69
ಕೋರ್ಟ್ ಹೇಳಿದ್ದು ಬೈಂಡಿಂಗ್ ಗೊತ್ತು.
head note
ಹೆಡ್ ನೋಟ್ ಓದ್ಬೇಡಿ.
and also
ಹೆಡ್ ನೋಟ್ is not by the judge, madam, by the publisher.
And in page number 69.
But the thing is, my lord, here also, my lord, there is a direction under section 22E, my lord, there is a bar to file a suit of the Legal Aid Service Authority Act, my lord. Therefore, my
Legal Hair Service Authority.
legal aid,
Legal aid.
Legal Service Authority Act.
ಆಯ್ತಾಯ್ತು.
22E, my lord, there is a bar to file a suit, my lord. And also, my lord, in respect of that, in one case, my lord, that is Shantava. Here they have filed a suit against the Lok Adalat compromise decree, and this honorable court held that, my lord, that suit itself is not maintainable. That
Very,
is in Shantava's case,
considering
my
the Bhargava construction
lordship
judgment, that judgment is passed.
40,
Which one?
page number
But,
14, my lord.
Shantava.
Shantava, MSA. By referring Bhargava constructions, it is referred. And in that also, your lordship, particularly it says that party to the suit.
This is Sanjeev Kumar Hanchate ಅವರು.
RFA.
Ramakrishna Mat.
It's RFA.
Please, adralli page number 69.
Para 69.
Para 69, your lordship, the next page 69.
Correct. Para
From-
69, page 69.
Please, next your lordship, from page number 7, it says that therefore it of compromise decree is passed by invoking order 23 rule 3 CPC, it is only binding on the parties, not to any other person. In this
Madam,
context,
23 rule 3 definitely. It has to go before the same court. But Lok Adalat.
3A, your lordship, that is considered in Gaurama case, your lordship. Please.
ಇದು ಬೇರೆ ಏನಿದೆ? ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಏನಿದೆ?
Merits mail, my lord, as per annexure B, page 31.
We'll first answer the maintainability.
Please.
Then take it on merits if it is maintainable.
Regarding maintainability, my lord,
ಅದಾಯ್ತಾ? ಮತ್ತೆ
please, my
ಹೇಳಿದಿರಲ್ಲ.
lord. Now merits, my lord, your lordship kindly come to annexure B, that is Palu Vibhaga Dastaveju, executed in the year 1968. Page number 31, my lord, typed copy. In para number 3, my lord, second line, survey number 1123B and 1123D, Vistirna 15 acres, 81 guntas, total extent, my lord. That is partition in the among the 4 brothers, as generalized in the.
ಆಯ್ತಾಯ್ತು ಹೇಳಿದ್ರಲ್ಲ.
Then, my lord, your lordship kindly see the suit, my lord, annexure E. Annexure E. Page number 38, operative portion. That is total extent they have included. My.
Your portion also is included.
Yes, total extent, 15 acres, 38 guntas
Where
is mentioned.
Where is the partition?
Partition is annexure B.
Page.
Page number 31, typed copy, my lord.
ಇಲ್ಲಿ 15 ಎಕರೆ ಅಂತ ಎಲ್ಲಿದೆ?
Your lordship kindly
Page
see
129 ಅಲ್ಲಿ.
129.
129.
Annexure E, my lord.
Yes.
The operative portion in the schedule B, they have mentioned in the property. Schedule property,
10 acres,
138.
8 acres.
Yes, total 15 acres. Yes, my lord.
Now,
They
you
have left
take me to the partition deed.
Partition, yes, my lord.
Page.
Partition deed is 31.
Schedule.
Schedule, my lord, separately they have not mentioned. In para number A, B, C and D, the schedule is mentioned. A to
ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ ಎಷ್ಟು ಇದೆ?
ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ in para number 3, my lord, A schedule ಅಲ್ಲಿ ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ 15 acre 81 guntas. ಅದರ ಪೈಕಿ 3 ಎಕರೆ 16 ಮುಸ್ತಮ್ಮನ ಭಾಗದ ಜಮೀನು.
ನೀವು ಯಾರು? ಗೌರಮ್ಮ.
We are from the,
ಆಯ್ತಾಯ್ತು on
in genealogy is page number 8 of my petition, my lord. We belongs to hair of Poojaraya.
ಇದ್ರಲ್ಲಿ ನೀವೆಲ್ಲಿದ್ದೀರಾ?
ನಾವು ಗುರಮ್ಮ, ರಾಮಪ್ಪ, ಮರಣ್ಣ ಥರ್ಡ್ ಲೈನ್ ಅಲ್ಲಿ ಇದೆ. And they belong.
Now, your lordship, yes, please. Now, your lordship, question of facts, I'll go. It is your lordship, after lapse of 2 years, they have challenged the compromise decree. By virtue of compromise decree, entries are changed. According to me, your lordship, we are in possession. Now they are in possession. If at all, your lordship, if it is remanded, if they were implemented to the suit, they cannot invoke 39(1) and 2. Again, they have to file separate suit, being the defendants. So again, technicality.
From the partition,
The
my lord,
judgments
I am
are-
in possession, I am cultivating the land.
In judgments
Till
and
the time
provision
they
of law is clear that 23(3)(a) is very clear. Yes, there is a bar for the parties to the suit. Parties, stranger who is not a party to the suit, he cannot file implead, your lordship. Please. Later also, your lordship, being defendant, they cannot invoke 39(1) and 2. Again, they go for separate suit. Please.
The petitioner is before this court. Petitioners are before this court calling in question a compromise entered into in OS 165 of 2023 before the Lok Adalat in a suit for partition. Enidu nature of suit partition anta ide. You said declaration.
ನನ್ನ ಕಡೆ entire petition copy ಕೊಟ್ಟಿಲ್ಲ ಅವರು.
Copy madam.
ಅವ್ರದೇ ಸೂಟು.
ಅದಕ್ಕೆ ಕಾಪಿ ಕೊಡಬಾರ್ದು ಅಂತಿದೆಯಾ?
ಅಲ್ಲಿ ಪ್ರೇಯರೇ ಇಲ್ಲ.
Come to page 22.
Partition, I am sorry, my lord, page 135.
Declaration ಅಂದ್ರೆ?
ಇಲ್ಲ, sorry, page 135, partition of 1/6 share.
You want something on merits to be told?
Fee schedule property.
Please.
You want to submit something on merits?
If it is passed over, your lordship.
Passed over ಇಲ್ಲ ನಾಳೆ ಏನ್ ಬೇಕಾ?
ನಾಳೆ.
ನಾಳೆ ತಗೊಂಡು. ಕಾಪಿ ಕೊಡಿ ಫಸ್ಟ್ ಫುಲ್.
Please.
Full copy ಕೊಡಿ. ಇನ್ಯಾವುದಾದ್ರು ಜಡ್ಜ್ಮೆಂಟ್ ಇದ್ರೆ ಕೊಡಿ.
Please.
Then take my judgment, no problem.
Please.
Yes. Tomorrow. Same stage.
Please.
Bill number 17, Sunil is Desai.
Principal.
Of man.
Pray for weeks time, Your Lordship.
Why? ನೆನ್ನೆಯಿಂದ ಇವತ್ತಿಗೆ ಹಾಕಿದ್ದೀನಿ.
Alla, my senior colleague had argued the matter, Your Lordship. Gayatri, yes, sir. She is not feeling well, Your Lordship.
Who?
Gayatri, yes, sir.
Not well.
My lordship, date Monday on fresh matters.
Monday.
Interim order already can be extended.
List on. Madam, ನೀವು ನೋಡಿದ್ದೀರಾ? Ready. Circular ಪ್ರಕಾರ who has to be seniority ತಾನೆ?
Please.
ಆಯ್ತು, we'll see. List on Monday.
Lords in fresh matters.
Same stage.
Please, your lordship. Great.
Bill number 18, Vidyavati Mukhopadhyay.
I appear for petitioner, my lord. I have challenged the order issued for appointment of the inquiry officer.
One third ilva?
Under,
Resolution
no,
by
no
1/3
one third,
members?
nothing.
Minutes.
Totally 49 members are there, my lord. Only one has filed a complaint.
So moto initiated at ಬರ್ದಿದ್ದೀನಿ.
So much ಮಾಡಿಲ್ವಲ್ಲ ಅದ್ರೆ?
There is no reasons assigned, my lord.
Where is the order?
Order is annexure A. Annexure A, my lord.
Page.
Page 12, my lord.
File your objections, madam.
Please, my lordship, I have filed
I am seeking
applications
for
seeking
stay of-
impleading. Impleading applications I have filed.
ನೀವು impleading applicant.
Now they have filed an
But
impleading
making us
application.
as
The
the
complainant
party,
filed a impleading application.
All right. We'll permit complainant to come on record. The council so and so has filed an application seeking the. IA put up ಆಗಿದೆಯಾ?
Yes, my lordship.
Order on IA 1 of 2025. The council so and so has filed an impleading application proposing to bring respondents 3 to 9 on record. Respondents 3 to 9 are said to be the complainants before the registrar, in furtherance of which the present inquiry is directed to be conducted. The learned counsel appearing for the petitioner, though, would oppose the impleading application for the reasons indicated in the affidavit accompanying the application, and being satisfied with the same, more so in the light of the fact that the impleading applicants are the complainants, I deem it appropriate to permit them to come on record. the counsel for the petitioner to amend the cause title accordingly. The learned counsel of the petitioner, Srimati Vidyavati Kottur Shettar, would submit that that section 25 requires 1/3 of the members to register, or required of the 1/3 of the members to come together to register a complaint. Or who has registered? Arjana idarile?
Six.
There are.
But your
it is
lordship in the
registered by
reference, my lord.
6 people. 6 members only. The learned counsel representing the impleading applicant would submit that the registrar can initiate inquiry under section 25 even so moto. Therefore, there is no warrant of interference at the hands of this court at this juncture. The matter would require consideration. List the matter on 18th. Further proceedings before the registrar shall remain state till the next date. Yes.
Inquiry has already
192 is the
commenced.
government.
Hey, already commenced.
Well, so what?
192 is government.
192 AG. Yes.
Please.
Till the next date, you convince, we'll dismiss it.
18th. My lordship, may I seek it on 20th or?
All right, 20th. List on 20th.
Grateful, my lordship.
19 RM Javed.
This not in connected matter appeal for petitioner. Your lordship may take that first.
Yes, my lord, that may be taken first.
Okay.
My lord, annexure A is.
Madam.
Lord, annexure A in page 9. Is the, my lord, page 10 is relevant, which is the jurisdiction of this masjid, which has been specified in page 10. Which are the area? No, my lord, annexure C, the petitioners had given the, my lord, objection with regard to holding of election. Kindly turn to my lord impugned order annexure D in page 17.
70.
17. Please. My lord, in this, my lord, serial number 3, 4, 5 and 10 are not, my lord, who comes under the jurisdiction of this masjid. They are, my lord, strangers reside outside the jurisdiction of this masjid. They have been, my lord, in the managing committee, they have been.
Who has brought them in?
My lord, respond number 1 WAF board has issued this, my lord.
Very statutory bar idya?
Yes. Annexure A alle ಹೇಳಿದ್ದಾರೆ jurisdiction. ಯಾರ್ಯಾರು ಇರಬಹುದು ಅಂತ ಹೇಳಿ. In page 10. In page 10, your lordship may kindly see, my lord. The jurisdiction work for the purpose of admission of members to the general body shall continue in, my lord, these are the areas. The Talwar Oni, Chalwadi Oni, Gaudru Oni, Kumbar Oni.
3 people are not there, is it?
My lord, 4 people are not there. My lord, serial number 3, 4, 5 and 10. In page 17.
3, 4,
5 and 10. And my lord, no elections are held from say 2022.
No elections are held.
No, it has been, my lord, kindly see, my lord, para 3 in this, my lord. The board circular where so and so public notice was issued. And, my lord, para 2, my lord, the board earlier constituted committee for management of work so and so dated 12/8/19 for a period of 3 years. And the term has expired. My lord, it is expired in 22. As per the board, 29/6/2000, public
are not conducted.
Lord, actually, as per the rule 54(5), before the expiry of the term of the committee, the previous committee, the outgoing committee should constitute a succeeding committee within 3 years before the expiry of the term. That has not happened.
If that committee fails to do
one
so.
minute. The moment if the succeeding committee is not constituted, then caretaker will step into the shoes of the committee automatically. Therefore, I mean, after that, he has to.
How long will the caretaker?
The elections were not held.
How long will the caretaker be there?
That term is not there in this rule, Milord.
There is no.
He has to elect a body within 3 months.
ಈಗ ಎಲೆಕ್ಷನ್ ಯಾವಾಗ ಮಾಡ್ತೀರಾ?
ಎಲೆಕ್ಷನ್ ಆಗಿದೆ ಮಿಲಾಡ್ ಇದರಲ್ಲಿ.
ಎಲ್ಲಾಗಿದೆ?
ಎಲೆಕ್ಷನ್ ಆಗಿದೆ. ಎಲೆಕ್ಷನ್ ಆಗಿ ಆರ್ಡರ್ ಪಾಸ್ ಆಗಿದೆ.
Election ಅಲ್ಲ, it is selection. They have sent proposal that has been confirmed. Kindly see, my lord, my lord, para 3, the district of
What do you
officer.
tell about the jurisdiction?
Jurisdiction ಬಗ್ಗೆ ನಾವು
They are the members within this jurisdiction, my lord.
How do you say that?
My lord, they are with reference to
ನೀವು
the.
ಹೇಳಿದ್ರಾಗಲ್ಲ, ಇಲ್ಲಿದೆ with reference to page 10.
Yes, my lord, with reference to their Aadhaar cards and all residence certificates, my lord. And this one letters issued by the HDMC corporation and all, they are residing in that places, my lord.
Where are those?
That has not been produced, that will be produced, my lord. What has happened is, my lord, since they are challenging the entire election procedure, which has been on 21/7/2024, wherein the 11 members have been selected as a committee members. Petition itself is not pointable. This
Where is the election held?
Please, my lord.
Election proceedings ಎಲ್ಲಿದೆ?
ಹಾಗೆ ಇಲ್ಲ election.
Where is the election proceeding?
My lord, meeting was called for, there are 140 members. Out of 140, 106 members were present.
Where is the election conducted in terms of the act?
Election proceedings will not be there. Either they may, in the process, in the resolution passed, the members of the body, either they may select or elect, that option is there. In this mode, they have gone for selection.
Where are the records?
Proceedings we have not
Produce
produced.
the
my lord.
records of election or selection, whatever you have done.
Yeah, we'll produce, my lord. It is there then.
The respondent shall place the records with regard to election or selection that has led to the impugned order, as the allegation is that there are no elections held at all as is known in law, and the members who are now 4 members of the newly constituted committee reside beyond the jurisdiction as is depicted under the model scheme of administration notified under the Waqf Act. Respondents, respondent board and the other respondents to produce the records concerning the residence of the 4 of the newly elected members who are said to be outside the jurisdiction, along with the evidence of residence and the record of election or selection by the Waqf board on the next date. List the matter on 18th.
One more connected matter. In this connected matter, during the pendency, there is stay order, my lord. During the pendency of the stay, the board has, because there was nobody to manage the affairs of the work institution, and in view of section 54(5), caretaker will automatically will be the member, the person who will be managing. The board has passed an order appointing caretaker as to manage the affairs of the masjid, and that order has been challenged in the subsequent writ petition. Both are connected, my lord.
On 18th.
Much obliged, my lord.
Fresh matter, sir.
Fresh matter.
Much obliged, please.
Obliged.
Number 20, BC Gnanaya Swami.
This is
Petitioner
day before
hearing,
yesterday's
my lord.
matter. Instructions in a bundle, Barbecue.
Anneda.
Day before
Monday
yesterday.
ಬಂದಿತ್ತು ಸ್ವಾಮಿ. There's a change in setup, we'll see. Nale, get instructions tomorrow.
Please.
Why his name should be in the rowdy list? Yes. Yes.
Number 21, Bahubali and Kanbargi.
I request for a week's accommodation.
Connect council. Notice ಆಗಿದೆ ಪ್ರಶಾಂತ್.
I have been served.
Council Prashant Usmani seeks 10 days time to secure instructions and make submissions. List the matter on 19th.
Please.
Yes.
22, James
Yes, ma'am.
Chandrasekhar.
Yes, my lord, I am appearing for the petitioner. Yes, my lord. This is the husband's petition, and the petitioner herein has filed a diverse petition under cruelty and other circumstances, my lords.
Circumstance.
And other circumstances
And for
like
the respondent, your lordship, for wife. Yes, your lordship. Your lordship, they have filed an amendment to the entire amendment of the pleadings, your lordship,
Correct.
the entire
He
pleadings.
wants to remove all that is against the child and not against, nothing against you.
Even against all the allegations, your lordship, the allegations is that they have not, the entire expenses has been borne by the petitioner, your lordship. For that also, they have not produced any receipt. That is the observation that has been made by the trial court in its order, your lordship, at page number 36, your lordship.
Yes, madam. And
The very nature, paternity of the child has been challenged, your lordship. With,
The amendment, is it?
yes, your lordship.
Yes, sir.
That entire changes
Yes,
the
ma'am.
entire.
Yes, madam.
Paternity is, paternity is challenged.
No. Basically, while filing the divorce petition, I did not having any such pregnancy minutes under the on the day of the marriage minutes, and subsequently she is having touch with the multiple persons through phone calls and all. After knowing and after checking up the
phone calls idre paternity doubt madbeka?
No, madam. And the doctor also he has given the opinion that he had on the first week of 2024 he has given a opinion that she is having a child in the womb prior to about 2 months grown up child, because I got a marriage just 1 month back, madam. Under such it has the evidence has to be led by the doctor and other documentary evidence has to be led by the madam. And this is the initial stage.
They're seeking the amendment at the stage
It
of
is the initial
cross-examination of
stage.
PW1,
Last
Your
week I
Lordship. That
kindly
is after
appreciate that.
lapse of 1 year.
Any stage of the case, I can file an
Yo, 617
amendment.
ಗೊತ್ತು sir, ಅದೇ ಹೇಳ್ಬಿಡಿ.
Yes, madam. And under such circumstances, still it is in initial stage, and there is it does not alters the nature of the petition also, madam. Under
In
such
the petition itself, he admits that is out of the wedlock the child is born, Your Lordship, in his own petition.
After marriage only child is
Yes, Your
born,
Lordship.
but it is not
Yes,
mine, my lord. This is my dispute, my
What
lord.
is it not yours?
Yes, my lord. Because my
Very
marriage
easy to-
was
Very
my
easy
ma-
for the father to say child is not mine when proceedings are brought for divorce.
No, my lord. Your lordship, I
No,
kindly
what?
appreciate
No.
that. My marriage
You
was
appreciate
occurred in the January 2024, my lord. The doctor opinions that it was grown up for 2 months back. That is during December she carries the pregnancy, my lord. That is the doubtful. That doctor has
Who
to
is
be
that? Who
examined.
is the doctor? Your friend?
Written opinion has to be looked into, my lord. So
Doctor
under
is
such
doctor is your
circumstances,
friend, huh?
my lord.
Doctor is your friend.
No. He's not my friend, my lord. It is their family doctor, my lord. That my wife's family doctor, my lord. Not my friend. So this is
Alright,
necessarily to be looked into by the learned trial court.
List the matter on 17th. Yes.
And stay may be extended, my lord.
Interim order subsisting will continue to the next date of hearing.
Please, ma'am.
23 Saurabh Hegde.
ಇದು recreation,
ಹೌದು ಇದು ಸೆಕ್ಷನ್ 105 ಆಫ್ BNSS ಮೆಲಾಟ್ ದೇರ್ ಇಸ್ ಅ ಪ್ರೊವಿಷನ್ ಅದು ಫೋರ್ಸ್ಫುಲಿ ಕಮಿಂಗ್ ಅಂಡ್ ಟೇಕಿಂಗ್ ಔಟ್ ದಿಸ್ CCTV camera there is a provision so which says that that has to be recorded panchanama agbeku then only they can take out those things but they are not doing it. Melod, one more submission is Melod. Now what they do is there last date I have submitted there are 2 copies. What they do, they take both the copies and they delete
DVR
it.
ನಿಮ್ಮ ಹತ್ರ ಒಂದು ಕಾಪಿ ಇರಬೇಕು ಅಂತ.
ಅಷ್ಟು ಮಾಡಿಕೊಟ್ರೆ ನಂದು.
Let him secure instructions. I will take this. Learned AGA is directed to accept notice for the respondents, secure instructions and make his submissions. Only with regard to the submission of the council appearing for the petitioner that when the recreation clubs of the kind are searched, the CCTV is taken away from the CCTV that is in place in the said recreation club is taken away.
DVR.
Is taken away by seizing the DVR. The DVR so seized, both the copies of the DVRs are said to be taken by the police. The learned counsel submits that if one is kept with the petitioner and one with the police, it would support all material even if investigation would ensue. The learned AGA to secure instructions in this regard and make submissions. List on 18th.
Please, but the other 2 matters which my lord had disposed day before yesterday.
ಅದು ಇದೆ ಇವತ್ತು.
ಅದಿಲ್ಲ ಅದು ಮೆಮೊ ಫಾರ್ ಬೀಯಿಂಗ್ ಸ್ಪೋಕನ್ ಟು ಹಾಕಿದ್ದೀನಿ. ನಾಳೆ ಬರ್ತಾ ಇದೆ.
ಬರ್ಲಿ ಅದು ಅವತ್ತೇ ಹಾಕೋಣ 18th ಹಾಕೋಣ.
18th ಸರಿ
ಬಂದ್ರೆ. Yes, next.
Number 24 Venkatesham Kharvi.
Wife petition for conjugal rights. Well, after the closure of the both evidence, my lord, so in the cross examination the husband has denied that there was no marriage was not consummated. So on that ground we have produced the medical evidence
for the petitioner to serve on the council represents the respondent in the trial proceedings and file an acknowledgement of such service by the 6th of November 2025. List the matter on 20th till such time further proceedings before the concerned court shall remain straight. Please. Next.
25 B. Muhammad Ali.
Lord, in this writ petition, the property consisting of mosque.
Learned AGA is directed to accept notice for respondents. List the matter on 21st.
They have to file application online, my lords. They have made a.
ಹೇಳಿ ಅವತ್ತು. List on 21st. Next.
Much obliged.
6 A. Zubair. B. Muhammad Ali.
Leadership senior is engaged. He is in VC leadership.
No, ಯಾರು ಇಲ್ಲ.
Vikram Ulgoil sir is engaged my lordship.
Miller, I have to file my power.
Pass on.
I have to file my wakalat yet to receive, Miller. I am
What's
sick.
the problem?
In the board, there is a lot of exercises going on regarding the portal which is opened under Umid Act. And they are
Without following section 65 of the WAF Act, leadership, they are appointed administrator. They have not see that managing committee, petitioner managing committee as conducting day-to-day affairs.
Password, please.
27 I.Y. Patil.
Parole.
Parole members.
Learned
This is
AG is
first.
directed to accept notice for the
Please.
respondents. List on Friday. ನಾಳೆ ತಗೊಂತೀರಾ ಅನ್ಮರೆಡ್ಡಿ?
Monday.
ಆಯ್ತು ಮಂಡೇ. ಇದ್ರಲ್ಲೆಲ್ಲ ಇಮಿಡಿಯೇಟ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್. ಎಸ್. ಸೇಮ್ 28 ಅದೇನೆ.
Same.
Learned AG.
29.
ಎಸ್. ಅಂಗನವಾಡಿ.
Matter pertaining to my lord, Anganwadi worker, my lord.
Correct.
My lord, they are issuing the endorsement, my lord. When the application filing, my lord, I have not uploaded the original marks card. On that ground, my lord, they are rejected my application, my lord.
Curable defect.
Please.
Curable defect.
But even though your lordship, she
ಈಗ
has not
appointment ಆಗೋಗಿದ್ಯಾ?
submitted.
ಇಲ್ಲ.
Agilla, but she has not submitted original document.
Upload ಮಾಡಿಲ್ಲ.
Upload ಮಾಡಿಲ್ಲ.
Provisional upload,
Duplicate.
my lord. At the time of my lord, I don't have a original marks card. Due to
ಏನ್ ಇದೆಯಾ?
ಇದೆ.
I will verify your lordship and make submissions.
ಅಲ್ಲ, if appointment, if the candidate has assumed office, the joined rather.
That I will ascertain and make submissions.
I will stall it only if it is, she has not assumed.
Please, your
Will
lordship.
do it. Yes.
Please, your lordship.
The learned HCGP is directed to accept notice for the respondent. The petitioner and the fourth respondents were participants in a selection process for the post of Anganwadi worker, helper.
Helper, my lord.
Anganwadi helper. The petitioner claims to be more meritorious than the one that is selected. The petitioner secures 531 marks and the selected candidate, the fourth respondent, 506 marks. The non-selection of the petitioner is said to be on the ground that the original marks card was not placed for scrutiny while the copy had been uploaded. The learned counsel for the petitioner submits that while filing the objections, the original marks card was submitted. The learned HCGP to secure instructions as to how and why the fourth respondent had been selected. In the event the fourth respondent has not joined as on today, the further proceedings shall remain stayed. In the event the fourth respondent has joined as on today, it shall remain subject to the result of the petition.
Please,
List the matter on 21st.
Please.
November.
Issue emergent notice to respondent now.
Four emergent hand summons.
Please.
The fourth respondent be served by way of hand summons.
Please. Much.
Till number 30, Anya Sahib.
Give respondent. Appear for respond number 3 and 5.
ಎನ್ನೇದಲ್ವಾ ಇದು?
ಇಲ್ಲ.
ಇಲ್ವಾ?
Fresh.
May it please your lordship. Lords, this writ petition is pertaining to Nurani Masjid, Alnawar, Dharwad, my lords.
Yeah,
Lords.
So,
Lord, the impugned order is at page number 53, my lord.
what's the challenge?
Yes.
Constitution
The
of
present
committee.
petitioner.
Constitutional committee. Na?
Yes. But the present
Constituted on
petitioner, my lord,
13th
is.
Who are you?
Lords, I am the president of the earlier existing managing committee as per annexure C, my lord.
All right.
Page number.
How are you challenging? Will maintainable?
ಇಲ್ಲ.
ಕೊಡಿ. Madam.
Para 14, 15 and 16.
ಅದೇ tribunal. 83.
Even if there is no order also, they have to approach tribunal.
Since, my lord, the order is passed without hearing the petitioner, is a
Paras-
violation of the principle of natural justice, my lord. And discretionary lies on before this honorable court to,
I will not exercise.
please. Lord, since there's an order, my lord.
Go before the tribunal. If there is no order also, you have to go before the tribunal.
Yes, it is here.
Some
Concerning
protection.
a work.
Even if no order has been passed under this circuit, the party can approach of tribunal for determination of dispute.
I'll permit you. Yeah.
Some protection order may be passed, my lord.
What protection orders?
My lords, it is very apparent from the, my lords, the impugned order that already there is an existing committee, my lords. It is supposed to be ended on 24/11/25. They passed an order, my lord, the impugned order on 13/3/25. For a moment, my lord, your lordship kindly peruse page number.
The committee has already assumed, sir.
13/3/25. In the March itself, you are running.
My lords, that I'll convince your lordship. Lords, there is a.
What protective order can I pass? Tell me. What protective order?
You have assumed the charge.
13/3/25 status quo ಹೇಳ?
My lords, that came to the knowledge of the petitioners, my lord, during the hearing of the writ petition, my lords.
What can be done? but 13,325 is already assumed.
No, my lords, they have not assumed the charge.
13,325 assumed charge.
They have not assumed the charge.
ಏನ್
my lords.
challenge ಮಾಡಿದ್ದೀರಾ sir?
My lords, kindly peruse page
13,325.
number for a moment, my lord. Kindly peruse page number 33. Writ petition.
Then no problem. You approach the tribunal, I will direct status quo to be maintained.
Yes.
ಅಷ್ಟೇ.
Please.
That's the protective order I can. KL Patil ಇದಾರೆ ಇದರಲ್ಲಿ.
ಇಲ್ಲ.
Next matter.
My lords, if even if the status quo order is granted, my lord. My lords,
That's the only thing that can be granted.
Yes, but on 24/11/25, my lords, my period will going to expire, my lord.
Correct, sir. Status, what else can be granted? Tell me.
My lord, what has happened? This earlier committee resigned unanimously, my lord. They resigned, my lord, now they have challenged it. And my lord, there are two.
Where is that resignation?
My lord, they have produced the withdrawal of resignation, my lord, a copy, my lord. Today I have misplaced my file. They resigned it and all the committee members doesn't come. My lord, kindly turn, my lord.
Anyway, new committee is in place. Let me
Yes,
not
yes,
get into
yes.
all that. You approach the tribunal. I will direct status
My lord,
quo to
sir.
be maintained till the
My lords, I
tribunal
still
decides.
submits, my lord, the violation of principle of natural justice.
Sir, violation has taken place 6 months ago or
My lords,
7 months ago.
that order came to the knowledge of the petitioner, my lord, during the hearing.
ನೀವು 1 year ಬಿಟ್ಟು ಆಮೇಲೆ ನಂಗೆ ನೆನ್ನೆ ಗೊತ್ತಾಯ್ತು ಅಂತೀರಾ?
Illa, my lords.
No, sir.
Let's kindly peruse the
No.
page number.
That can't be accepted. If it was
Initially-
an order passed yesterday, there is some meaning.
In the month, my lord, in the month of October, my lords, on 15/10, this order, we came to the knowledge of this order, my lord.
ಹೌದು, petition ಹಾಕಿರೋದು ಯಾವತ್ತು 23/10.
Please, my lords.
No, sir. Absolutely difficult.
In page 58, they have resigned, my lord.
Yes.
That's all right. Let me not get into all that.
Yes.
My lords,
Everything
we
is,
have already withdrawn that resignation also, my lords, as per annexure.
sir, you have resigned, withdrawn that resignation or resignation that's pending before the board, all that is. You are challenging 13/3/2025.
Please.
Constitution of the committee.
Yes.
Correct. It is 7 months old. In a petition that is not maintainable or not entertainable rather, you'll have to approach the tribunal. We'll send you to tribunal.
My lords,
ಏನು
kindly,
protective order ಬೇಕು status quo will
my
grant.
lords, kind request, my lords, kindly peruse page number, lords, annexure N, my lord.
No.
Annexure N. Lords, during the hearing, my lords, at the time of hearing this writ petition, my lord, the respond number, the counsel who is appearing for respond number 4 and 8.
ಆಗಿದ್ದ?
Yes, ide. We came to the knowledge of this order at the time of the hearing of this writ petition, my lord.
A new committee is already constituted.
Yes. And since a liberty is granted to the petitioners to challenge this order, as
ಆಯ್ತು, objection ಹಾಕಿ.
my lords, it's very apparent on the.
No, 1 minute. The petitioner had approached this court in writ petition 101-457 of 2025. The learned counsel Sadiq Godwala, appearing for respondents 4 and 8 therein, placed on record the constitution of a new committee on 13/3/2025, which the petitioner submits that was the first time it came to the knowledge of the petitioner that the new committee is constituted. Therefore, withdrew the petition seeking liberty to raise a challenge to the order dated 13/3/2025. In that light, the respondent shall now file their statement of objections. This the matter on, ಯಾರ್ಯಾರಿಗಿದು?
Notice to the respondents.
Who is that?
Respond number 1 and 2 must appear.
1 and 2 Mohammed Ali.
Mohammed Ali.
1 and 2
Please.
Mohammed Ali. ನೀವು Sadiq?
3 and 5 appear.
3 and 5, 4.
My lord, others notice.
Notice.
Emergent notice list on 21st.
My lords, till then a stay maybe.
Stay ಇಲ್ಲ, status quo ಕೊಡ್ತೀನಿ.
Please, grateful your lordship.
Status quo ಇರಲ್ಲ?
Please.
Yes. Yeah. Next.
31, which case?
Seeking mandamus, my lords, to issue NOC pursuant to annexure B.
Bagalkote.
Sanjay Chinal models have served copy.
8 weeks time, we'll consider.
The petitioner is before this court seeking the following prayer, heard so and so. The petitioner submits an application seeking a no objection certificate in terms of the Bagalkote Town Development Authority rules to issue an NOC. For what?
For my lords.
For construction.
Please.
NOC for construction of the property. The non-consideration of the said application stroke representation is what has driven the petitioner to this court in the subject petition. The learned counsel Sanjay, so appearing for the respondent Bagalkot Town Development Authority, submits that if reasonable time is granted, the application of the petitioner for seeking of NOC would be considered in strict consonance with law and appropriate orders would be passed. In the light of the said submission, without entering into the claim, merit of the claim of the petitioner, I deem it appropriate to dispose the petition with a direction to the respondents to consider the application of the petitioner and pass necessary orders within an outer limit of 10 weeks from the date of receipt of the copy of this order, if not earlier, ordered accordingly.
Please.
Next.
32 KL Patil.
Hold on, connected matter, I have moved at 2:30, connected to these two petitions.
Connected matter?
You, ಎರಡು petition.
ಅದೇ ಮಧ್ಯಾಹ್ನ election.
2:30 ಒಂದು move ಮಾಡಿ.
2:30 pass over.
33.
Same, 32, 30.
4. Rajshekar Halli.
Compromise.
Yes, please.
Lok Adalat.
Lok Adalat. As per compromise decree, my lord, there are direction to issue, enter my names in property, my lord.
I am for the respondent number 1. I'll permit it to file Wakalat on behalf.
Registry Ilaki.
Please.
Learned counsel so and so undertakes to enter appearance for the first respondent. Learned AGA for the second respondent. List on 17th.
Please.
Yes, next.
Cell number 35.
We are back to appear through VC lordship. Because this is
Why?
a short point
Oh,
lordship in this
yes.
matter. Lordship, the respondent has filed DV petition against the grandson and the daughter-in-law after the demise of son. Lordship has dealt this matter while they have filed it as a senior citizen act under citizenship.
Oh, yes, yes.
So they have filed DV Act. And the DV Act, Lordship, the court has directed us to file a asset and liability affidavit. We filed a memo stating that in this case, our asset and liability memo is not required, and that he has passed an impugned order. And we are challenging the impugned order of the directing us to file a asset and liability matter. Lordship, we already paying almost 14,000 rupees daily.
That's all right. Assets and liabilities, why it should not be filed?
Lordship, kindly appreciate. Here the issue is not between husband and wife.
Then
here is the mother and
senior citizens.
Senior citizen. And
who is that who has directed assets and liabilities to be filed here?
In the DV case, Lordship, it is in DV case they have filed DV case against us.
All right, who are you?
My lord, I am appearing voluntarily if you are.
Voluntarily?
I am in trial.
Voluntary appearance.
Yes, my lord.
The learned counsel so and so undertakes to enter appearance for the respondent.
I am filing wakalat, my lord.
Registry to print the name of so and so is appearing for the respondent. They list the matter on 18th. Further proceedings before the concerned court shall remain stayed till the next date. Please.
Yes. Deeply
obliged. Copy.
Cell number 36.
In terms of
Permission to draw.
Thank you.
Please.
37.
Granted.
DB Patil.
CMP.
Please.
Letter is withdrawn. And madam. Substitution of arbitrator.
Please.
Who is there? Learned counsel on the earlier occasion.
37 item.
37.
Yes, my lord, we are.
Matter has been settled between the parties. is
Yes,
what?
yes.
We'll close it then.
Yes, please. Your lordship, I'll just hand over the copy of the settlement.
Heard the learned counsel appearing for the petitioner and the respondent. So and so, or name Barkole. The parties to the list had earlier submitted that the matter has been settled between the parties. The learned counsel now submits that the matter has been settled and places the terms of settlement arrived at between the parties. The terms of settlement, could you give the reads as follows. In the light of the settlement arrived at between the parties, further the petition need not detain before this court. Recording the said settlement, the petition stands disposed.
No. That may be taken on record.
Yes, I have already
Yes.
extracted it.
My lord.
Yes. Next.
38.
38 in terms of memo. 39 memo.
38, 39, my lord.
Sridhar Prabhu.
Done. ಅದ್ರಲ್ಲಿ ಸರ್ವಿಸ್ ಇದು ವಿಡ್ರಾಯಲ್ ಅಲ್ಲಿ ಮೇಲೆ ಹರ್ಡ್ ಪೆಟಿಷನರ್ ಹರ್ಡ್ ಮೇಡಮ್ ಆಮೇಲೆ ಮೆಮೋ ಫಾರ್ ವಿಡ್ರಾ. ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ ಮೇಡಮ್? ಅಲ್ಲ ವಕಾಲತ್ ಹಾಕಿಲ್ಲ ಅಂದ್ರೆ ಅದರಲ್ಲಿ ಸ್ಟೇಟ್ Learned HCGP is permitted to file ವಕಾಲತ್ in the next 4 weeks if not already filed. ಅದು ಹಾಕ್ಬಿಟ್ಟು ಆಮೇಲೆ ಏನಿದು?
Your stay vacating application is filed. My learned friend, my lord.
ಯಾರು ಶ್ರೀರಂಗ?
Yes.
Yes. Lord, section 11 orders challenge, Lord. There is already an order of Lord, this honorable court, Lord, deciding the issue with regard to, my lord, the validity of the section 11 order that has been passed, which is now subject matter of a batch of writ petitions, writ appeals. Writ appeal 526 of 2024, 529 of 2024 and 530 of 2024. It is pending before the division bench of High Court, my lord. And so far as similar petitions are concerned, my lord, where section 11 and 11(2) orders were challenged subsequent to the decision in the earlier batch. Lord, there are 2 sets of orders which have been passed by coordinate bench. My learned friend, Lord, is there who will pass on the 2 orders.
Where is Prashant?
In the case of writ petition 355,
is appearing for Prashant Gaudre.
355 of 2025, that order is at page 3 of, my lord, the memo. This is an order of 13th of January 2025, wherein, my lord, there was a challenge to the 11(2) order, my lord, fixation of tariff by the commission pursuant to section 11 order. And, my lord, it was directed that they should go and file an appeal against this order. And pursuant to this, there are appeals filed before the APTEL with regard to the same order under 11(2), appeal 75 of 2025 and 77 of 2025 before APTEL, my lord. There are 2 appeals which are pending consideration now. In so far as prayers very similar to the prayers made in the present proceedings is concerned, in case of NSL Sugar, Lord, wherein my lord had initially, my lord, granted an interim order, page 11 of the memo. Subsequently, my lord, matter has been heard, and, my lord, the petitioners were directed to, Lord, if they are aggrieved, file an application in the pending appeal, writ appeals, and seek, Lord, reliefs if any. That is the direction. And, Lord, with that observation, writ petitions were dismissed. Lord, pursuant to this, my learned friend, my lord, has now filed applications in the pending writ appeals, 526 of 2024 and other connected appeals. Therefore, my submission, my lord, is so far as section 11 order of the government is concerned, my lord, it has already been, there is a decision already, Lord, in place, which is subject matter of the appeal. And that appeal is pending. And the coordinate bench has directed, my lord, that if they have any grievance with regard to that very order, they should make an application in those proceedings. And in so far as 11(2) orders are concerned, my lord, there are already appeals before the appellate tribunal against the very same order. And therefore, my lord, my submission, my lord, is to avoid, my lord, any, my lord, multiplicity of proceedings and 2 forums considering the same issue when there is a alternate efficacious remedy under 111 for my learned friend, my lord. Kindly direct him, my lord, to take recourse to the appeal remedy which is already available, because there are already appeals pending pursuant to orders of the Honorable High Court.
Yes, may I, my lord?
Yes.
My lord, may I pass on this memo? Wherein, my lord, lordships pass an interim order in this matter, in an identical matter, I would say. The issue is this, before your lordship peruses that, my lord, the issue in this writ petition is this, page 110, my lord, is the order of the commission. And Annexure A is the order of the state. Annexure A, my lord, is the section 11(1) order. Wherein, my lord, they have compared.
Order ಮಾಡಿದ್ನಲ್ಲ
ಮಾಡಿದ್ರಲ್ಲ ಅವ್ರು ಏನ್ ಮಾಡಿದ್ರು, they were present. Then they filed another application for vacating stay in the very matter and said that this very petitioner has filed a writ appeal there and please relegate him there and, my lord, let him file an application. Now the same treatment they want to give me in this writ petition. There the distinction is, first of all, my lord, it was heard, both were heard. Thereafter, they filed an application for vacating stay. The court entertained. I said internal res judicata. All that was considered. They said I am finally disposing it off and said you are the petitioner and you are the writ appellant before the division bench. You go. Now here, my lord, this distribution company is telling me to go. Urine appeal hakle illa. Lorships will see who has filed the appeal in writ appeal is SLDC. The State Load Dispatch Center has filed. State has filed. State's order. My lord, the Annexure A is the state order under section 11(1), and I am challenging it before your lordship. Now, my lord, what has happened is
ಫೈಲ್ an appeal.
ಅಲ್ಲ ಯಾವುದು ಇಲ್ಲ ಅಪೀಲ್ ಏನಿಲ್ಲ ನಾನು ಸ್ವಲ್ಪ ಇದು ಹೇಳ್ತಿಲ್ಲ.
ಈಗ ಜಸ್ಟಿಸ್ ಅನಂತ್ ಹೆಗಡೆ ಅವರ ಆರ್ಡರ್ ಇದೆಯಲ್ಲ,
that, my lord, yes, that order in Renuka Sugar's case, there he challenged KERC's order, my lord.
Really, what is under challenge here?
Here is the government order.
Also KERC.
11(1) ಅಲ್ಲ ಹೇಳ್ತೀನಿ I'll 11(1) order at
come to page 89.
Yes. Yes. Page 89, my lord.
Purportedly under 11(1).
Yes, yes. 105 may kindly be seen, my lord. This is the order which is, my lord, under challenge. And consequent order is KERC order. ಈ 11(1) order na basis itkondu 11(2) order is passed. So I cannot, my lord.
11(1) order appeal ಹಾಕಬಹುದಲ್ಲ?
ಇಲ್ಲ. There is government order, my lord. I cannot even challenge it before KERC.
What is Justice Anant Hegde's order?
Yes, Justice Anant Hegde's order, my lord, says, my lord, that Renuka Sugar's challenge,
Sugars ಅಲ್ಲಿ ಏನ್ challenge ಇದೆ?
Exclusively the 11(2) order was challenged. Lordships will see, my lord, the prayer, page 5 of the memo filed. Writ petition filed, OP number so and so, and consequently direct the respondents to pay. ಆದ್ರಿಂದ ನೀವು KERC ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡೋದಾದ್ರೆ ಆಪ್ಟೆಲಿಗೆ ಅಪೆಲೇಟ್ ರೆಮಿಡಿ ಇದೆ ಅಂತ ಕಳಿಸೋದು. ದಟ್ ಇಸ್ ಕರೆಕ್ಟ್ ಲಾ. And subsequently what happened, my lord, I had challenged both in NSL at page 11, which my learned friend, my lord, has produced along with the memo. ಈ NSL sugar ನಲ್ಲಿ I had challenged, my lord, 11(1) order as well as 11(2) order, KERC order as well. What the learned single judge says, you are the writ appeal, you are the respondent there in the writ appeal. ಇವರೇ writ appeal ಹಾಕಿದ್ದಾರೆ, ಅಲ್ಲೇ adjudication ಆಗುತ್ತೆ, ಅಲ್ಲೇ ಮಾಡ್ಕೊಂಬಿಡಿ ಅಂತ ಹೇಳಿದ್ರು. Then I filed an application because, my lord, the issue was NSL itself was the respondent in the writ appeal filed by, my lord, my learned friend. So therefore it is correct. ಇಲ್ಲೇನಿಲ್ಲ, ಇಲ್ಲಿ ನಾನು 11(1) order challenge ಮಾಡಬೇಕು, 11(2). Now what has happened, my lord? The writ appeal is pending before the division bench and Friday is the hearing. My learned friend has to commence arguments.
Where?
In division bench, my lord. ಇದನ್ನ ಇಲ್ಲೇ ಇಟ್ಕೊಂಡು 2 ವಾರ ಅಡ್ಜರ್ನ್ ಮಾಡಿ ಅವರು ಅಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮುಗಿದ್ರೆ ಇದು it will be settled. That's all I'm saying. Instead of relegating me to the division bench, and, my lord, SLDC is the appellant there. What happened, my lord?
No, I'll take this on Tuesday. If nothing has happened in the writ appeal, we'll decide.
Next,
no, 5th, 4th, list the when is the appeal there?
On Friday, my lord. Friday 2:30.
List the matter on 4th at 2:30 p.m.
Yeah.
Yes.
Great.
Great. Interim orders may kindly.
Interim order subsisting will continue to the next date of hearing.
41, Sheridan Patil.
It's a request a week's time, my lord.
A week's time to do the needful.
Copy of the respond number 1, my lord. So it has,
Learned Counsel Rajshekhar Burji accepts notice for the first respondent registry to print the name of so and so is appearing for the first respondent.
Submission. Lord, so it has become
infructuous.
Infructuous. I memo ಹಾಕ್ತಾರೆ.
ಮೆಮೊ ಹಾಕಿದ್ದೀರಾ?
ಮೆಮೊ ಹಾಕ್ತೀರಿ. ಪಾರ್ಟಿಷನ್ ಇತ್ತು ಮೆಮೊ. Tomorrow or day after.
ಪರವಾಗಿಲ್ಲ. ನೀವು ಹಾಕಿ. What is the claim?
Transfer.
ಅದಕ್ಕೆ ಸಿಗ್ನೇಚರ್ ಹಾಕಬೇಕು. The petitioner is before this court seeking the following prayer. We heard the learned counsel Rajshekhar Burji appearing for the first respondent, the learned HCGP appearing for this. ನೀವಿಲ್ವಾ? GS served ಅಂತ ಇದೆ?
ಇಲ್ಲ. ಅದು ಕೇಸ್
ಇಲ್ಲ. So and so. For the respondent, the issue relates to transfer. The petitioner during the subsistence of the subject petition has retired on attaining the age of superannuation. Therefore, nothing can survive to be considered in the subject petition. Therefore, the petition is disposed as having become infructuous. Adike act party signature. Learned Counsel Rajshekhar Budji is permitted to enter file his wakalat in the next 4 weeks. Next.
Obliged.
HM Dharigun, PN Hatti.
Transfer
Made
ಇದು.
application for Maladi. Release this,
Transfer.
transfer, release the salary,
Not paid.
not paid.
My lord, it is held up.
Why?
My lord, he has been relieved.
Interim order idmel ಮತ್ತೆ ಹೆಂಗ್
He
salary
was
ಕೊಡ್ತಾರೆ?
relieved, my lord, before an interim order could be passed. That is the contention.
Now, where is he working?
My lord, he's still there only.
Salary.
Allah, that IA, my lord, that let there be a court order, IA could be allowed. But this WP, my lord, may not. My lord, everybody, my
First
lord,
salary ತಗೊಂಡ್ಬಿಡ್ಲಿ, ಆಮೇಲೆ we'll decide. The
ಎಲ್ಲರೂ transfer ಆದ ತಕ್ಷಣ, my lord, for 7 or 8 continuous years, he has served at Sirsi.
on merits ಇರ್ಬೋದು. But if he is working and salary is not paid, that's not correct. You release the salary, I will consider this. It may get dismissed also, we don't know.
The date may be fixed.
That I will, all that will do. The petitioner is before this court, calling in question an order of transfer dated 4/4/2025. A coordinate bench of this court grants an interim order of stay of the order of transfer in terms of its order dated
13/5.
13/5/2020.
13/5.
ಹೌದು, ವೆಕೇಶನ್ ಅಲ್ಲಿ ತಗೊಂಡ್ರು.
ಅವಾಗ ಕೊಡೋದು 13/5/2025. By virtue of the interim order, the petitioner is continuing to work at
Sirsi.
Sirsi. An application is now preferred seeking a direction for release of salary. The learned counsel Harsh Desai, representing the respondent university,
Yes, ma'am.
university submits that by the time the interim order was granted, petitioner had already been relieved, which is disputed by the counsel appearing for the petitioner. But the fact remains that the petitioner is still working at Sirsi, and the allegation is salary is not paid. Therefore, whether the petitioner has a right or otherwise would be considered at the time of final hearing. This petitioner cannot be made to work without payment of salary. Therefore, the university. Therefore, the university shall release the salary of the petitioner forthwith release the salary by the next date of hearing. List the matter on 18th in fresh matters list.
Please.
Dispose it on that day. Astal salary ಕೊಟ್ಬಿಡಿ, ಇಲ್ಲರ ಕೇಳಲ್ಲ. Yes.
Silva 43, Sanket.
May I please, my lords, I am seeking extension for a different purpose, if I may please, my lords. 15 days back, they have made an offer. They have made an offer to regularize by way of mortgaging my dwelling.
Document.
My lords, let me put another thing, my lord.
Document.
This
Offer
was-
document.
This was orally done. This was orally done, orally. And only yesterday, they changed their offer and they said me that if I pay 5 lakh, they will regularize it.
Where is that?
Today, I am paying 2 lakhs. My lords, I have a text of manager.
Where is
Client has
the-
received a text message.
Who appears for the respondent?
My lords, no one is appearing. In fact, I was.
Canara Bank. ಯಾರಿದ್ದಾರೆ Canara Bank? ನೀವಿದ್ದೀರಾ? ನೀವು ಇದ್ದೀರಾ? ಅವ್ರ ಹೆಸರು ಮೇಡಮ್. So and so accepts notice for the respondent Canara Bank. The learned counsel for the coordinate bench of this court had granted an interim order of stay on 30/6/2025. The learned counsel appearing for the petitioner submits that an offer has been made to pay 5 lakhs and the account could be regularized. Solely on the said submission, awaiting further instructions at the hands of the respondent, the interim order shall continue to the next date of hearing. List the matter on 19th.
Very great.
Yes.
Sorry, Malad.
44.
Previous matter, Malad.
Huh?
Previous matter. One more connected matter post along with Malad.
ಯಾಕೆ ಅದೇ ಅರ್ಧ?
Ad Malad is during 2023 is appointed as a Malad
Tag along.
coordinator. That is also stated.
ಆಯ್ತು. ಅದರಲ್ಲೂ ಹರ್ಷ ದೇಸಾಯಿ ಅವರು ಇರೋದಾ? Same day. Next.
44, Srinath Pachapuri.
This is KPID matter, my lords, where, my lords, 3 societies have been, my lords, declared, my lords, as fraud, my lords, by the government, and a notification was passed under KPID, my lords. Now, 232 crores of amount has been embezzled by the society, my lords. A special court is, my lords, established.
Oh, what is under challenge, sir?
But the claim of these depositors have been refused on the ground that there is no verifiable proof, my lords. Lord, this claim petition was,
Let Viresh come.
yes. Lords, there are another connected matters, my lords.
Alla kodi.
Yes,
Numbers
my sorry.
Tag these petitions along with so and so, list them all on 6th.
Please.
Awaiting the appearance of Viresh Budihal.
Please.
Yes, next.
Bill number 45, Girish Yadwad.
In preliminary hearing haki. Tell.
For petitioner, my lords, kindly pass over, my lords. This is regarding the not.
ಇದೆಯಲ್ಲ?
This is election not
Section matter.
complete over. Here I undertake to file wakalat for R7 DCC Bank, Lord.
R7.
One submission, my lord. This is regarding not to vote, my lords.
Here
He is the defaulter, my
seeking a
lords.
mandamus, directing the 10th respondent not delete his name from the voter list. Lord. My lord has granted
The
permission
petitioner
I am for
that
respondent on the
substantive ground right to vote cannot be taken away by
Yes.
stroke of pen.
and he has
Vote.
casted vote, my lord.
Is casted his
Casted
vote.
vote.
I am for respond number 10, my lord. Today I have filed wakalat, my lord.
ಏನ್ ಉಳಿತಾ?
ಅಷ್ಟೇ ಉಳಿತು.
Kindly pass over, my lord, senior.
ಇಲ್ಲ ಬೆಳಿಗ್ಗೆ ಹೇಳಿದ್ದೀನಿ ಅವ್ರಿಗೆ ಇಷ್ಟೇ ಅಂತ ಹೇಳಿ.
ಇಷ್ಟೇ?
Please, please.
ಅಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಳ್ಳಿ ಏನಾದ್ರು ಇದ್ರೆ.
ಅಷ್ಟೇ ಮಾಡಿದ್ದಾರೆ ಅದನ್ನ.
Sorry, ma'am. The petitioner is before this court seeking the following prayer. Owing to the submission of the counsel for the petitioner, this court had, in terms of its order dated 15/10/2025, observed as follows. The learned counsel for the respondent, Shivraj Mudol, submits that, seventh respondent, Allah? Seventh respondent submits that the elections are over and the petitioner and the 10th respondent has already cast his vote. In the light of the said circumstance, reserving liberty to the petitioner to avail of such remedy as available in law, the petition stands disposed. All contentions are kept open to be urged before the appropriate forum. Ordered accordingly.
Result
The result withheld agidya?
ಎಲ್ಲಕ್ಕೂ
The result of, I'll mail barಕೊಳ್ಳಿ. In the light of the elections being over, the result that is, the results of the election shall be declared and all remedies shall remain open for the petitioner to raise a challenge before the appropriate forum.
Not one But my submission. vote may kindly be, my lord. My vote may kindly count.
Vote court count agli. Correct barಕೊಳ್ಳಿ. Pass the following order. The elections are now over. The 10th respondent has been permitted to vote and the vote has been kept in a separate sealed cover owing to the submissions then. In the light of the elections getting over and the remedy of calling in question the said elections being elsewhere and not before this court, I deem it appropriate to direct the respondent to declare the results counting the vote of the 10th respondent as well, reserving liberty to the petitioner to avail of such remedy as is available in law, and all contentions that are projected before this court to be urged before the appropriate fora at the appropriate time. Ordered accordingly.
Please. Today I have filed wakalat on behalf of respondent number 10.
ಬರ್ಕೊಂಬಿಡಿ ಯಾರ್ಯಾರ್ದು ಅಂತ.
Anand Bhagyavadi.
So and so. Yes, next.
160.
175, 175, 176 pertaining to DCC Bank.
Same order?
Same ಅದರಲ್ಲಿ they have casted vote ಮಾಡಿ separate ಇದಾಗಿದೆ.
ಅದೇ ಇದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದೆ ಅದೇನಾ?
ಇದು ನಿನ್ನೆ ಮಾಡಿದ್ದಾರೆ ಅದು ಸೇಮ್. ಶ್ಯಾಮ್ ಪ್ರಸಾದ್ ಸಾಹೇಬ್ರದ್ದು ಇದೆ.
ಬರ್ಕೊಂಡು ಮಾಡಿ ಗೊತ್ತಾ ಯಾವ್ದು ಅಂತ. ಇವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ ಸಾಕು ಅವ್ರು
ಇದರಲ್ಲಿ ದಿ ಪಿಟಿಷನರ್ಸ್ ಹ್ಯಾವ್ ಕಾಸ್ಟೆಡ್ ವೋಟ್ ಮಾಡಿ. ಈ ಕೇಸಲ್ಲಿ ರಿಸ್ಪಾಂಡ್ ಕಾಸ್ಟೆಡ್ ವೋಟ್ ಇಷ್ಟ ಆಯ್ತು.
ಯಾವ್ದ್ರಲ್ಲಿ?
ನೋಡಿ 175, 176 ನೋಡಿ ಎಸ್ಟರ್ಡೇ ಆಗಿದೆಲ್ಲ ಸೇಮ್ ಅದು.
ಆಯ್ತು ಅದು ಯಾವ್ದು ನೋಡ್ಕೊಳ್ಳಿ ಮೇಡಮ್.
ರಿಸಲ್ಟ್ ಟು ಬಿ ಅನೌನ್ಸ್ ಮಾಡಿ.
ಅದೇ ಸೇಮ್ ನೆನ್ನೆ ಏನು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ ಅದು. Next.
Appearing for petition.
In terms of.
My lord, one objection for this, my lord.
Objection to withdraw?
Seriously. What, my lord, 230, another matter is coming up. The consequence of this matter, my lord, what they have done, why they are withdrawing it, my lord, 230 it may be taken, both the matter.
If he has filed a petition, he wants to withdraw the petition.
My lord, what the prayer they have asked, what interim order they have got, my lord, kindly.
ಈಗ ವಿಡ್ರಾ ಮಾಡಕ್ ಬೇಡ ಅನ್ನಕ್ಕಾಗತ್ತಾ?
ಅಲ್ಲ ಯಾಕೆ ಅವರು 230 ವಿಡ್ರಾ ಮಾಡ್ಲಿ, ಬಟ್ ಅದು ಇನ್ನೊಂದು ಪಿಟಿಷನ್ ಇದೆ ಇದ್ರದ್ದು, ಅದು 230 ಬರ್ತಾ ಇದೆ, 2-3 ಸೇರಿಸಿ ಇದ್ ಮಾಡ್ಬೋದು. ಕೈಂಡ್ಲಿ 230 my lord.
Respondent number 8 has, my lord, not to cast more than one vote. That is the contention of the petitioner. Respondent number 8 has not even casted the vote. He has selected unanimously.
No, my lord.
That is the memo filed, my lord. That memo may be accepted.
It may be taken, my lord. With that writ petition, I'll make submissions.
230 ಮೂವ್ ಮಾಡಿದೀರಾ?
ಹೌದು ಮಾಡಿದ್ದೀನಿ. ಆ ಕಾನ್ಸಿಕ್ವೆನ್ಸ್ ಏನಾಗಿದೆ ಅನ್ನೋದು ಮೂವ್ ಮಾಡಿದ್ದೀನಿ. 230 ತಗೋ.
But difficult to permit someone to object withdrawal.
Yes. After hearing that matter, my lord may. Please.
47.
Same.
Pass over. 47 is same. ಅದು withdraw ಇಲ್ಲ?
ಅದು withdrawal ಆಗಿದೆ.
ಎರಡು withdrawನೇ. I am not.
Please.
46, 47. Harvey,
48.
2 days time, 2 days.
2
Monday,
days time
Monday.
is granted to comply with the office objections in the event they stand complied, list on Monday in fresh matters list. Yes.
40 right, dismissal.
Any cost as per 22/9.
Taking 2 days accommodation. Kindly pass over, my lords. I'll do it.
By the end of the day.
Please. Please.
ಸಾಯಂಕಾಲ 4 ಗಂಟೆ ಕರಿತೀನಿ.
Please.
ಅಷ್ಟಲಾಗಿದ್ರೆ ಸರಿ, ಇಲ್ಲದ್ರೆ ಅಪ್ಲಿಕೇಶನ್.
Please.
ಬಿಕಾಸ್ ನಿನ್ನೆ ಒಂದು ಇವತ್ತೊಂದು ಮಾಡಕ್ಕಾಗಲ್ಲ, ನಿನ್ನೆ ಹಾಗೆ ಮಾಡಿದೆ.
Please.
263 same.
Up to?
63.
ಹಾ.
64 FE Patil, Shashank Hegde.
Disposal.
Week after next.
ಯಾಕೆ ಪಾಟೀಲ್ ಸರ್?
Some IS has been filed by implementing application by yes. IML.
ಆಯ್ತು, ಒಂದು ಡೇಟ್ ಕೊಡ್ತೀನಿ ಅವತ್ತು. ಲೆಸ್ ದ ಮ್ಯಾಟರ್ ಆನ್ 6ನೇ ತಾರೀಕು ಆಗ್ಬೋದಾ? ನೆಕ್ಸ್ಟ್ ವೀಕ್
10th Milord.
10th ಬೇಡ,
11th or 12th.
ಆ ವೀಕ್ ಬಿಟ್ಟು ಬೇರೆ.
Next week.
ಆಯ್ತು, 18th.
Please.
List the matter on 18th as a last chance. It is made clear no further adjournment would be granted in the matter.
Some impending applications are there, my lord.
Well, all applications would be considered along with the main matter.
Yes.
Judgment covered ಇದೆ.
16th. Date ಯಾವ ಕೊಟ್ಟು 18th.
Yes. 17. 18th. 18th. Yes.
Bill number 65. Scale Patil. Bill number 65.
18th.
66 J Shetty. Shetty, base content.
ಗವರ್ಮೆಂಟ್ ಇದಾರ ಮೇಡಮ್? ಸ್ಟೇಟ್ ನೋಡಿದ್ದೀರಾ? 66.
Please, your lordship, vacate they have filed respond number 2 is
What's issue?
please.
2021 Password. Password.
67 VM Shilvan.
Petitioner has expired, my lords. I filed application to bring the legal heirs on record. It is a writ of mandamus.
ಅದಕ್ಕೆ ಎಲ್ಲಾರ್ಸ್ ಆನ್ ರೆಕಾರ್ಡ್. ಯಾರು ಮಿಲ್ಕ್
ಕನ್ಸಿಡರ್?
ಕರ್ನಾಟಕ ಮಿಲ್ಕ್ ಅಂಡ್ ಏನದಾರ ಅದೇ ಯಾವುದು?
ಮಿಲ್ಕ್ ಫೆಡರೇಷನ್, KMF.
ಫೆಡರೇಷನ್ ಮರ್ತ್ಬಿಟ್ಟಿದ್ದೀರಾ? ಕರ್ನಾಟಕ ಮಿಲ್ಕ್ ಅಂಡ್ ಏನದಾರ ಅಂತ. ಏನ್ ಮ್ಯಾಂಡಮಸ್ ಏನು?
I was not paid pay scale of as paid to the other employees, my lords. There was discrimination. That is my submission.
But the petitioner has died now.
How? He has expired, my lords.
You bought the LRs on
After
record?
superannuation, he expired.
ಇಲ್ಲ, LRs on record ಬಂದಿದಾರ?
I filed application, my lords. That is
During the subsistence of the petition, the petitioner is no more. Therefore, 3 applications have sprung. One for abatement, setting aside abatement, one for condonation of delay, and the other to bring the LRs on record. On a perusal at the contents of the application and the affidavit accompanying the application, when being satisfied with the same, the applications are allowed. The petitioner shall amend the cost title by bringing in the LRs on record. The issue relates to fixation of revised pay of the deceased husband. And the deceased husband who retires on attaining the age of superannuation without getting his revised pay, which he has been agitating throughout. Therefore, in view of the monetary benefits available to the family even, the right to sue would survive. In that light, list this matter on 19th in preliminary hearing. Yes, next. Respondent yaru? Notice agilva?
notice agide, but they are not represented.
KMF ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ ಗೊತ್ತಾ ಮೇಡಮ್?
KMF, I'm told that Arvind Kulkarni appears. I asked him, but this pertains to cattle field section. That is the reason he cannot take a notice anta ಹೇಳಿ.
ಅದೇನು ಕ್ಯಾಟಲ್ ಬೇರೆ ಬೇರೆ ಇದೆಯಾ ಅಲ್ಲಿ, ನೀವು ಒಪ್ಪಿರ ಆಗ್ತೀರಾ? KMF Learned Counsel Arvind Kulkarni is directed to accept notice for the respondent. ಕೊಡಿ ನೀವು ಹೇಳ್ತೀನಿ. Petitioner to serve set of papers upon the aforesaid counsel. Next.
68 SH Dharwad.
In this case, I'm appearing for the petitioner, my lords. Now, in this case, my lords, petitioner was a whistleblower of the multi-crore fixed.
ಎಲ್ಲಿ whistle blow ಮಾಡಿದ್ರಿ ಸರ್?
My lords,
Where did you blow your whistle?
in the fake stamp scam, my lords, that Telgi scam, my lords.
ಓ ಆ ಕಾಲದಲ್ಲಿ.
Yeah, please, my lords.
ಇವಾಗ ಯಾಕೆ ಬಂದಿದ್ದೀರಾ?
Lords, at that time, my lords, due to his service, he was allotted with a free site, my lords, as a reward, that 4060 site. And the government, my lords, vice later has contended that it is government will pay the amount, my lords. And subsequently, allotment was also been made to me, my lords. But instead of, my lords, reward, they have asked me the amount of rupees 3,83,000.
ಕೊಡ್ಲಿಲ್ವಾ?
Kotila, my lords. 3,83,000 they asked, my lords. Thereafter, my lords, subsequently, I made representation stating that it was a reward anta. Again, my lords, they have not considered stating that I have not deposited the amount within 90 days. And subsequently, my lords, though it was as a reward, I asked them, I am ready to pay that amount also, my lords. Still that, my lords.
ಬೆಳಗಾವಿ ಅರ್ಬನ್ ಡೆವಲಪ್ಮೆಂಟ್ ಅಥಾರಿಟಿ ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
MA Hulial Melots is no
ಆನ್ ಅಲ್ಲ ಹೇಳಿದ್ ಮೈಕ್ ನಿಮ್ಮ ಹತ್ರ ತಗೊಳ್ಳಿ ಅಂತ.
MA Hulial Melots is not on the panel of Belgaum Urban Development Authority.
Who is in?
Today I undertake Melots to file.
Learned Counsel Gurudev Gachinmat undertakes to enter appearance for the Belgaum Urban Development Authority in place of MA Hulial. Registry to print the name of Gurudev Gachinmat as appearing for the first respondent. The issue in the list revolves around.
Melots, I request for some time. I have not yet filed. Please.
The issue in the list revolves around the entitlement of the petitioner for a site on account of him being a whistleblower, which led to the proceedings in the year 2006 and 7 concerning concerning so and so. As assured to the petitioner, a site measuring 40/60 was to be allotted. The allotment has not come about even today, and the respondents are dodging the petitioner on the issue. Therefore, Gurudev Gachinmat shall secure instructions as to why the petitioner's entitlement is being dodged, notwithstanding the assurance so granted to him. List the matter on 20th in preliminary hearing.
69 Anant P. Saudi. Suresh S. Kundi.
ಏನಿದೆ ಇಷ್ಟೊಂದು ಅಪ್ಲಿಕೇಶನ್? ಅನಂತ್.
I have received the copy of the application. I'll file objection, Lordship. Production of documents. Yes, called for some documents.
All objections in the applications be complied with by the next date. All other applications except the office objections will be considered along with the main matter. List the matter in preliminary hearing on 19th.
Please.
Objections, if any, by the respondent by then.
Please.
Next.
Number 70.
ಆಯ್ತು. ಅದು ನೆನ್ನೆ ಇದ್ರಲ್ಲ ಅದು ನೆನ್ನೆ ಇವತ್ತಿನ ಕೇಸಿಗೆ ನೆನ್ನೆ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೇಳ್ತಿದ್ದಾರೆ.
My request on next week.
ಕೇಳಿದಾರಂತೆ ಬಿಡಿ. 70.
71.
70 list after 2 weeks.
My lord, some date may kindly be given, my lord.
ನಿಮ್ದಲ್ಲ ಸರ್ 71 ನಿಮ್ದು.
71.
Wait. Yes, Ramesh.
My lord, may I request next week, my lord. AG will appear, my lord. They have filed replace.
71.
Please.
At the request of the learned AGA, list the matter on 18th.
Please.
Yes.
73.
72 ಏನಾಯ್ತು? Infractus close ಆಯ್ತು. Yes.
73 Abhinandan Hiremat.
Lords, it is an amendment application, my lords. Subsequent appointment during the pendency of the writ petition, my lords, I was made to challenge that, my lords.
What appointment, sir?
Lords, it is a promotion of Anganwadi helper to Anganwadi worker. Okay.
What happens?
Lords,
ಚಾಲೆಂಜ್ ಮಾಡಕ್ ಹೇಳಿದ್ನಲ್ಲ ತಾನೆ.
ಹೌದು.
And for the respondent.
The petitioner will allow the amendment. Order on IA, ಇದು ಬಂದಿದೆಯಾ ಅದು?
ಹೌದು ಬಂದಿದೆ.
ಎಲ್ಲಿದೆ?
Point number 2, my lords. Point number 2, it is an impleading application. Sorry, amendment application.
Order on IA 2 of 2025. For the reasons indicated in the affidavit accompanying the application and being satisfied with the same, the impleading application stands allowed the petitioner to amend the cause title. Emergent notice to the impleading applicant
It is
written.
already on record.
ನೀವೇ appear ಆಗ್ತಿದ್ದೀರಾ?
ಹೌದು.
Learned counsel so and so, already ಇದ್ದೀರಲ್ಲ?
ಹೌದು.
List the matter on 17th. Objections if any by the respondent by then. Next.
74, Shaila Bellikatti, Mrityunjay Tata Bangi.
Lordship, may I seek a short accommodation next week, any date, Your Lordship?
Filed the application for vacating in January.
Please.
Compromise, my lord, recorded before the Lok Adalat in 2010 is called in question by one of the beneficiary and her daughter, who is the wife of the plaintiff.
Please, my lord.
ಯಾಕೆ ಆಮೇಲೆ dispute arose between husband and wife, is it?
Please,
There is no
and,
dispute between
that
husband
was-
and wife.
What's the thing, problem?
Lord, subsequently, my lord, when the survey was sought to be conducted, based on that survey, my lord, since they say that there is a discrepancy in survey based on the compromise decree, that is a cause of action, my lord, to challenge the compromise decree.
Lordship, if Your
No,
Lordship
now
kindly
you tell
peruse.
me, if in the compromise, the petitioner has been given something less than what she was entitled to, what can be done?
Lord, it's a Lok Adalat decree. Unless she alleged, my lord, fraud.
ಎಷ್ಟು ಬಂದಿದೆ ನಿಮ್ಗೆ?
Lordship, the husband of the petitioner has got 1 acre, Your Lordship. But actually, if really survey is conducted, this house property in writ petition number 1, Your Lordship, that doesn't come in the respond number 1's property, Your Lordship. Your Lordship, ಅಂದ್ರೆ
ನಿಮಗೆ ಏನ್ ಬಂದಿದೆ?
ನಂದು ನನ್ನ ಹಸ್ಬೆಂಡ್ ಶೇರ್ ಎಲ್ಲಿ ಬರ್ತೈತೆ ಅಲ್ಲೇ ಇದೆ. ರಿಯಲಿ ಮೆಜರ್ಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಅದು ಬೇರೆ
ಅಲ್ಲಿ ಇಲ್ವೇ ಇಲ್ವಾ?
ಅಲ್ಲ, ನಮ್ಮ ಪ್ರಾಪರ್ಟಿಯಲ್ಲೇ ಬರುತ್ತೆ. ಅದನ್ನ ಅವರು ಕೊಟ್ಟಿಯಾಗಿ ರೆಡಿ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಡ್ಯೂರಿಂಗ್ ದ ಕೋವಿಡ್ ಪೀರಿಯಡ್ ದೇ ವಿಸಿಟೆಡ್ ದ ಸ್ಪಾಟ್ ಅಂಡ್ ನೋ ನೋಟಿಸ್ ವಾಸ್ ಇಶ್ಯೂಡ್ ಅಂಡ್
That is for
in view of a grant of order
2020 ಲಾಗಿರೋದಾ?
2010
ಅಂತ ಇದ್ದಾರೆ.
Compromise decree.
Compromise decree 2010. Execution in the year 2020 during the COVID period. At least notice could have been served upon me. ನನ್ನ ಮನೆ ಇದೆ and by way of a government order I have constructed a house.
ಅದು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಳ್ಳಿ.
Even that is an ancillary prayer, my lord, that can be adjudicated in the execution proceedings.
Let's the matter finally on 6th in
Please.
fresh matters. We'll
Please.
close it on that.
Obliged.
75, Sriharsha Nilopan, V. Muhammad Ali.
The matter pertains to, my lord, the appointment of administrator to the Waqf. My lord, during the subsistence of status quo order passed by this honorable court, your lordships may kindly see page 75. Pending consideration of my approval for scheme of administration, there was status quo order, para 5, my lord.
Status quo shall prevail.
Yes.
ನಂದು ತಂಗಿದೆ ಇದು. ಅಲ್ಲ.
Now the administrator has been appointed, my lord.
Notwithstanding this.
Notwithstanding, without approval of my scheme, my lord, can be remanded, your lordship. Yes, that's the.
Will allow it and send
Yes,
it
your
back. The petitioner is before this court seeking the following prayer. The very petitioner had approached, the very petitioner had approached this court in writ petition 173 of 2022, which comes to be disposed by the coordinate bench in terms of its order dated 18th March 2024. The 2024. The order passed by the coordinate bench reads as follows, page 73 to 75. The coordinate bench observes that the election, the coordinate bench directed the first respondent to take appropriate decision with an outer limit of 4 weeks. Until then, the status quo was set to prevail. Notwithstanding the status quo, the impugned action of appointment or constitution of a new managing committee has sprung, and therefore the petitioner is back at the doors of this court. In the light of the status quo being in operation for a period of 4 weeks and the impugned action being taken within the said period, the only consequence would be obliteration of these orders. 4 weeks ಮಾತ್ರ ತಾನೇ ಇದೆ status
4
quo?
weeks until consideration of my approval for scheme of administration, my lord.
Until ಅಂತ ಇದೆಯಾ ಇಲ್ಲಿ?
Yes, ಇದೆ.
Yeah.
In page 75.
4 weeks or until consideration of the claim of the petitioner under the scheme of administration. Therefore, in the light of the impugned action being taken during the subsistence of the order of status quo as directed by the coordinate bench, the only consequence would be that the impugned orders to be obliterated and the matter remitted back to the hands of
First respondent.
back to the hands of the first respondent to bear in mind the observations made in the court by the order in the coordinate bench and then take action in accordance with law. In that light, the petition deserves to succeed, albeit in part. The impugned so and so stands quashed. The matter is remitted back to the hands of the first respondent. The first respondent to redo the exercise, bearing in mind the observations made in the course of the order passed by the coordinate bench. So it's ordered accordingly.
Prayer number 2, my lord. Mandamus directing to consider my proposal for approval.
The first respondent shall, while reconsidering the issue, also consider the prayer 2 na yavudu?
Proposal of the petitioner.
Also consider any proposal submitted by the petitioners in strict consonance with law.
Yes. My that interlocutor application to implead me as one of the.
ನೀವು impleading?
Impleading account.
They are, my lord, members of the committee. I am representing the committee as a president.
ಅಲ್ಲ ಬೇಕಾ? ಜಗದೀಶ್ ಪಾಟೀಲ್ ಹರ್ಡ್ ಅಂತ ಎಲ್ಲ ಹೇಳ್ಬಿಟ್ಟು in the light of the disposal of the petition, the allowing of the impleading application would become unnecessary.
Yes, for an outer limit of like, otherwise they will not do it from 2020 to the same.
Action shall be taken within an outer limit of 12 weeks from the date of receipt of the copy of the order. 12 weeks.
Yes. 76.
Not necessary under your application is not recorded.
Further consideration.
Your application is not allowed.
ಯಾರು ನಾವದಕ್ಕೆ ಸರ್
ಚೈತನ್ಯಕ್ಕೆ
Lords, 77 Lord IPL.
76 ಇದು.
I'm sorry, 77. I'm sorry.
One moment, I'll come to 76. Termination sir ಇಲ್ಲಿ madam.
No, he's not there, my lords, and we haven't got instruction from the department in this case, my lords.
Interim order ಇದೆಯಾ?
Interim order is there, no?
Learned counsel M. Tirumalesh seeks 2 weeks time.
4 weeks time, my lords. It's a constitutional validity is challenged, my lords.
Seeks 4 weeks time to secure instructions, file statement of objections. List the matter on 27th November. 4 weeks. Yes.
77. Shiv Prasad Shantangoda.
For the petitioner, as per direction of this honorable court, on 12/9/2025, there is a direction to file the affidavit of the respective respondent number 1 and 2, my lords.
All right.
Affidavit is received, my lords, so I will file in the counter, my lords.
Now Lords, I may only point out that affidavit. I am the beneficiary of the acquisition. Lord, 1 minute, if Lords, give me. Lord, I am a beneficiary of the acquisition. Earlier, my Lords, there was a proposal by the Special Land Acquisition Officer to delete certain acquisition in my favor. That was challenged by us. And this honorable court, my Lord, observed that the question to delete or include vests with the state government to take a final call. In fact, no logical conclusion pursuant to the order of this honorable court, state government should have taken a decision. But unfortunately, KIDB, instead of government taking a decision, has issued one more notice. KIDB has taken a stand that the impugned order is inconsequential. It requires to be withdrawn. I'm in agreement. Not petition may be allowed. In fact, not. It is really inconsequential.
I don't know, Malad, how the Leonard Senior Counsel Malad is making that submission. Now, kindly say, Malad,
the board is not making this submission.
But board is going to do, and how are they saying, Malad? They are beneficiary, and they get a right.
Why
they
I'm
get a
saying
right only after final notification.
One second. They have filed an affidavit, Lord. They have filed an affidavit. Copy of has been served upon me. Paragraph.
They are not served on the petitioner, Malad.
Today you received, my lords, we will file the.
That affidavit, is it?
Please, my lords.
ಅದನ್ನೇ
That
ಹೇಳ್ತೀನಿ.
affidavit is, that
No,
affidavit,
no,
that
are you-
affidavit
are
is
you
not given to court.
affidavit that
That
is filed by the state?
State
No,
and
that affidavit,
The copy is.
The
affidavit,
copy is served upon us. Para 13, they say, my lord, impugned orders are inconsequential. It requires to be withdrawn. All that I was only bringing to lordship's notice so that what.
no,
lordships could-
kindly see the additional affidavit. No, kindly see the additional affidavit filed by the impleading applicant, my lord. It itself goes on to show how they are hand in glove. They themselves say on the ground of, so that there is no violation of principle of natural justice, notice has been issued, and 28(4) will be issued in consequence. Even before affidavit has been filed, the beneficiary is fully aware what is happening. No, this itself goes on to show, my lord, there's something else more than what meets the eye.
Beneficiary is controlling everything.
And my lord, kindly see that the affidavit, my lord, is not given to court, not given to the petitioner, but my lord, the beneficiary.
Today.
Beneficiary is fully aware.
One minute. Have you served the affidavit
No,
on
no,
them?
Not.
Copy is served.
ಯಾಕೆ ಅಪ್ರೂವಲ್ ಕೇಳಿದ್ದೀರಾ ಅವ್ರದ್ದು?
ಅಲ್ಲ ಏನಾದ್ರು ಕರೆಕ್ಷನ್ಸ್ ಇತ್ತಂದ್ರೆ ಮಾಡ್ಕೊಡ್ಲಿ ಅಂತ.
Approval is not biased.
ಮತ್ತೆ ಕೋರ್ಟ್ಗೆ ಕೊಟ್ಟಿಲ್ಲ ಯಾವುದು ಸರ್?
Today.
Advance copy they have served, my lord. Nothing. No, all that I was bringing to lordship's notice is, my lord, the KIDB now concedes that the impugned orders is inconsequential, requires to be withdrawn. No, anyway, my lord, I leave it to.
We'll take it tomorrow then.
Please.
Yes, tomorrow. ಇದೇ ಹಿಂಗ.
I will file with the memo.
List tomorrow and fresh matters list.
In the meanwhile, if my lord, the impleading applicant permits, the KIDB can serve a copy on me, my lord.
ಕೊಡಿ ಕಾಪಿ. Petitioner ಕೊಟ್ಟಿರೋ.
Yes, that's why, my lord.
Everyone know what you are doing except petitioner at the court.
Please.
Yes, list tomorrow.
But this is actually, my lord, it is by mistake they have issued it. That's all. They have issued it by mistake. That impugned order is issued by mistake.
All right. Let's see. Yes.
78, K. Patil, Chetan Manoli.
Great, please.
Madam, in this case, I filed an application to implead some of the officers. Madam.
Implead whom?
Implead deputy commissioner and.
Will allow the application. For the reasons indicated in the affidavit accompanying order on IA 2 of 2025. For the reasons indicated in the affidavit accompanying the application and being satisfied with the same, allowed petitioner to amend the cost title. The learned AGA is directed to accept notice for the respondents. Impleading ಆದ್ಮೇಲೆ ಏನಾಯ್ತು? ಎಷ್ಟಾಗುತ್ತೆ?
Proposed respondent numbers.
Impleading applicants 5 and 6. 5 or 6? 5 ಮಾತ್ರ. Impleading applicant number 5. Yes.
And notice to impleading respondent number 4, my lord, because Jilla Panchayat is there.
Emergent notice to the fourth respondent, Jilla Panchayat. Next, Chetan Manoli appear ಆಗ್ತಿರೋದು ಯಾರು?
KNNL, my lords. He appears for KNNL.
78 ಅಲ್ವಾ ಇದು?
78, my lords. KNNL he appears, Jilla Panchayat also.
ಆಯ್ತು. Learned AGA accepts notice. ಯಾರನ್ನ ಇಂಪ್ಲೀಡ್ ಮಾಡ್ತಿರೋದು ಈಗ?
Deputy Commissioner, Tahsildar and
Deputy Commissioner, Tahsildar, he will take
and
notice.
Assistant Commissioner, and Tahsildar and Assistant Commissioner.
For all of them, he will take
He
notice.
take notice, except Jilla Panchayat, my lord, I think Chief Executive Officer for Jilla Panchayat.
Newly impleaded applicants ಗೆ 5, 6, 7 AGA. ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಯಾವ್ದು ಯಾರು ನೋಡಿ ಅದಕ್ಕೆ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್. Yes, next.
79, Rajappa Budia.
79, it
It was
was
adopted with the petitioner, my lords.
Order to be listed.
Lord, this is one of the difficulty, my lords.
11.
House.
May make a.
What has happened is.
Why did it come today?
Like, there was kindly please to. At my request, my lords, the matter has been listed. Your lordship kindly please to direct me to deposit 10 crores, my lord. But at order sheet ಅಲ್ಲಿ 10 ಲಕ್ಷ ಅಂತ ಬಂದಿದೆ.
ಅಲ್ಲ 10 crores ಮಾಡಿಲ್ವಾ? On or before
10 ಲಕ್ಷ ಅಂತ ಬಂದಿದೆ. ಅಲ್ಲ ಅದು 10 ಕೋಟಿ ಅಂತ ಇರೋದು 10 ಲಕ್ಷ ಅಂತ ಬಂದಿದೆ ಆರ್ಡರ್ ಅದಕ್ಕೆ ಸ್ವಾಮಿ.
Order 10 lakhs. 10 lakhs ಆಗ್ಬಿಟ್ಟಿದೆ.
10 lakhs ಆಗ್ಬಿಟ್ಟಿದ್ಯಾ?
Plus DD for I have deposited.
ವರ್ಡ್ಸ್ ಅಲ್ಲೂ ಬರಿಬೇಕು ಅಂತ ಹೇಳೋದು. ಯಾರ್ದು ಇದು? AC.
My lord, sir.
On
May I make one request?
2025.
No, 10 lakhs is already deposited, my lord. I am supposed to deposit 9 crore 90 lakhs.
When?
Today itself, DD is ready.
In terms of the order dated 17/10/2025, this court directed deposit of 10 lakhs, which has inadvertently been printed as 10 crores, which has been inadvertently printed as 10 lakhs. The 10 lakhs is already deposited, and Learned Counsel Gurudev Gachinmat submits that 9 crore 90 lakhs would be deposited in the course of the day. The matter was directed to be listed on 1410. List the matter on 1710. Yes.
11.
1710. Yes.
1711.
1711. 1711.
Please.
Yes.
Cell number 80, Srinand Pachapure.
In this, I've been instructed to appear on behalf of respondent number 2. May I seek a week's accommodation? I'll file power, my lords.
2015, sir. What's the matter?
Milords, he was appointed as a warehouse manager, grade 2, milords. Milords, the goods which were came from the transit, milords, there is a due to storage of these goods, milords, and due to dryage, milords, there is difference in the amount to which, milords, has caused loss to the corporation. They initiate inquiry. Your lordship may see, milords, the first charge at annexure B1, and in the report, the charge which they have stated is totally different. Something other products inquiry is conducted. Mekkejola antare reportedly. Charge ali, milords, wheat and rice anta. Lordship may kindly take page 71.
Sheet, sir?
Please.
Where is the charge sheet?
Yes, milords. Your lordship put
time tomorrow.
18 milords.
Day after tomorrow.
Monday, please, day after tomorrow.
Please.
Day after tomorrow.
Please.
My lord, my name you deleted. K. Anand.
To delete the name of
K. Anand Kumar.
Anand Kumar and print the name of Shiraj Bullali.
Please.
Is appearing for the fourth
Second
respondent 2 to 4.
Please.
At his request, list day after tomorrow.
Please.
2015.
Please,
Next one.
please.
81, SN Rajendra.
Hearing for the petitioner. Petitioner is challenging, my lord, annexure P and my lord, annexure Y1, wherein, my lord, the claim of the petitioner with regard to, my lord, refixation of the pension at the rate of 50% of the last pay drawn, my lord. My lord, now the calculate, while making calculation, my lord, annexure Y1, my lord, your lordship may kindly take up ink page 89, my lord. Ink page 89. My lord, they have, my lord, they have now said that, my lord, the petitioner has worked only 26 years, 5 months, which made them, my lord, as a 53, 6 months, my lord. The calculation by which, my lord, last pay drawn, my lord, is 21,800. My lord, they have taken it as a 10,800 is the 50%. Now, for it, my lord, they have taken as 53% into divided by 66%, because, my lord, as per rule 291, my lord, the maximum service of the, my lord, employee should be 33 years for claiming maximum pension, my lord.
All right.
Now they have taken as.
ನೀವು ಜಾಯಿನ್ ಆಗಿದ್ದೆ ಯಾವಾಗ ಹೇಳಿ ಸರ್?
Please, my lord.
ಜಾಯಿನ್ ಆಗಿದ್ದೆ ಯಾವಾಗ ಡೇಟ್ ಹೇಳಿ?
Now join agit, my lord, 17/11/1976, my lord. I was appointed as
driver on daily wages.
Driver on a temporary basis.
Regularize ಆಗಿದೆ.
Regularized, my lord, as per the apex court judgment, my lord, 10 years, my lord, will complete on.
ಆಗಿದ್ದೆ ಯಾವಾಗ? Where is the order?
Agittu, they have passed ink page, my lord, 75, my lord.
My lord, annexure D.
Ink page 71.
ಒಂದು ನಿಮಿಷ ಡೇಟ್ಸ್ ಹೇಳಿ ಸರ್.
Annexure D.
Ink page 75, my lord.
Wait.
Annexure D.
Dates you should tell me.
Date.
Appointed on 17/11/1976.
Please, my lord.
Did you pass an order of regularization?
Please, my lord.
Oh, he
That
was
is-
dismissed from service, is it?
Later, his service was regularized on 2012/1999, my lord.
2012/1999.
1999. The order is at annexure D, page 18, my lord.
All right.
And he has retired on 2010-2016, my lord.
2010?
2016.
Ah.
He has served for the period of. My lord. He has served for the period of 36 years and 5 months, my lord.
Correct.
When he completes the service of 33 years, he is then only entitled for 50% of the pension, my lord.
36 ವರ್ಷ ಮುಗಿಸಿದ್ದಾರೆ ಅಂತ ಈಗ
ಅಲ್ಲ 36 ವರ್ಷ ಆಗಿಲ್ಲ, my lord.
ಮತ್ತೆ ಎಷ್ಟಾಗಿದೆ?
26 years, 5 months.
ಎಲ್ಲಿಂದ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದ್ರೆ?
From regularization, my lord. Date of
1190 ದಿಂದ calculation ಮಾಡಿದ್ದಾರೆ. My submission is that, my lord,
1190.
1190 1990 ದಿಂದ ಅವರು ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ ಡೇಟ್ ಆಫ್ ಜಾಯ್ನಿಂಗ್ ಅಂತ. My submission is that, my lord.
1990
ಹೌದು ಸರ್.
1990 ಯಾಕೆ?
My submission is that from 1986 they have to consider it.
1186.
ಹೌದು 1986 ದಿಂದ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರೆ my lord 10 years will be completed on 17/11/1986 my lord.
Where is
In
the
view
order?
of the government order my lord, your lordship may kindly take.
ಕ್ವಶನ್ ಕೇಳೋರು
Please, ma'am.
ಕ್ವಶನ್ ಕೇಳಿದ್ಮೇಲೆ ಆನ್ಸರ್ ಮಾಡಿ.
Please, ma'am.
ನೀವು ಆನ್ಸರ್ ಮಾಡಿದ್ಮೇಲೆ ನಾ ಕ್ವಶನ್ ಕೇಳಕ್ಕಾಗಲ್ಲ.
Please.
ಅದಕ್ಕೆ ವೇರ್ ಇಸ್ ದಿ ಆರ್ಡರ್ ಆಫ್ ರೆಗ್ಯುಲರೈಸೇಷನ್?
Annexure my lord R in page 75. 75. In page 75.
ನಿಮ್ಮ ಹೆಸರು
ಸದರಿ ದಿನಗೂಲಿ ನಾವು
ಸದರಿ ಬಿಡಿ, ನಿಮ್ಮ ಹೆಸರಲ್ಲಿದೆ ಹೇಳಿ ಸರ್.
ನಮ್ಮ ಹೆಸರು ಲಾಸ್ಟ್ ಇದೆ 5 MM ತಾರಿಹಾಳ್, ವಾಹನ ಚಾಲಕ. ಡೇಟ್ ದಿನಗೂಲಿ ಸೇವೆಗೆ ಹಾಜರಾದ ದಿನಾಂಕ 17/11/1976. And now your lordship may kindly take my lord annexure Q in page my lord 71 my lord, the government order, which says that my lord on completion of 10 years my lord, his their services has to be regularized, by which my lord the date of my lord regularization would be 17/11/1986.
So, is anything else?
My lord.
Anything else?
My lord, annexure D may kindly be seen, my lord. The regularization is from 1/1/1990, my lord. Calculating from the date of regularization till the superannuation, my lord, the petitioner has served for the year of 26 years and 5 months, my lord. He is entitled for 43% of the salary last drawn, my lord. Calculating that, he is getting the pension of 8,670. Please, my lord.
Calculation, madam.
Which is proper. There is no.
Proper.
Allah.
Correct, irli.
My lord, as per KCSR rules.
ಕರೆಕ್ಟ್ ಆಗಿದೆಯಾ?
Correct ಆಗಿದೆ.
ಏನ್ ಮೇಡಮ್ ನೀವು ಹಂಗೆ ಅನ್ಬಿಟ್ರಿ?
The salary loss.
Petitioner.
One more submission.
No more submission. No more submission.
In ಬೇರೆ ಪ್ರೇಯರು ಇದಾವೆ, ಬೇರೆ ಪ್ರೇಯರು ಇದಾವೆ with regard to promotion, my lord.
ಅದಾದ್ಮೇಲೆ
Promotion, my lord. My lord, I was my lord promoted as my lord junior sanitary inspector in the year 2001, my lord, on 6/2/2001 annexure W, my lord, in page 80. My lord, the cadre and recruitment rules, my lord, requires for the post of promotion of senior sanitary inspector 3 years has to be worked as a junior sanitary inspector and has also to pass a departmental exam. My lord, I have passed my departmental examination in the year 2007, my lord. Thereby, my lord, I have become eligible for the consideration of my case for the post of my lord, the senior sanitary inspector. Therefore, I made a representation as per annexure A, B, C, my lord. My lord, in spite of making those representation, my lord, my cases were not considered. Therefore, my lord, after continuous, my lord, request, as per annexure L, they have given an endorsement saying that, my lord, since you have not produced the certificates of passing the departmental exam, your case has not been considered. I approached this honorable court, my lord, and this honorable court has allowed the writ petition and thereby set aside the, my lord, that impugned order and directed them to reconsider. My lord, now as per annexure P, now they have again rejected on the different ground, saying that, my lord, you have not filed any objection to the seniority lists which were prepared. My lord, since you have not raised any objection, therefore your case has not been considered. My lord, even that fact has also been, my lord, wrong.
HDMC na?
SDMs.
ಇಲ್ಲಾಗದೇ ಇದು. Yes.
And moreover.
You treat your employees like chattels. That's the whole problem. ನೀವು ಯಾರು ಇಂಪ್ರೂವ್ ಆದ್ರೆ ನೀವು ಆಗಲ್ಲ. ಎಲ್ಲಾದ್ರಲ್ಲೂ ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡಿದ್ರೆ ಮಾತ್ರ ಆಗಲ್ಲ.
ಆಮೇಲೆ my lord, the HDMC is not appointing authority, my lord. That is the state.
State is supporting you.
Please, your lordship. Your lordship, as annexure P, your lordship, which discloses the entire amount, your lordship, which as per the KCSR rules, it was fixed, your lordship.
Oh, he has taken it, but his claim is regularization from 1/1/1986.
90.
It is calculated from 1/1/1990 itself, my lord.
ಅದೇ ತಪ್ಪು. ಅದೇ ತಪ್ಪು. Dharwad district judgment prakara, if you see the government order dated 1/1/1990, those who have completed 10 years of service from the date of their initial employment ಅವತ್ತಿಂದ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಬೇಕು.
But
That is the judgment of the apex court. In terms of that, you have issued the government order.
from the date of regularization, his service will
problem.
be considered, Your Lordship.
1186 ಇಂದ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರೆ ಪೆನ್ಷನ್ ಸಿಗುತ್ತಲ್ಲ.
248A ಕೆಳಗಡೆ 3 years maximum benefit ಕೊಡ್ಬೇಕು ಅಂತ ಇದೆ. Thereby my lord 33 years complete
ಆಗುತ್ತೆ.
33 complete ಆಗುತ್ತೆ.
And my lord, in between they were terminated, my lord. They were
ಅದೆಲ್ಲ
that
set
is set
aside
aside
ಆಗಿ
ಆಗಿದೆಯಲ್ಲ.
reinstate ಆಗಿ back wages ಕೊಟ್ಟು ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಲ್ಲ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಎಲ್ಲ
If Your Lordship, on the order of the court, Your Lordship, after setting aside the court's order, if he joined, Your Lordship, that will not be considered, Your Lordship.
No, but reinstatement with continuity of service ಕೊಟ್ಟಿದ್ರೆ it will. Back wages ಕೊಟ್ಮೇಲೆ continuity of service ಕೊಟ್ಟಿರ್ಬೇಕು. Otherwise it won't be at all.
But only on the order of the court.
Issue looks complicated, ಇಷ್ಟೇನೆ. Jugglery of dates, nothing else. ಇವ್ರು ಹೇಳಿದ್ರೆ ಮತ್ತೆ ಇನ್ನೂ ಸ್ವಲ್ಪ ಕಾಂಪ್ಲಿಕೇಟ್ ಮಾಡ್ಬಿಡ್ತಾರೆ. Yes. The petitioners.
ಆಮೇಲೆ ಇನ್ನೊಂದು ಪ್ರೇಯರ್ ಇದೆ. 10 years time bond scale ಕೊಡ್ಬೇಕಾಗಿತ್ತು. 2001 ಕ್ಕೆ I was promoted as a junior sanitary inspector.
ಅದಕ್ಕೆ ಡಿಸ್ಪೋಸ್ ಆಗಿಲ್ಲ ಇದು ಇಲ್ಲಿವರೆಗೆ.
ಅಲ್ಲ, 3 ಪ್ರೇಯರ್ ಇದೆ. If I am allowed, my consider for promotion, then I am not entitled for that prayer. That is what I, please.
As simple as that.
Yes. Yes.
ನೀವು ಟೈಮ್ ಬೌಂಡು ಬೇಕು, ಪ್ರಮೋಷನ್
ಅಲ್ಲ, ಪ್ರಮೋಷನ್ ಕನ್ಸಿಡರ್ ಆದ್ರೆ ಇದು
ಮತ್ತೆ ಏನ್ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀರಾ? Yes. The petitioner is before this court seeking the following prayer. Heard so and so. What's your name?
Pranav.
Heard the learned counsel, so on appearing for the petitioner, counsel Pranav and Srimati Girija Hirimat. The learned, the petitioner, facts in brief germane are as follows. The petitioner is appointed as a driver on daily wages in the L appoint agidda?
Corporation.
Avagel corporation it. In the erstwhile Hubli, in the Hubli Dharwad Municipal Corporation.
Driver in horticulture department, my lord.
The petitioner was initially appointed as a driver in horticulture department of the respondent corporation on 17/11/1996. The 1976. The petitioner during his service, owing to certain omission and commission, had been dismissed in terms of an order dated 17/5/1984. The order of dismissal, the penalty of dismissal was challenged before the industrial tribunal, and the industrial tribunal had set aside the dismissal of the petitioner with a direction for reinstatement, continuity of service and back wages. The said order was challenged by the respondent before this court, and the back wages was reduced to 50%. The other directions issued by the tribunal stood affirmed. Therefore, the petitioner was taken back into service with continuity of service. The petitioner then retires on attaining the age of superannuation on 20th October 2016. The issue is with regard to fixation of pension of the petitioner. The petitioner represents to the respondent claiming several benefits: promotion, refixation of pension, and time-bound scale. The non-consideration or rejection of the claim of the petitioner is what has driven the petitioner to this court in the subject petition. The learned counsel Rajendra, appearing for the petitioner, would vehemently contend that the petitioner ought to have been regularized from the date on which he completed 10 years of service, which would be on 16/11/1986, with effect from 1/1/1986, as is done in the case of every other daily wage employee. If the regularization date is taken back to 1/1/1986, he would get 30 years of service. And in terms of section 248A, rule 248A of the KCSR, a person who is working on daily wages is absorbed or regularized, he would get 3 years addition to qualifying service. Therefore, it would take his service to 33 years. And if 33 years is the service, he would get full pension, is the submission of the learned counsel appearing for the petitioner. Apart from the said claim, the petitioner also has represented for grant of promotion from sanitary inspector to senior
sanitary inspector.
ಸುಮ್ನೆ ಇದ್ರೆ ನಾನು ಬರಿತೀನಿ. Sanitary inspector to senior sanitary inspector. The said representation has also gone unheeded, and the learned counsel submits that he is entitled to all the relief that is sought at the hands of this court. Per contra, Pranav hakla or dakla?
Sir, RH.
Per contra, learned counsel Gurudev Chinmata.
RH Angadi.
Learned RH Angadi.
Please.
Per contra, the learned counsel R.H. Angadi, appearing for the respondent corporation, would vehemently refute the submission in contending that the date of regularization of the petitioner is taken as 1/1/1990, which is appropriate, and taking the service of the petitioner as 1/1/1990, the petitioner would get 26 years and 6 months of service from as on the date of his retirement. Therefore, pension is fixed accordingly. There is no warrant of interference, is the submission of the learned counsel for the petitioner. Insofar as the claim for promotion is concerned, the learned counsel submits that he had not passed the departmental examinations, requisite departmental examinations. Therefore, the claim for promotion was also not considered. The learned, he would seek dismissal of the petition. The learned HCGP would also toe the lines of the learned counsel appearing for the respondent corporation in contending that the regularization of the petitioner has been accepted by him.
It is not in dispute, Your Lordship, as on date, after 10 years, his regularization has been done, Your Lordship.
The learned
From the
counsel
date
would
of
submit that the
regularization is to be
regularization of the
considered.
petitioner has come about correctly after 10 years of service, and therefore there is no warrant of interference for change of the date of regularization.
From
All
the
the
date of
consequent.
regularization is may be considered. From the date of regularization, it may be considered.
Yeah, warrant, there is no warrant from the date of, there is no warrant to change the date of regularization. And the service of the petitioner should be considered only from the date of regularization, which is appropriately considered, and pension is fixed. Therefore, the petitioner is not entitled to any of the relief that is sought at the hands of this court. She would also seek dismissal of the subject petition. I have given my anxious notes, therefore narrated sounds. The issue is with regard to entitlement of the petitioner for seeking 33 years of seeking pension on complete year of seeking pension on completion of 33 years of service, for which the link in the chain of events and the dates are required to be noticed. The petitioner joins the service of the Department of Horticulture in the Hubli Dharwad Municipal Corporation on 17/11/1976. 1976. His regularization comes about with effect from 1/1/1990. As contended by the petitioner had completed 10 years of service on 16/11/1986. In the interregnum, certain developments take place. The petitioner, owing to certain allegations, had been proceeded with departmentally, and a penalty of dismissal from service was imposed. This was challenged before the industrial tribunal, and the admitted fact is that the industrial tribunal had set aside the order of dismissal, directing a reinstatement with 100% back wages. This is challenged by the corporation before this court. This court, the learned single judge of this court modifies the back wages portion of the award by reducing it to 50% while sustaining all the other reliefs. The other relief that was granted was reinstatement with continuity of service. These are admitted facts. The reinstatement with continuity of service would mean that the petitioner has been in continuous service from 17/11/1976 without any break. Therefore, 10 years of service must be calculated in, how the 10 years should be calculated from of a daily wage employee is borne out from the government orders issued pursuant to the order passed by the apex court in Dharwad district. The government order is clear that the date on which the employee would, the daily wager would complete 10 years of service would be the date on which the regularization must ensue. In the case at hand, the petitioner has completed 10 years of service as on 1986. Therefore, the regularization date ought to have been from 1/1/1986, as is done in every case of the regularized employees pursuant to the direction of the apex court in the case of Dharwad district so and so. The petitioner's date of regularization being taken as 1/1/1990 is the error that has crept in at the foundation. In that light, the petitioner becomes entitled to the date of regularization to be 1/1/1986 and not 1/1/1990. Thus comes in 4 years of service to the qualifying service of the petitioner, which takes his service to beyond 30 years. Even then, the petitioner would not be entitled to complete pension on completion of 33 years of service. In such circumstances, Rule 248A would become applicable. Rule 248A of the KCSR reads as follows. Rule 248A permits qualifying service to be added to a daily wage employee unless he is on work charge establishment for a period that would not exceed 33 years. Since the petitioner has now got 30 years of service with the altered date of regularization, what the petitioner would be entitled to under 248A would be only 3 years of service. As the qualifying service by any method of addition cannot go beyond 33 years. Therefore, the petitioner becomes entitled to addition of 3 years to the said qualifying service, which takes his service to 33 years. The petitioner thus becomes entitled to pension on calculation of complete service rendered by him, which would be 33 years. The pension should be calculated accordingly in terms of law. The other relief that is sought by the petitioner is consideration of his promotion to the post of senior sanitary inspector from the cadre of sanitary inspector. Where is Rule Cell?
My lord, in page 77. 77, my lord. 76. Must have put in.
The rules that govern such promotion reads as follows. Page 76. For promotion from the cadre of junior health inspector to the cadre of senior health inspector, a junior health inspector must have put in not less than 3 years of service. The petitioner was promoted, junior health inspector
2001. 6 to 2001.
Is said to have been promoted to the cadre of junior health inspector with effect from 6 to 2001. Therefore, the petitioner would become entitled for consideration of his case for senior health inspector from 2004. The petitioner during his service has submitted plethora of representations seeking promotion to the cadre of senior health inspector. Those have been turned down on the score that he has not passed the departmental examinations. The learned counsel for the petitioner has placed on record that the department that the petitioner has cleared all the departmental examinations and therefore he is entitled to the cadre of senior health inspector. This submission on a perusal at the documents appended to the petition is merits acceptance. Therefore, the respondent corporation must now consider the case of the petitioner for promotion to the post of senior health inspector, as he had registered his entitlement by way of representations both in the year 2007 and 2011, well before his retirement on attaining the age of superannuation. Those have gone unheeded or rejected contrary to law. Therefore, they would merit reconsideration, bearing in mind the observations made in the course of the order. For the aforesaid reasons, the following order. The writ petition is allowed, so and so stands quashed. The date of regularization of the petitioner is now declared as 1/1/1986, as is done in the case of every employee who who was regularized pursuant to the orders of the apex court in Dharwad district, ಅದು ಕೊಡ್ತೀನಿ. So and so. The petitioner shall be entitled to addition to qualifying service in consonance with Rule 248A of the KCSR. The respondent shall now calculate the qualifying service in terms of the observations made in the course of the order and refix the pension of the petitioner. And the respondents shall also consider the representation of the petitioner submitted seeking promotion to the post of senior health inspector, all in an outer limit of 12 weeks from the date of receipt of the copy of the order, and pass necessary orders refixing the consequential benefits that would flow from the subject order, ordered accordingly.
Appearing for petitioner without conducting any inquiry and without dispensing with the
Yes,
inquiry,
come, sir.
punishments
That
are
your
to be
lordship
passed.
in impugned order annexure L, your lordship.
Disability.
Disability.
Even your lordship as per annexure L, only submission that even the notice was issued to the petitioner, he has not appeared. That is my only.
Yen penalty?
Not penalty denying treating the period of absence, that is 143 days as absent only. And denying the gratuity for that period. There are 7 onwards, my lord.
We'll close it.
Annexure L, your lordship, for a moment, your lordship, what your lordship, I am not disputing the
There are 7
order.
onwards.
ಎಲ್ಲಿದೆ ಪ್ಯಾರಾ 7 ಇಲ್ಲಿ?
In page 6.
ಮೈನರ್ ಏನ್ ಪೆನಾಲ್ಟಿ ಇಂಪೋಸ್ ಮಾಡಿರೋದು?
That your lordship, 148 days, your lordship, no salary, that is the.
ಅಷ್ಟೇನಾ?
Denying gratuity for that period.
Because lordship in the annexure L, it was referred.
Okay, Bharadwaj, consider ಮಾಡಿದ್ದಾರೆ ಬಿಡಿ.
All judgments have been considered.
The petitioner is before this court seeking the following prayer. The issue in the list, the issue in the list revolves around the imposition of penalty of recovery now?
Illa. From 11120.
Issue in the list revolves around denial of salary, is it?
Salary and gratuity.
Denial of salary and gratuity for a period of 148 days.
43 days.
43 days. The learned counsel, MM Kannur submits that no inquiry was necessary to be conducted in the light of the penalty being depicted as a minor penalty under the regulations. Notice issue madilva?
Madidare, but he has not appeared.
Notice was issued for appearance before the competent authority. The petitioner, though in receipt of notice, failed to appear before the authority. Therefore, the respondent left with no choice had to impose the said penalty. And therefore impose said penalty. The learned counsel would submit that the petitioner cannot now project that he was no inquiry was conducted prior to the imposition of the aforesaid penalty. The learned counsel for the petitioner submits that the issue in the list stands completely answered in identical circumstances by the coordinate bench in terms of the order dated 12th September 2025, wherein the coordinate bench, considering the entire spectrum of the law, has held as follows from para 7-2. And in the light of the issue being completely answered by the coordinate bench and notwithstanding the vehement opposition of MM Kannur, I deem it appropriate to follow the same and pass the same order, that is grant the same relief that is granted by the coordinate bench in the cases of in those cases, in this case as well. Allot cost same.
Please. Time frame, Lord.
ಅಲ್ಲೇನ್ ಕೊಟ್ಟಿಲ್ವಲ್ಲ?
ಅಲ್ಲ ಇದ್ರ
Actually, ವಾಪಸ್ ಕಳಿಸ್ಬೇಕು inquiry ಮಾಡಕ್ಕೆ. If that is the ground on which it is set aside, you have to send it back for inquiry.
Remanded the matter, your lordship.
Notes for this reason, page number 17 of that judgment, Lord's my request. Not, for last 5 years, they are passing the similar orders. Therefore, the coordinate bench has refused to remand back. Yes, grateful.
83, Ravi in Chekkarade and DM Bandi.
2 weeks time back, kindly. 2 weeks time back, I'll file my objections. I'm for respondent.
Learned counsel Dayan Bandi seeks 2 weeks time to file statement of objection. We'll list on 18 objections, if any, by then. Next.
84.
84. No request on-
5 of DNS 2023. The case of the prosecution is that
ಯಾವ ಕೋರ್ಟ್ ಕನೆಕ್ಟ್ ಆಗಿದೆ ಮೇಡಮ್?
that some information dated 4/2025.
Srinivas.
Sixth, my lord. Senior is engaged in this matter.
These are the matters, my lord. Yesterday, your lordship had, my lord,
Dispose
disposed of the
ಮಾಡಲ್ಲ
matter.
ಅಷ್ಟೇ.
The 70 ಕೆಳಗಡೆ dispute has to be raised.
ಅದರಲ್ಲಿ
Elections were already held and my lord,
serious
23
allegations against the returning officer.
23
Despite there being orders from the,
ಅಲ್ಲೇ
Allah, to video record the entire lord election process. He has not done it. Lord, complaints are filed to the superintendent of police. He has not initiated any action. And lord, society has come before this court stating that writ petition has to be allowed. Statement of objections is filed by the lord society.
My request is,
Lord, your lordship may kindly see, lord, it is lord
List on
case
six-
covered by lord where
sixth
Supreme
and
Court
fresh
says.
matters list.
Sixth,
As a-
lord,
as a last chance.
please.
It is made clear no further adjournment would be granted in the matter.
Supreme Court, lord, categorically in Chandigarh mayor election.
What
Lord,
is,
yes, 2024, lord, I'll just pass.
what do you call? Yes. File reading.
Please.
Please.
85 case.
Sixth.
Lords, the petitioner was working for KHDC, my lords, and he retired on 31/7/2020. And prior to 2 months from the retirement, the order was passed at annexure A, deducting the 80,000 from the terminal benefits of the
Oh, ಇದು
petitioner.
without enquiry.
in the last occasion, I requested, my lords.
Allow
to-
ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ.
ಹೌದು.
ಮಾಡ್ಲಾ?
Lords, my only submission, lords, with respect, ಇದು ಒಂದು liberty court, because we will initiate, my lords, in accordance with law, whatever against him.
ಯಾವಾಗ ರಿಟೈರ್ ಆಗಿರೋದು ಯಾವಾಗ?
31/7/2020.
2020.
Yes.
ಈಗ ಯಾಕೆ ಕಾಟ ಕೊಡ್ತೀರಾ?
That is the only submission of mine.
Yes, what's on merit ಏನು ಮೇಡಮ್?
It's, my lords, the amount was deducted.
Amount was
For that.
deducted, but you have nothing to do with that, is it?
No, my lords, no notice was issued, no inquiry is conducted.
Hmm.
And the reason is regarding, he has not taken a sanction from the managing director to convert the clothes from 15,000 meters of printed clothes
Hmm.
from bed to the bed sheets and pillow covers.
But
That
he
is
has
the
taken,
only-
is it?
Please, my lords.
He has taken sanction?
He has, proposal was sent to him, but it was returned without endorsements.
It
So
was
he
not
thought
grant-
it is
It was not
permitted.
granted by the higher authorities, ಅನ್ನೋದು ನಮ್ಮ point.
Without any endorsement, it was
The
returned with the
petitioner
signature.
is before this court, calling in question the action of the respondent Hubli Karnataka Handloom Development Corporation, by which an amount of 80,000 has been recovered from the salary of the petitioner by way of 4 monthly installments of 20,000 each, commencing from April 2020 till the date of his retirement. Heard the learned counsel Srimati Padmaja Thadpatri appearing for the petitioner and the learned counsel also representing the respondent. The facts in brief germane are as follows. What's your name?
Lords, Prakash.
ಅವ್ರ ನಿಮ್ದೇ ಹಾಕ್ಲಾ?
ಅವ್ರದ್ದು.
ಗುರುದೇವ್.
ಪ್ರಕಾಶ್ ಅಂದಾನಿ madam.
ಪ್ರಕಾಶ್ ಅಂದಾನಿ.
ಪ್ರಕಾಶ್ ಅಂದಾನಿ.
ಅವ್ರ ಹೆಸರು ಹಾಕಿ. The petitioner, the service particulars of the petitioner need not be narrated in the case at hand as they are not germane. It would suffice if the narration would commence from the date on which the impugned order is passed. It would suffice if the narration would be from the year 2018 when 2018, i.e. on 25/9/2018, when the petitioner submitted a proposal to the managing director of the corporation through the controller of accounts to convert 15,000 meters of printed cloth into bed sheet and pillow covers at approved old rates of stitching and stitching charges. The managing director is said to have written a remark on the proposal to proposal, quote unquote, please discuss. And accordingly, the file was returned to the controller of accounts. The controller of accounts, without writing any remark thereon, is said to have put his signature and returned the file to the petitioner. The petitioner was not aware of the order of the managing director, which had observed the aforesaid please discuss remark. And therefore, the petitioner went forward and converted the printed bed sheets and pillow covers as was proposed. This happens in the year 2018. The audit objections appear to have cropped up later, which led to recovery of the amount of rupees 80,000 from the salary of the petitioner. 80,000 was not recovered at one stroke, but by equal monthly installments of rupees 20,000. The issue is whether such recovery could be made without even issuing a notice to the petitioner. The admittedly, recovery of money does have economic and penal consequences upon the petitioner, and the recovery of money is also recovery from salary is also a specific penalty under the rules. In that light, they said recovery could not have been made at the outset in compliance with the principles of natural justice in the least. Notice ಕೊಟ್ಟಿಲ್ಲ ಅಲ್ಲ ಅವ್ರಿಗೆ?
No.
In the least, or an inquiry to be conducted in the event the petitioner would dispute his claim. On the sole reason that the petitioner is robbed off his salary without even issuing a notice, the order impugned would be rendered unsustainable. The unsustainability of the order would lead to its obliteration. Even otherwise, for an inquiry for recovery from salary to be made, though it is a minor penalty, if the employee would dispute it, an inquiry must ensue. Is the law laid down by the apex court in the case of OK Bharadwaj versus Union of India, 2001 9 SCC page 180. In the light of the law being clear and the issue and the imposition or taking away of the salary of the petitioner being in gross violation of principles of natural justice, the natural consequence would be the petition. The natural consequences would be the success of the petition. In that light, the petition deserves to succeed with a direction to the quashment of the order and with a direction to the respondent to reimburse the amount that is withdrawn from the salary of the petitioner. Interest ಬೇಡ ಯಾಕಂದ್ರೆ ಎನ್ಕ್ವೈರಿ ಮಾಡಬೇಕು.
Quashing of annexure A and F.
ಏನ್ ಹೇಳಿದ್ರಿ?
ಅದೇ with seeking the liberty to initiate whatever in accordance with
the learned counsel appearing for the respondent would submit that though the inquiry is though notice was issued and the recovery is made, they are now seeking liberty to issue notice and effect the recovery or take action in accordance with law. The petitioner has retired on attaining the age of superannuation in the year 2020. The issue is as narrated herein above. In that light, since the petitioner has retired from service to give a quietus to the issue, I deem it appropriate not to permit the respondents not to reserve liberty to the respondents to initiate any proceedings. The only relief that the respondents could get at this juncture is denial of interest for the refund of the amount as is the refund of them for the aforesaid reasons. The following order: petition is allowed so and so quashed. The respondents are directed to reimburse or / refund the amount of 80,000 to the hands of the petitioner with an outer limit of 4 weeks from the date of receipt of the copy of the order. In the event the amount is not reimbursed or refunded within 4 weeks from the date of receipt of the copy of the order, the petitioner would become entitled to interest at 6% per annum till the date it is paid, and till the date is paid. Order.
Six scale party.
Pensionary benefits, my lord,
Not paid?
not paid.
Why?
Their claim is that there was criminal case pending against me.
Acquit agidira?
Not, it is quashed. I have produced the copy also.
That's the only reason?
That's the only reason which is mentioned in the
Hubli
statement.
Dharwad,
House Corporation. Statement of objections also, they claim that their criminal case is pending, which is quashed by this honorable court. I have produced the copy.
When was it quashed, sir?
Very recently, my lord. On 30th August 2025, produced the copy along with this on 17/10/2025.
Month of August, my lords.
ಈಗ ಯಾವಾಗ ರಿಲೀಸ್ ಮಾಡ್ತೀರಾ?
My lords, there is a civil suits are pending, my lord, before.
Civil suit?
Please, my lord, for recovery suits, my lord.
ಯಾವ recovery suits?
There is a misappropriation conducted by this petitioner, my lord.
Department enquiry ಮಾಡಿದ್ರಾ?
Departmental inquiry is
Conducted
quashed
by lord.
thrice.
ಈಗ
There is no departmental inquiry remain now.
ಎಷ್ಟು ಬರ್ಬೇಕು ನಿಮ್ಗೆ?
Only provisional pension is granted, pension fix ಮಾಡಿ.
Pension and other terminal benefits ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ.
ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಸರ್?
According to rule 214A, my lords, there is a.
According to 214A ಏನಿದೆ ಸರ್?
Judicial proceedings are
Judicial
pending.
proceedings is only criminal proceedings, sir. ಅಲ್ಲಿ definition ಇದೆ what is judicial proceeding ಅಂತ. Not civil suits instituted by you. ಆ ತರ civil suit ಹಾಕ್ಬಿಟ್ಟು ಎಲ್ಲಾರನ್ನೂ ಮನೆ ಕಳಿಸ್ಬಿಡ್ತೀರಾ ನೀವು? Judicial proceeding ಅಂದ್ರೆ ಏನು ಅಂತ definition ಇದೆ 214, see there. Yes.
And statement of objection also, they mention only this criminal case pendency.
ನೀವೇ ಮಾಡ್ತೀರಾ ಇಲ್ಲ ನಾನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಸ್ವಲ್ಪ ಎಂಬೆಲಿಶ್ಮೆಂಟ್ಸ್ ಆಗುತ್ತೆ ಅದಕ್ಕೆ, ಕಾಸ್ಟು ಇಂಟ್ರೆಸ್ಟು ಅದೆಲ್ಲ ನೀವೇ ಕೊಟ್ಬಿಟ್ರೆ ತೊಂದರೆ ಇಲ್ಲ. 10 days ಟೈಮ್ ಕೊಡ್ತೀನಿ, ಅಷ್ಟ್ರಲ್ಲಿ ರಿಲೀಸ್ ಮಾಡಿದ್ರೆ ಓಕೆ, ಇಲ್ಲ ಅಂದ್ರೆ ಯು ವಿಲ್ ಗೆಟ್ ಅ ವೆರಿ ಹಾರ್ಶ್ ಆರ್ಡರ್.
Please. With respect to that point, my lords will ಅವ್ರ ಜೊತೆ
ವಿಚ್ ಪಾಯಿಂಟ್ ಸರ್?
ಅದೇ 10 days ಅಲ್ಲಿ ಕೊಡೋದ್ರ ಬಗ್ಗೆ ಸ್ವಲ್ಪ ಕ್ಲಾರಿಫಿಕೇಶನ್ಸ್ ತಗೊಂಡು
ನಾನು ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ, ನೀವೇ ಕ್ಲಾರಿಫಿಕೇಶನ್ ತಗೊಂತೀರ? I need not wait for clarification to pass an order. The petitioner is before this court seeking release of his terminal benefits. On the score that the petition against the petitioner, there were departmental proceedings and criminal proceedings. Pension of the petitioner on his retirement on attaining the age of superannuation was not settled, although provisional pension was paid. The proceedings against the petitioner departmental have all been ended in exoneration. This is an admitted fact. Even then, pension was not paid on taking recourse to the words judicial proceeding in Rule 214 of the case of the KCSR. The judicial proceeding pending was a criminal case, which is also quashed, which is quashed by the coordinate bench of this court. Therefore, the projection of impediments for release of complete terminal benefits of the petitioner have today vanished. The HDMC has now come up with a new plea that certain civil suits are filed against the employee seeking recovery of money, as there was allegation of misappropriation of funds. On the very same set of facts, two judicial proceedings had, one quasi-judicial proceeding and another judicial proceeding had sprung. The quasi-judicial proceeding has ended in the exoneration. The judicial proceeding has ended in its quashment. Therefore, the pendency of the civil suits cannot and shall not be an impediment for release of terminal benefits of the petitioner. Retire agide yavaga?
28/2/2023.
The petitioner has retired
2.5 years. 2 years, 8 months.
2 years, 8 months ago, and has not been paid any pension. Therefore, I deem it appropriate to grant 2 weeks' time to the respondent, Hubli Dharwad Municipal Corporation, to release the terminal benefits that is accrued in favor of the petitioner. In the event the respondents would not, as they have no justification to withhold today, the costs of litigation and interest on release of terminal benefits would ensue. List the matter. on 19th.
Published.
87, 50 case. Shivraj Hiriyama.
Dismissed from service, my lords, and Narega scheme, my lords. Last date of hearing, my lords.
Contracts are Narega scheme will dismiss.
All, my lords. That's project.
87.
That project itself is not been implemented, my lords. I have produced photograph before, my lords. Annexure F1.
Project photograph ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತಾ?
Of Shirgupa village, my lords.
Yes.
I filed my objection.
ಅಷ್ಟೇ ಏನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ.
Sorry.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಏನಿಲ್ವೇ?
No, my lord.
No.
My kind submission.
Huh.
My kind submission is that, my lord, he is a outsource employee, my lord. My lord, 1 year after the, by taking into consideration of their.
ನಾವು reinstate ಮಾಡ್ತಾ ಹೋಗ್ಬಿಟ್ರೆ.
ಅಲ್ಲ my lords, ಅಲ್ಲಿ in para 9, my lords of my lordship.
Stigma ಏನಾರು ಇದ್ರೆ I will expunge all the stigma.
ಅಲ್ಲ on which ground of misconduct, my lords, that project itself, my lords, is not implemented, my lords. That is my role, my lords, is.
ನೀವು ಎಷ್ಟು ವರ್ಷಕ್ಕೆ ಅಪಾಯಿಂಟ್ ಆಗಿತ್ತು ಸರ್?
2019.
ಎಷ್ಟು ವರ್ಷಕ್ಕೆ?
1 year.
1 year. ಲಾಂಗ್ ಬ್ಯಾಕ್ ಆಗೋದು.
From that
ಇದನ್ನ reinstatement ಎಲ್ಲ ಮಾಡ್ಕೊಂಡು ಕೂತ್ಕೊಳ್ಳೋಕೆ.
At least ಅವ್ರು reconsider ಮಾಡಿದ್ರೆ,
reconsider
I will produce.
Reappoint ಮಾಡಕ್ ಬೇಕಾದ್ರೆ I will direct without being influenced by whatever observation is.
Please, my lords.
I will not reinstate or something.
Please, my lords, reconsider.
The petitioner is before this court seeking the following prayer. The petition heard sounds. The petitioner is appointed on 7/6/2019 as a barefoot technician. You barefoot le idra purti?
Please.
Yes. Barefoot technician under the Narega scheme on the element.
Narega scheme.
So the appointment was for a period of 1 year. He is terminated prior to the expiry of 1 year. 1 year ಆದ್ಮೇಲೆ ಮಾಡಿದ ಮುಂಚೆನಾ?
ಇಲ್ಲ 1 year ಆದ್ಮೇಲೆ 2019 I appointed, my lords.
ಅಲ್ಲ ಆಯ್ತು, terminate ಮಾಡಿದ್ದೆ ಯಾವಾಗ?
2023, my lords.
The petitioner, after working about 4 years, has been terminated on account of certain misconduct. The learned counsel for the petitioner submits that the respondents did not conduct any inquiry or issue notice prior to the termination on account of misconduct, and therefore has caused serious prejudice to the future of the petitioner. The appointment of the petitioner admittedly was for a period of 1 year in terms of the order of appointment dated 7/6/2019. The contract has ended and no order directing inquiry or reinstatement into the post would ensue in the case at hand. The only order that could be passed in favor of the petitioner is that the petitioner, if has to be taken back by the respondents to the service of the same post, the observations in the impugned order will not come in the way, or the misconduct will not come in the way. Therefore, the observation petition stands disposed. Madam?
Liberty, my lords, liberty to approach, my lords.
Approach where? The petitioner is at liberty to approach the respondents for the necessary relief.
Please. In connected matter, my lords, same matter, my lords, only. Technical assistant.
Ado barefoot, technical assistant. Yes. Next.
KTA, Sabil Ahmed Jagdish Patil.
My lordships, I appear for the petitioners in these matters, my lordship. My lordship, in earlier posture, my lordship had heard this matter. In earlier posture, my lordships have heard this matter, my lord. This pertaining to applicable petitioners having appeared.
We came to know that they have not followed the rule 4, your lordship. Then your lordship, we cancelled the selection list and the notification.
My lord. Orders dated 23/9/2025 may kindly be perused, my lords. Passed by this honorable court in this petition.
ಏನ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ರಿ?
The entire selection list.
Notification ಹೋಯ್ತು.
Yes, lordship.
ಇಲ್ಲ, notification ಹೋಗಿಲ್ಲ.
Notification cancel ಅಂತ ಬಂದಿದೆ ಅದರಲ್ಲಿ.
ಇಲ್ಲ.
Or that is the only lordship. I got a clarified there lords that is notification itself has been cancelled.
Selection cancel
ನೀವು notification ಮಾಡ್ತೀವಿ ಅಂತ ಅಂದಿದ್ದಾರೆ ಅಷ್ಟೇ. ಅಷ್ಟರಲ್ಲಿ ಬೇಕಾದ್ರೆ ಮಾಡ್ತಾರ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಬಟ್ ನಾನು Assurance ಕೊಡಕ್ ಬರೋದಿಲ್ಲ.
ನೀವು assurance
Yes,
ಕೊಡ್ಬೇಕು.
because we
Not-
need a typist come
Court
copyist.
ಇದು.
Court ಇದೆ ಅದಕ್ಕೆ.
My lords, orders of this honorable court on 23/9.
I have seen,
This-
sir. Yes.
My lords, the selection list which
Selection is cancelled ಅಂದ್ರೆ it means notification ಇಂದಾನೆ ಹೋಗಿದೆ ಅಂತ ಅರ್ಥ.
ಇಲ್ಲ,
You need not be explicit, sir. What is this?
my lordship may take to my lordship's own orders, my lords, on 24/2/2025. Annexure K is the order impugned in this writ petition. Only the final merit list which have been prepared are cancelled.
Whatever it is, till the order of appointment springs, no right gets accrued to a person who is in the select list. There is no appointment order issued now. Even after issuing appointment order, they will not get anything. It's only 50% of the right.
Indeed, my lords, but arbitrary, the cancellation order does not disclose us even the reason for cancellation.
You have no right to say that. When you
My
have, you get no right for weighing in the select list, you cannot say the select list cancellation is bad. Arbitrary illa enill. Yes.
Because in page 59, my lords, the reason is not mentioned.
Notification ಅಷ್ಟೇ
Recently cancel ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ಅದನ್ನು ಹೇಳಿಲ್ಲ ಅದರಲ್ಲಿ.
matter on 25th.
ಅಲ್ಲ, after 15th ಬೇಡ.
After 15th better.
Till up to first week. First
US court.
ಇಲ್ಲ US ಇಲ್ಲ, ಮಗಳ ಮದುವೆ ಇದೆ.
My lord, may I request on 5th, my lords, for little.
Yes.
89, Saurabh Sandhu.
My lords, Saurabh is engaged in other court. Kindly short
ಏನ್ ಟೆಂಡರ್ ಇದು?
My lord, it was for
I'll pass over.
repair and for repair, excavation and sliding of the canal work, my lord.
ಆಯ್ತು, ಏನ್ ಚಾಲೆಂಜ್ ಇದ್ರಲ್ಲ?
Literally, way back in the year 2010, we had issued a tender with the condition of the tender that 10% should be collected from the beneficiaries.
Pass over.
May I request a date could be fixed? I have filed objections.
Short
my lord.
Date is 2:30. Yes.
My lord,
ಮುಗ್ಸೋಣ ಬನ್ನಿ sir. Tender matter ಏನು? Yes.
may I request
Come,
some
come.
short,
Come in the afternoon.
please.
Bill number 90, R. Nagendra Naik, Girish V. Bhatt.
Please, my lord, sir. I seek 2 week accommodation to file my statement of objection. 2 weeks accommodation to file my statement of objection.
Girish V. Bhatt seeks 2 weeks time to file statement of objections. Objections, if any, by the 21st of November. List the matter on 25th November.
Please.
Yes.
91, Jagdish Patil, Sadiq and Godwala.
Please, I appear for petition, Power Karmika seeking regularization. Last occasion, Dharam Singh's judgment, my lord, since last 12 years, they are serving the corporation.
List the matter on 5th in preliminary hearing. In fresh matters. Yes.
92, Shivrajesh.
ಯಾರು ಮಾಡ್ಬೇಕು? ಗವರ್ಮೆಂಟ್ ಸಾಧಿಕ್
Deputy Commissioner. Is a formal party.
ನಂದೇ
Deputy Commissioner, last occasion.
Yes, next. 92.
92, Shivrajesh Balloli.
Appear for the petition. I seek a short accommodation. Will file the rejoinder. 1 week time can be granted.
At the request of the council appearing for the petitioner, list the matter. The learned counsel of the petitioner seeks time to file rejoinder to the statement of objections. Rejoinder be filed by the next date, list on 25th November. Next.
Interim order can be.
Interim order subsisting will continue to the next date of hearing.
Obliged.
93, VP Vadvi, Vijay Madali.
1 week's accommodation, my lord, sir.
A week's time is granted to the Saka Ondwara.
Already lordships has given a time. I sent the my lord's statement of objection.
Finally, 10 days time is granted to file statement of objections, failing which it shall be construed that there are no objections to be filed. List the matter on 19th.
Please. Great.
94, Balgodai Patil.
For the respondent number 4, my lords.
Tender matter.
Filing for the objection.
Aktira.
Yes, please.
Learned counsel seeks time to file, a week's time to file statement of objections. Ready idea?
ಇಲ್ಲ,
List the matter on interim order idea?
No, my lord.
List the matter on 18th, objections if any by then. Yes, next.
95,
Please.
Raghavendra Purohit, Suresh Gundi.
Matter is pertains to, my lord, the premature transfer, my lord. My lord, the
Interim order
earlier,
idea? Yes.
my lord, the petitioner was working in KVG Bank head office, Dharwad, my lord.
ನಾವು ಕೆನರಾ ಬ್ಯಾಂಕಾ?
Canara Bank.
Canara Bank.
ಪ್ರಿಮೆಚೂರ್ ಅಲ್ಲಲ್ಲಿ ಅದೇನಿದೆ? ವೇರ್ ಇಸ್ ದಿ ಗೈಡ್ಲೈನ್ಸ್?
Guidelines, my lord, that along with rejoinder, my lord, I have produced. My lord.
Fact, he is serviced by service
Page
rules.
number 20, my lord.
You are in which category, sir?
Please, my lord. Physically handicapped, my lord.
Physically handicapped.
Please.
He is a divisional manager.
Divisional manager.
Divisional manager, my lord.
ಅದೇನ್ ಟೆನ್ಯೂರ್ ಇದೆಯಾ ಅದಕ್ಕೆ?
Tenure area. Page number 20 of the rejoinder application, along with the rejoinder, my lord, I have produced.
20.
21 ದಲ್ಲಿ
That itself is not applicable.
The period of deputation, my lord.
Please.
20?
21, my lord. Period of deputation. The period of deputation shall be initially for 3 years.
Deputation?
Deputation.
ಈಗ ಡೆಪ್ಯುಟೇಷನ್ ಆಗಿದೆಯಾ ನಿಮ್ದು? ಎಲ್ಲಿಗೆ ಡೆಪ್ಯೂಟ್ ಆಗಿದ್ದೀರಾ?
To the Bangalore, my lord. To Bangalore, my lord.
ಕೆನರಾ ಬ್ಯಾಂಕ್ ಇಂದ ಆಚೆ ಹೋಗಿದ್ದೀರಾ?
ಆಚೆ ಹೌದು.
ಎಲ್ಲಿ?
KVG ಬ್ಯಾಂಕ್ ಮೊದಲು ಡೆಪ್ಯುಟೇಷನ್ ಮೇಲೆ ಹೋಗಿತ್ತು.
ಒಂದು ನಿಮಿಷ. ಈಗ ಡೆಪ್ಯುಟೇಷನ್ ಟ್ರಾನ್ಸ್ಫರ್ ಇದು?
Is a general transfer, my lord.
You don't import.
No, initially it is a
state government's problem.
Lord, as per the annexure A, my lord, my petition, my lord, is transferred.
On deputation to Karnataka Vikasa Grameen Bank is hereby repatriated and
transferred to the Canara Bank Associates subsidiary RRB vertical, my lord.
One nimisha. When were you deputed, sir? Date?
He was deputed to the 2023, my lord, in the year 2023.
So premature repatriation.
Please, my lord.
He was repatriated to Bangalore, only to be transferred to Vijapur. He was transferred to Vijapura. He is refused to report there, and because of the stay order, he is not reported to Vijapura.
Stay order report ಮಾಡ್ಕೋಬೇಕಾಗಿಲ್ಲ.
ಇಲ್ಲ, stay order ಇರೋದ್ರಿಂದ report ಆಗಲಿಲ್ಲ. But from KVG Bank, because they were KVG Bank and Vikas Grameen Bank merged, we were supposed to, he was asked to come to Bangalore. He reported to the head office Bangalore. From there, he was transferred to Vijapura. And a divisional manager.
So, where is the order of repatriation?
Please.
ಈ ಕರ್ನಾಟಕ ವಿಕಾಸ ಗ್ರಾಮೀಣ ಬ್ಯಾಂಕ್ ಹೋದ್ರು.
ಹೌದು.
ಅದು ಯಾವ್ದಕ್ಕೆ ಮರ್ಜ್ ಆಯ್ತು?
Vikas Grameen Bank.
Vikas Grameen Bank is still there.
Now it is the KG Bank, my lord. Now it is merged into
Karnataka Grameen Bank. Now it's
Karnataka Grameen Bank, correct.
But he is the employee of Syndicate Bank. Later on, Canara Bank.
ಅದು ಮರ್ಜ್ ಆಗಿರೋದು. Yes.
Canara Bank, he is an employee of Canara Bank. He was deputed for KVG. KVG merged with Grameen Bank. After that merger, his services were not required there. So earlier he was transferred. They requested, because of that merger period, they requested him to continue for 1 more year. The transfer order was cancelled, which was sent to Bangalore. Bangalore report madaka cancel aitu. So he would continue. He was supposed to continue, but he says that he was not intimated about the cancellation. Then he was transferred to Vijapura. But
tomorrow in fresh matters list.
Please.
Yes. 96.
Sean Madpati.
2025.
Matter pertains to, my lord, appointment of Anganwadi helper. Lords, where, my lord, the petitioner name will appeared in the, my lord's provision list.
Who is now appointed?
Nobody has appointed, my lord.
Your Lordship, as the objection was called for, Your Lordship, provisional list has been published. And when the call for the objections, one lady, Your Lordship, Soumya, she has filed an objection on 15/5, Your Lord. 15/5, Your Lordship, saying that she is a widow. So considering that objection, Your Lordship, that provision list has been stopped, Your Lordship. Stopped, Your Lordship. So
Selection has not proceeded.
not yet proceeded, Your Lordship. And
Selection
issued-
ಬನ್ನಿ ಆಮೇಲೆ.
Allah, my lord.
ಇಲ್ಲ,
That is
ಆಗಿಲ್ಲ.
not the case. Till today, they have not, my lord, issued the final list.
You can't insist on that. You are a.
My lord, annexure D for a moment, my lord. Page 31. The one who has filed the objection, her, my lord, the objection was rejected, my lord. Now they wanted to, my lord.
Appointment and ಮಾಡಿಲ್ವಲ್ಲ.
My lord, they wanted to, my lord, the appoint the very same person, my lord.
Has it come about? Not yet.
Not yet.
The petitioner is before this court seeking the following prayer. The petitioner is a participant in the selection process to the post of Anganwadi helper. The learned HCGP would, on instructions, submit that the provisional select list wherein the name of the petitioner did figure has been objected to by one Saumya, who is said to be a widow. The matter is at that stage. Therefore, the petition so preferred by the petitioner is undoubtedly premature.
My lord, I'm sorry. Their objection was rejected, my lord. Page 31, 32 I had produced, my lord.
The learned counsel would premature. The learned counsel for the petitioner submits that the objections of Saumya had been rejected and what remains is issuance of a final select list. While this court cannot issue a mandamus to issue the final select list at the apprehension of a participant in a select list.
Lordship, one more submission. As they have already notified that call for new circular.
So I will participate ಮಾಡಬೇಕು. To notify the select list. The learned HCGP on instructions and verification of the records would now submit that the said selection process itself is shelved, 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 and a new notification is issued calling for applications from eligible candidates. Therefore, it is for the petitioner to apply under the new notification calling for applications for the post of Anganwadi helper. The name of the petitioner is only found in the provisional select list. It is trite, TRIT. It's trite that a candidate whose name figures in the provisional select list would not get any right to question the selection or seek a mandamus that the selection should be concluded. Selection should be taken to its logical conclusion. Therefore, reserving the liberty to the petitioner to knock at the doors of the appropriate fora at the event of need, and also reserving liberty to participate in the selection process pursuant to the subsequent notification, the petition stands dismissed.
My lord, a final list, my lord, they have issued, my lord.
ಎಲ್ಲಿದೆ?
That copy I have produced, my lord.
Final list
ಮಾಡಿದ್ದಾರೆ.
Even then ಬರಲ್ಲ. No right, provisional or final. Yes. ಹೊಸ ನೋಟಿಫಿಕೇಶನ್ ಮಾಡಿದಾರೆ ಈಗ?
Notification ಅಂದ್ರೆ only ಪ್ರಕಟಣೆ. Just to, my lord, appoint the one who has filed the objection.
Madam,
for that reason, my lord, they
new appoint selection notification ಅಥವಾ ಬರೀ
ಹೊಸ
ಅಲ್ಲ ಹೊಸದಲ್ಲ, only
ಮರು
for
ಪ್ರಕಟಣೆ ಹೊರಡಿಸಲು ಸಮಿತಿಯು
ಕೊಡಿಲ್ಲ.
Even her name is also, my lord, mentioned in that objection.
ನಿಮಿಷ, we'll see.
That Saumya Hadapad, my lord.
Wait. ಮರು ಪ್ರಕಟಣೆ ಹೊರಡಿಸಲು ಸಮಿತಿಯಲ್ಲಿ ತೀರ್ಮಾನಿಸಲಾಯಿತು. ಸೌಮ್ಯ ಆಯ್ಕೆ ಮಾಡಬೇಕು. ಸದರಿಕೆ ನೇಮಕಾತಿ ಕುರಿತು ಸಾರ್ವಜನಿಕ ಫೈನಲ್ ಲಿಸ್ಟ್ ಎಲ್ಲಿದೆ?
Finalist, my lord, sir, produced annexure E, my lord.
Even then, we cannot stop them to withdraw. And,
My lord, then, my lord, obviously they will appoint her only, my lord.
No, ಮರು ಪ್ರಕಟಣೆ ಮಾಡಿ
ಅಲ್ಲಿ
ತೀರ್ಮಾನಿಸಲಾಯಿತು.
ಅವ್ರ ಹೆಸರು ಬರ್ದಿದ್ದಾರೆ ಅವಳದು.
ಪ್ರಭು ನಾನು ಬರ್ದಿರಿ 234.
I'm waiting for my name, my lords. Now, my lord,
Waiting for your
colliding with
appointment.
the government, my lord.
Waiting for your appointment.
Please, illa, exclude,
Wait
include in the
till
final list.
2:30.
Please.
Come back. Yes.
Humble submission, Lordship. Serial number 59 is pass over. Dismissal list ಒಳಗಿದೆ. 1 weeks ಒಳಗೆ ನಾನು ಕಂಪ್ಲೈ ಮಾಡಿ.
ಸಾಯಂಕಾಲದೊಳಗೆ.
ಇಲ್ಲ ಅದು I have to retype the whole thing.
ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡಿ. ಇಲ್ಲ ಡಿಸ್ಮಿಸ್ ಮಾಡಿರ್ತೀನಿ ಆಮೇಲೆ ರೀಕಾಲಿಂಗ್ ಹಾಕಿ.
Is only 2 days time because ಅದನ್ನ ಇವತ್ತು ಟೈಪ್ ಆಗಬೇಕಾಗಿದೆ.
Every day I can't change my stance. I should be consistent. ಮೊನ್ನೆ ಎಲ್ಲ ಹಂಗೆ ಮಾಡಿದ್ದೀನಿ. ಸಾಯಂಕಾಲ ಇಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್.
My lords, one submission, my lord. Serial number 64. My lords are given on date on 18th, my lord. Main is for 19th, my lord. Senior as some personally. 19th, please.
Serial number 107.
Madam, Court Master, ma'am. List will continue or 230 matter will be taken or list will continue, ma'am?
Chillama?
Lordships. Your Lordships.
Yes, yes.
Your Lordships, can I make a mention, Your Lordships?
What is that?
Your Lordship, serial number 76, when the matter was called out due to technical reasons, we could not make a mention, Your Lordships.
76, ಏನದು? Huh.
Your Lordship, subsequent to directions of this Honorable Court in the interim order dated 9th September 2025, we filed a stay petition before the tribunal, Your Lordships. And the matter has been heard twice and it has been fixed for further hearing on 3/11, Your Lordships. Our humble prayer is that till the disposal of stay petition by the tribunal, no precipitative action may be taken by the department for recovery, Your Lordships. That is
Have
our
they
humble prayer.
There is no interim order here?
My Lords, there is an interim order dated 9th September 2025, Your Lordships.
Then forget it, don't worry. Yes, next.
My Lords, in that order,
If there is,
this Honorable...
sir, if there is anything, you move the matter. When there is an interim order, should I clarify my own order? Yes, next.
Please, my Lords.
Lord, 96, my Lord. Lord, sir, I may permitted to narrate some facts, my Lord.
ಊಟ ಮಾಡಿಲ್ವಾ?
My Lord, I may permitted to narrate some facts, my Lord. On 7/3/2025, as per Annexure A, a notification was issued for the Anganwadi helper, my Lord. My Lord, Annexure B, my Lords, where, my Lord, the present petitioner filed online application, my Lord. Thereafter, my Lords, a provision list was, my Lords, issued, where the petitioner name was, my Lords, appeared. My Lords, this is the, my Lord, notification total, my Lord, 12 talukas. Out of 12 talukas, one Halaya taluka, my Lords, we belongs to. There, my Lords, 13 posts were, my Lord, issued. Out of 13, my Lord, a final list was issued, my Lord, 12 persons were, my Lord.
Wait, madam, secure
Yes.
instructions. Merely because someone files objections, would you give up the entire process itself?
My Lord, I am sorry, my Lord. Adu reject ಮಾಡಿದ್ದಾರೆ. That is also rejected, my Lord.
Is rejected.
With reason.
Sir, that doesn't stop them from calling for fresh applications.
ಅಲ್ಲ fresh application ಅದು ಕರೀತಿಲ್ಲ ಈಗ ಅವರು only to my Lord get her appointment, my Lord, they are calling because the entire process is already over, my Lord. A final list is also issued.
One submission, Your Lordship, before he makes the submission. Actually, the Maruti Nagar where the post has been called for, Your Lordship, that is in ward number 6, Your Lordship. Through oversight, Your Lordship, ward number 7 anta hakidare. That is also one of the reasons,
That's the
Your Lordship.
instruction you have.
Please, Your Lordship, but that we cannot make a statement, Your Lordship, because
If they want to file objections, let them file objections.
Please.
ಅದು
Because-
ಹಾಕೋಂಗಿದ್ರೆ ಹಾಕ್ಲಿ ಬೇಕಾದ್ರೆ.
that is also, that is the reason, that is also one of the reason, Your Lordship, and after receiving this objection also, Your Lordship, what they have taken decision is
You have no right,
instead of.
sir. Merely because your name figures in the final select list, provisional select list, no right.
My Lord, if, my Lord, the entire process is recalled, that is very true, my Lord.
If the process,
My Lord, final notification issued.
ಆ ವಾರ್ಡ್ ಮಾತ್ರ ರೀಕಾಲ್ ಮಾಡಿದಿರಾ ಈಗ?
Please, my Lord.
For what? ಹೌದು.
ಅಲ್ಲ,
Entire
my
ಎಲ್ಲ
Lord,
ward
only
ಗಳು
2
ಮಾಡ್ಬೇಕು
persons
ಅಂತ
were, my Lord, sir.
No,
Only
that's
2
not it.
persons, my Lord.
Sir, you are in the select list, provisional select list. You have no right. If they have called for applications afresh, you please apply.
ಅಲ್ಲ, ಇನ್ನು ಫ್ರೆಶ್ ಕರೆದಿಲ್ಲ ಅದನ್ನು, my Lord, that was not cancelled.
Now decision, we have taken the decision, Your Lordship, as I have shown
My
already.
Lord, sir, the objection ಹಾಕ್ಲಿ, my Lord, sir.
ಏನ್
Go
ಬೇಡ,
through
ಏನ್
that.
ಬೇಡ, ಅಷ್ಟೇ.
My Lord, that is not the my case, my Lord. My Lord,
Sir,
one
you tell me, provisional select list ಅಲ್ಲಿ ನೇಮ್ ಬಂತ?
ಫೈನಲ್ ಲಿಸ್ಟ್ ಬಿಟ್ಟಿದ್ದಾರೆ.
ಫೈನಲ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ನೇಮ್ ಇದೆಯಾ?
ಇಲ್ಲ, ನಂದಿಲ್ಲ ಅದರಲ್ಲಿ.
ಇಲ್ಲ.
ಪ್ರೋಸೆಸ್ ಸ್ಟಾಲ್ ಮಾಡಿದೆ.
ಅಲ್ಲ, ಈಗ ಅವರು ಫ್ರೆಶ್ ನೋಟಿಫಿಕೇಶನ್ ಕರೆದ್ರಂದ್ರೆ ಸ್ವಾಮಿ, ಓನ್ಲಿ ಫಾರ್ 2 persons, one for me, another for who was rejected. Then, my Lord, their intention only to, my Lord, appoint the.
All contentions will be open if they call for applications for
My Lord, next week, my Lord,
No.
My Lord, next week, my Lord,
already
I'll go
passed
through
an
that.
order. ಯಾಕೆ?
ಅಲ್ಲ, because, my Lord, ಅಲ್ಲ, this is, my Lord, clear case, my Lord, where, my Lord, the.
No clear case.
ಅಲ್ಲ, my Lord, government has, my Lord, colluded with the one who has, my Lord, who wanted to select, my Lord.
Colluded ಆಗಿ ಆಮೇಲೆ ಅದು
ಅಲ್ಲ,
collusion.
ಅದನ್ನ ಬರ್ದಿದ್ದಾರೆ, ಆ ಕಾಪಿಲ್ ಅದೇ ಇದೆ. ಅವಳನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕಂತೇಳಿ we have called for the next ಫ್ರೆಶ್ ಅಂತ ಹೇಳಿ.
ಕಾರಣ ಇಲ್ಲ.
ಅಲ್ಲ ಬರ್ದಿದೆ, ಸೌಮ್ಯ ಹಡಪದ್ ಅಂತ ಬರ್ದಿದಾರ ಅವರು.
ನೇಮ್ ಬಂದ ತಕ್ಷಣ ಅದಲ್ಲ ಇರೋದಲ್ಲಿ, ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ ಅಂತಿದೆ ಅಷ್ಟೇ.
ಅಲ್ಲ ಅದು ಒಂದ್ ನಿಮಿಷ, ಅದ್ ಒಂದ್ ಮಲೋಡ್ ಸ್ವಾಮಿ ಪರ್ಮಿಟೆಡ್ ಟು ರೀಡ್ ದಟ್ ಮಲೋಡ್. ಪೇಜ್ ಮಲೋಡ್ ಪೇಜ್ 31 ಮಲೋಡ್. ಮೇ ರೀಡ್ ಮಲೋಡ್. ಈ ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯ ಹಾಗೂ ಉಲ್ಲೇಖಗಳ ಸಂಬಂಧಿಸಿದಂತೆ ಶಿಶು ಅಭಿವೃದ್ಧಿ ಯೋಜನೆ ಹಳಿಯಾಳ ತಾಲೂಕಿನ ದಾಂಡೇಲಿ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಮಾರುತಿ ನಗರ್ 2 ವಾರ್ಡ್ ನಂಬರ್.
ಯಾವ ವಾರ್ಡ್?
ನಂದ ಮಾರುತಿ ನಂಬರ್ 2 ಮಲೋಡ್.
ಈಗ ಯಾವ ವಾರ್ಡ್ ಕರೆದಿದ್ದು?
That is the confusion, Your Lordship. Actually, Maruti Nagar consists in ward number 6, Your Lordship. Now ward number 7 anta mention ಮಾಡಿದ್ವಿ. So it is ward number 6 we are supposed to
detail
call
order
for,
is
Your
passed.
Lordship.
ಬೇಕಾಗಿರೋ ವಾರ್ಡ್ ನಂಬರ್ 6.
6 ಈಗ ಆಗಬೇಕಾಗಿತ್ತು. So she has correctly, the Soumya has filed the
objection is your wrong word ಕರೆದಿದ್ದೀರಾ.
ಹಂಗಾಗಿದೆ. That is also the reason, Your Lordship.
ಮಲೋಡ್ ಅಲ್ಲ ಅವ್ರ ಮಲೋಡ್ಸ್ ಲೆಟ್ ದೆಮ್ ಫೈಲ್ ಅಬ್ಜೆಕ್ಷನ್ ಮಲೋಡ್. ಮಲೋಡ್ಸ್ next week ಮಲೋಡ್ any date.
Unnecessary, sir.
Malord, I'll go through that, Malord.
Your name was in the provisional select list. Please. Your name is not in the final select list, nor the selection has gone forward. They have closed that particular ward's recruitment. They are going to issue fresh notification.
They have not closed it, Malord. ಇಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡಿಲ್ಲ. ಈಗ they just wanted to for new Malord. ಅದು ಕ್ಲೋಸ್ ಆಗಿಲ್ಲ. That notification was not Malord withdrawn even.
ಇನ್ನೊಂದು ಪ್ರಕಟಣೆ ಅಂತ ಆ ವಾರ್ಡ್ ಮಾಡಿದ್ರೆ ಅದ್ರಲ್ಲಿ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿ. ಮುಂದೆ ಸೆಟ್ ಅಸೈಡ್ ಆಗದು ಈಗ ಅವ್ರು ದೇ ಹ್ಯಾವ್ ಟೇಕನ್ ಪ್ರಿಕಾಷನ್ ಅಷ್ಟೇ. ಎಸ್ ನಥಿಂಗ್ ಅಷ್ಟೇ. ಸೇಮ್ ಆರ್ಡರ್ ವಿಲ್ ಲೀವ್ ಯು ಆಲ್ ಎವರಿಬಡಿ ಇಸ್ ಓಪನ್. ಬೆಳಗ್ಗೆ ಮಾಡಿದ್ದೀನಿ, ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ. ಎಸ್ ನೆಕ್ಸ್ಟ್.
Malord, next week Malord. Malord, next week fresh matter ಅಂತ Malord. Malord, fresh matter ಅಂತ next week ಇಡ್ರಿ.
ಯಾಕೆ?
Malord, I'll argue, Malord. Let them produce that document. Malord, this is the case, Malord. They wanted to appoint, Malord, the one whose application was rejected, Malord.
In the event the apprehension of the petitioner is correct, that the recruitment process insofar as the present ward is shelved only to accommodate the
Soumya Hadapad, please.
Only to accommodate Soumya Hadapad. The petitioner is at liberty to move the matter for revival of the subject petition.
Please, much obliged.
That will protect you.
Please.
Yeah. Madam, 2010. Yeah.
Amrut Vasan Joyce.
Lord, please, my lord. The petitioner is challenging annexure F. Annexure F is terminating the petitioner who was employed as an Anganwadi teacher on the basis of certain allegations and FIR being filed against some other person, my lord. Yes, ma'am. 7 petitions, same.
All on allegations?
On same allegation, annexure F, my lord. Lord,
what is that allegation?
Allegation is, my lord, there was a paper publication in Vijayawani Kannada daily newspaper stating that there was some misappropriation of nutritious food which were supplied to the children. And subsequent thereto, my lord, FIR came to be filed. And thereafter, my lord, this honorable court was pleased to quash the entire proceedings based on that complaint, my lord. Meanwhile, FIR, my lord. FIR is annexure E, my lord, page 38, my lord. Subsequent thereto, my lord, they have been released from the judicial custody. Entire FIR and complaint filed against the petitioners and some other persons were quashed by this honorable court, my lord. Even otherwise, my lord, they have terminated the Anganwadi teachers from the post of Anganwadi teacher, my lord, without there being any issuance of notice or any giving opportunity, my lord.
Show cause notice has been issued, Your Lordship, and they are in custody, Your Lordship.
ಈಗ ಆಚೆ ಬಂದಿದ್ದಾರೆ.
ಅಲ್ಲ ಈಗ ಬಂದಿದ್ದಾರೆ.
ವಾಶ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ ಎಲ್ಲ.
That is insofar as what the criminal petition is filed by only one person, Your Lordship. FIR has been quashed, Your Lordship. But the allegations against all these persons were also there, Your Lordship, and the departmental inquiry, and this is also different, Your Lordship, wherein show cause notice has been issued.
Idralli, if you want to cast a stigma and send them away, basic requirement. Notice ಕೊಟ್ಬಿಟ್ಟು contract appointment ಅಲ್ವಲ್ಲ ಇದು?
Honorary post.
Honorary, whatever is there, they have some rights to continue. And without holding any inquiry on or even taking notice ಕೊಟ್ಟು reply ಕೊಟ್ಟಿದ್ದಾರಾ?
No notice has been issued.
No notice ಅಂತ ಇದ್ದಾರೆ?
ಕೊಟ್ಟಿದ್ದಾರೆ.
ನೋಡಿ ಮೇಡಮ್.
It was issued on 17/2/25, Your Lordship.
ಈಗ I am holding writ petition 104-375. ಅದರಲ್ಲಿ ನೋಟಿಸ್ ಇದೆಯಾ ನೋಡಿ.
375. All the petitioners' name were there, Your Lordship, in that notice. ಎಲ್ಲರಿಗೂನು ಕೊಟ್ಟಿದ್ದೀವಿ.
For my instruction, my lord, they have not been served with any notice. Because on.
Where is the order? Termination order, sir.
Termination order is annexure F, my lord. Page 45, my lord. Lord, for termination of petition.
1 minute. One by one.
Please.
Notice was issued on 13/2, Your Lordship. She has taken the, received the signature.
Reference ilvalla madam. ಮಾಧ್ಯಮದಲ್ಲಿ ಪ್ರಕಟವಾದ ವರದಿ, ಉಪನಿರ್ದೇಶಕರು ಧಾರವಾಡ ಇವರು ಸಲ್ಲಿಸಿರುವ ವರದಿ, ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ so and so. Even in the preamble, there is no notice issued or reply submitted by them indicated.
On 17.
Notice ಕೊಟ್ಬಿಟ್ಟು ಮಾಡಿ ಅಷ್ಟೇ.
On 17/2 notices were issued, Your Lordship.
There is no reference even in the impugned order that notice were issued. This order is dated 3/3/25.
Please.
17/2 ಕೊಟ್ಟಿದ್ರೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ ರಿಪ್ಲೈ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಇರ್ಬೇಕಲ್ಲ. ಮಾಧ್ಯಮದಲ್ಲಿ ಬಂದಿರೋದು ಮಾತ್ರ.
Signature is also there, Your Lordship. Signature is there.
ಇವ್ರದಾ?
ಹೌದು.
My submission, my lord, on 18/2/2025, they have been arrested. The petition was arrested on 18/2/2025. No opportunity, my lord. 14 days they were in custody.
Reply ಕೊಡಕ್ಕೆ opportunity ಇಲ್ಲ. You
13.
will send it back. Not reinstatement. Everything will depend upon the
inquiry.
reply submitted and the consideration being done. They will bear in mind the quashment of the criminal case.
Please.
The conglomeration of these cases are by different petitioners projecting an identical issue. The issue is termination of Anganwadi workers at different Anganwadi centers, which would come within the precincts of PRECINTS, precincts of Hubli, Dharwad city. Heard the learned counsel appearing for the petitioner and the learned HCGP, Srimati Girija Hirimat. The since the facts are common in all these cases, I deem it for the sake of brevity, I deem it appropriate to narrate the facts obtaining in writ petition 104-375 of 2025. The petitioners in all these cases are appointed pursuant to a selection process, are appointed as Anganwadi worker pursuant to a selection process instituted by the respondent. During the subsistence of their service, it transpires that a complaint comes to be registered against these petitioners, which becomes a crime in crime number 10 of 2025, which was itself based upon certain newspaper reports or the news that was aired in the television channels. This led to the registration of the crime, led to the petitioners being taken into custody. The petitioners then questioned the registration of the crime against them in criminal petition 100-976 of 2025 and connected cases. The criminal petition comes to be allowed by the coordinate bench of this court in terms of its order dated 25/2/2025. In the light of the quashment of the crime itself, the petitioners were released from custody. The petition was released from custody on 3/3/2025, only to be shown an order terminating them on the same date, i.e. 3/3/2025. The learned counsel for the petitioner submits identical orders are passed in all the connected cases. The learned counsel further contend that the petitioners are terminated on account of a stigma of certain allegations. No notice was issued to the petitioners. Even if notice is issued, the petitioners had no opportunity to submit their reply. Therefore, the order of termination, which by itself refers to certain allegations, is on the face of it stigmatic, which could not have been issued without complying with the principles of natural justice, in the least. He would seek quashment of the orders. He would further contend that the coordinate bench has quashed the crime itself against these petitioners. The reason for termination is the registration of the crime. Therefore, the crime today is not even in existence. The learned counsel would seek the quashment of the orders and consequential reinstatement as is sought for. Per contra, the learned HCGP would vehemently refute the submission in contending that these petitioners are alleged of serious misconduct. They are with regard to nutritious food that was supposed to be distributed to pregnant women in Anganwadi centers in Marbutidara.
It has been seized.
Yen Madidare?
They have not provided, Your Worship.
Has not been provided and was kept away. This was seized at the time of search, and this was what was projected or aired in the television. Based upon this, the crime is registered. The crime is quashed on technical grounds. The learned counsel would further submit that quashment of the crime has nothing to do with the grave misconduct committed by these petitioners. She would seek dismissal of the petition. I have given my anxious answer. The aforenarrated facts lie in a narrow compass at this juncture. The petitioners on registration of the crime were taken into police custody on 17/2/2025. 18/2/2025. The learned HCGP on verification of the records would submit that a notice was issued to these petitioners on 17/2/2025 seeking to show cause as to why their services should not be terminated. The learned HCGP would, as contended by the learned HCGP, the signatures of these petitioners are also found in those notices. Therefore, they have received those notices. Even if they have received those notices, it needs to be noted, what cannot be forgotten is, on 18/2/2025, these petitioners were taken into custody. If they were taken into custody and released only on 3/3/2025, the day on which the termination orders are passed, they ostensibly did not have opportunity to submit their reply to the show cause notice. In that light, the orders of termination, which by itself cast serious stigma upon these petitioners, could not have been passed without an opportunity being provided to these petitioners to submit their replies. In the light of the issue at this juncture lying in the aforesaid narrow compass, notwithstanding the vehement opposition of the learned HCGP, I deem it appropriate to afford an opportunity to these petitioners to submit their reply to the show cause notices so issued. And if not issued, the respondent shall now issue a show cause notice to these petitioners seeking their reply and then pass necessary orders in accordance with law. As a matter of form, for the purpose of submission of the reply or issuance of show cause notice as indicated herein above, the impugned show cause notice would stand obliterated. The obliteration would not result in an axiomatic consequence, AXIOMATIC, axiomatic consequence of reinstatement into the services. All that would depend upon the decision of the competent authority after considering the reply of these petitioners. For the aforesaid reasons, the following order. The petitions are allowed in part. The impugned orders of termination stand quashed. The matter is remitted back to the hands of the competent authority. Madam, competent authority. Competent authority.
Second respondent has issued the notification.
Back to the second respondent.
That is at Bangalore, my lord.
Second respondent to issue a show cause notice to these petitioners afresh within 2 weeks from the date of receipt of the copy of the order, and the petitioners to submit their reply within 4 weeks from the date of receipt of the show cause notices, and the state to take a decision upon the said show cause notice within 8 weeks. 8 Saka?
Please, Your Lordship.
Within 8 weeks thereafter. Therefore, the process of the issuance of notice and a decision to be taken must conclude within 14 weeks from the date of receipt of the copy of this order. All contentions except the one considered in the course of the order of both the parties shall remain open.
Notices were earlier issued by R3, Your Lordship.
Sorry, R3.
Please.
R3 respond. Ordered according.
Please.
Separate order. Separate order.
Separate orders.
One this separate order ಬೇಕಾಗತ್ತೆ ಯಾಕಂದ್ರೆ they are individuals.
Individuals.
Separate order.
Please.
ಇದೆ same order.
Please.
They are individuals. ಅದಕ್ಕೆ ಉಪಯೋಗ.
Please.
Shivraj Balloli.
Seeking my lord's direction against the fifth respondent to determine my lord's the compensation for the compensation for laying of lines my lords by the first respondent under Telegraph Act.
Laying of lines.
Electricity lines.
I appear on behalf of respondent.
Telephone line ಎಳೆಯೋ ಕಾಲ ಹೋಗಿದೆ. Yes.
Lord, I appear on behalf of respondent number 1. Lord, a short accommodation may kindly be given. I request to have it on 4th or 5th, my lord. I'll seek instruction and
6th ತಗೊಳ್ಳ?
Please. Well, 6th, some personal inconvenience.
Why?
Not in town.
Supreme Court ಹೋಗ್ಬೇಕಾ? ಇಲ್ವಾ?
Bangalore
matter.
Some other work.
As regards 4 to 6, my lord, it is not our project, it is the project of respondent number 1.
We will take it on 7th.
Please.
This is the matter on 7th in preliminary hearing at the request of I forget your name.
Harshvardhan Patil.
Harshvardhan. Yes.
Please. My name may kindly be shown. It
ಅದೇ
is
ಇಲ್ಲ
through
ಇಲ್ಲಿ.
oversight. It is not.
ಯಾರದು?
mentioned. Harshvardhan Patil.
ಯಾರಿಗೆ?
Respondent number 1, my lords.
Register to print the name of Harshvardhan
Patil.
Harshvardhan Patil is appearing for the first respondent.
Please. Grateful.
Obliged.
99, Abhinandan V. Raymond. V.S. Kamte.
Madam, my lord, seeking sanction of the promotion according to the seniority. Let's on the ground they have refused.
Yes, misappropriation, my lord, inquiry was conducted.
Department inquiry ಆಯ್ತಾ?
Inquiry conducted, my lord, charges were proved, my lord, the matter is before the, my lord, the competent authority for imposing punishment. So at that stage, my lord, the
ಅದ್ರಲ್ಲಿ
proceedings.
ಎಲ್ಲಿ ಬರುತ್ತೆ ಪ್ರಮೋಷನ್?
ಅಲ್ಲ, charges ಇದು guilty is not proved, my lords.
It is there actually.
ಅಲ್ಲ, my lords, my ground for the seeking.
Lord, I can place on record, my lord, whatever is, because the inquiry, charges are proved and it is before the competent
This,
authority.
my lords, if it is proved, my lords, it's, I'll leave to the court, my lords. My lords, my claim according to this writ petition, my lords, during the sanction of the promotion to my junior colleagues, as of that date, my lords, the article of charges were not framed and issued against me, my lords. It is covered by judgment of this honorable
ಗೊತ್ತು
court.
sir.
On that ground, my lords, I am seeking the.
What was the date on which the DPC met?
My lords,
Or
article
others
of
considered?
article of charges were issued in the year 2021, my lords.
Year ಅಲ್ಲ sir. Year ಅನ್ನು January to December ಯಾವಾಗ?
29/10/2021. But my lords, my juniors, they were granted according to the seniority, my lords, on 16/4/2018.
ಇದು 21 ಚಾರ್ಜ್ ಶೀಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರು.
ಹೌದು. Only on that ground, my lords, I am before this court, my lords, that cannot be done ಅಂತ ಹೇಳಿ.
Yes sir.
Misappropriation and he was
ಪರವಾಗಿಲ್ಲ.
kept under suspension in 2014.
And it was,
he was under suspension.
Lords, suspension was on 2014.
Later on, Lord, he was, Lord, your lordship is aware, Lord.
22/8/2014
he was reinstated.
ಗೆ suspension ಆಗಿತ್ತು. 12/11/2000 14, my lords, he was reinstated.
12/11/2014 reinstated.
Yes.
Charge sheet was issued in 2021.
In 2021, my lords, October 29.
When were you due for promotion?
2018, my lords, April 16th.
Anything else? Nothing.
No, joint inquiry was there, my lord, actually.
What inquiry was there?
Joint inquiry, my lord.
ಯಾವ joint inquiry?
Inspector, my lord, this property.
Charge sheet ಯಾವ ಇದ್ಯಾಕ್ ಬೇಕು?
Charge sheet, my lord, 2021. My lord, may I request, my lord, a short accommodation, my lord, because I understood, my lord.
Lords, if it is,
Undoubtedly, my
if
lord,
it
charge
is
sheet
proved,
is
my
issued
lords,
to the-
my
Departmental inquiry would commence only on issuance of the charge.
Exactly.
Charge sheet
21
is
ದಲ್ಲಿ
issued in
ಮಾಡಿದ್ದಾರೆ.
2021.
Promotion 18.
18 promotion ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀರಾ?
Disapprobation earlier to that, my lord.
ಇರಬಹುದು. Charge sheet issue ಮಾಡಿದ್ಮೇಲೆ ಮಾತ್ರ
The reason,
DE
my lord,
pending.
my lord, I will
DE
find
is
out.
not pending, he
Lord,
cannot
I
be
understand.
denied promotion. ನಾಳೆ ತಗೊಳ್ಳ?
legitimate right of my.
ಆಯ್ತು ಸರ್.
Monday or Tuesday, my lord, my lord, I will secure the instructions, my lord.
Monday,
The reason for, my lord, delay in issuing charge sheet.
That is reason fatal, sir. Delay is fatal.
Tuesday, my lord.
ಆಯ್ತು ಯಾಕೆ ಫೇಟಲ್ ಅಂದ ತಕ್ಷಣ ಟ್ಯೂಸ್ಡೇ ಹೋಯ್ತಲ್ಲ ಏನಿಲ್ವಾ?
That's on 4th.
ನಿಮಗೆ ಟೈಮ್ ಬೇಕಾ?
ಇಲ್ಲ ಇಲ್ಲ.
List on 4th.
Please.
In fresh matters list.
Please, ma'am.
I'll close it.
100. Complete.
Lord,
Come to sir.
this is not covered by, my lord, by the Honorable Supreme Court judgment.
Sir,
my
ಆಗಿದೆ
lord.
respondent.
And, my lord,
ಕೊಡಿ.
coordination. This Honorable Court, my lord.
The petitioner is before this court seeking the following prayer. The heard the learned counsel B.S. Kamte appearing for the petitioner. The respondent is served and remains unrepresented. The learned counsel for the petitioner submits. ಇನ್ನು ಅವ್ರನ್ನ ಕೇಳಿಲ್ವಲ್ಲ?
My lord, relying upon this Honorable Supreme Court judgment, my lord.
ಅಲ್ಲ ಅಲ್ಲ. Respondent served ಅಲ್ಲ?
Served, my lord, unrepresented. Notice was ordered.
Third unrepresented. Learned counsel for the petitioner submits that the issue in the list stands completely covered by the judgment rendered by the apex court, which is all followed by the coordinate bench in that is 1976 judgment.
Yes.
Coordinate bench. The coordinate bench has held as follows. In the light of the issue standing completely, the coordinate bench, in the light of the issue standing completely answered by the coordinate bench, the petition deserves to succeed with the same order that is passed by the coordinate bench. ಇಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ? Yes, same order.
But if refer to this, the coordinate bench of this Honorable Court also ordered.
ಅದನ್ನೇ ಕೋಟ್ ಮಾಡಿದ್ದಾರೆ ಪೂರ್ತಿ.
ಎರಡು, based on Supreme Court judgment.
ಅದೇ 1976 4SC
76 ordered. Limitation point ordered. Yes.
101. ಮೃತ್ಯುಂಜಯ ಹಳ್ಳಿಕೇರಿ.
Kindly have this man Monday, my lords. I will find.
Tuesday.
Tuesday.
Please.
Rest on Tuesday at the request of the learned AG. Next.
102. NR Kupelur.
Mandamus. ಯಾರು ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕಾಗಿದೆ? ನೀವಾ? ಕ್ಲೋಸ್ ಮಾಡುವ? The petitioner is before this court seeking the following prayer. Heard so and so. The petitioner submits a representation to respondents 1 to 4 to register a crime against respondents 5 to 8. The complaint narrates certain allegations. Notwithstanding the complaint, it is the case of the petitioner that no crime is registered against the respondents. And therefore, the petitioner is before this court. The learned AGA would submit that action would be taken in strict consonance with the judgment of the apex court in the case of Lalit Kumari versus State of Uttar Pradesh, 2014 2 SCC page 1, and necessary action would be taken on the representation submitted by the petitioner. In the light of the said submission, I deem it appropriate to dispose the petition with a direction to the respondent to take action on the representation/complaint of the petitioner in consonance with the judgment of the apex court in the case of Lalit Kumari. Ordered according. Next.
103. Umme Salma.
Your Lordship, appearing for petitioner, Your Lordship. Writ of mandamus, Your Lordship. And
Virola.
No, Your Lordship. Writ of mandamus directing the respondents to restore the convict prisoner's work, Your Lordship, which has been allotted at the time of conviction, Your Lordship. He is the convict prisoner of 302. He had been allotted
kitchen work.
Yes, please, my lords. It has been subsequently taken back,
Why
Your
is,
Lordship, without
why is the work withdrawn?
no reason has been given, Your Lordship. Subsequently, in the year 2023, they have withdrawn, Your Lordship, without
Secure instructions.
Yes, instructions have come, my lords.
List the matter on Tuesday in fresh matters list.
Yes.
The learned AGA to secure instructions and make his submissions. Yes, next.
Please,
Lord, I appeal for the petitioner. The petitioner, Lord, is a mining company.
My lords, in this case, you have to file objections, my lords.
Lord, there is a point. I am not seeking for any further relief. I am limiting my relief. Your Lord may kindly permit me to. This reconnaissance permit was given, my Lord. And that was followed by a prospecting license. Now, in respect of the area, in respect of one portion of the area where the gold is found, the same has been allotted to the playground in a school. Large area is available. I am limiting my prayer only to request the deputy commissioner to consider my representation. There is a writ petition also pending, where there is an order not to precipitate and not to auction this also.
I will go through it. Objection alla. Bari mandamus restrict ಮಾಡ್ತಾ ಇದ್ದಾರೆ. I'll take it tomorrow in fresh matters.
Please.
Let's tomorrow heard the learned senior counsel Ashok Harnalli appearing for the petitioner. The learned AGA seeks a day's accommodation to go through the papers and make his submissions. List tomorrow in fresh matters.
Please.
Bari representation consider ಆದ್ರೆ ನೋಡ್ಕೊಂಡು. Next. ಇಷ್ಟೇ.
Last year matter, number 26.
Well, it's appear for the petitioner. I'm sorry I missed it in the morning. Was the challenge in this writ petition is to an order appointing an administrator, presumably under section 65 of the Waqf Act. Just a few relevant dates, my lords may kindly note.
Yes, sir.
On 30th of March. Yes, 30th of March 2022, a managing committee was appointed, my lords, for a period of 3 years. Now, in the meantime, my lords, since the 3-year term was coming to an end, notices were issued for selection of the new managing committee. General body meeting was held on 21st April 25, and a 21-member managing committee was elected. And my lords, we wrote to the Waqf officer for his approval to recognize the new managing committee. This was done on 3rd of May 2025. My lords, we receive an endorsement about 3 days later on 6th of May 2025, stating that since your scheme of administration is still pending approval, we cannot approve your managing committee as of now. But they specifically say that as soon as your scheme of administration is approved, we will approve your new managing committee. Then, my lords, in the meantime, while that my scheme of administration is still pending consideration, on 22/9/25, my lords may kindly see page 19 is the impugned order. They appoint an administrator. They don't refer to which section. They appoint the local tahsildar as the administrator. And 3 days after that, my lords, they
administrator taken over.
My lords, I'm not sure. My instructing counsel can verify that, my lords.
As per section 65 of the Waqf Act, Lordship, there has to publish the official as per 65 official gazette ಆಗಬೇಕು ಫಸ್ಟ್ ಆಮೇಲೆ ಅಸ್ಯೂಮ್ ಮಾಡಬೇಕು as per section 65
Yes, sir.
So therefore, my lords, the appointment of the administrator, one is it's contrary to the mandate of section 65. Two, my lords, the circumstances are such that they keep my application from recognizing the new managing committee pending on the ground that my scheme of administration is pending approval. 3 days after the administrator is appointed, they approve the scheme of administration. So it's written, the malafide also seem to be writ large.
Learned senior counsel appearing for the petitioner. The petitioner, the subsisting managing committee is before the court.
I was the complainant in this matter. I have not been arrayed as a party.
Wait, we'll see. One, file an application. The managing committee was, the subsisting managing committee is at the doors of this court, calling in question the action of the first respondent in appointing an administrator. The learned senior counsel, taking this court through the documents appended to the petition, would prima facie demonstrate that the order impugned in the subject petition dated 22/9/2025 runs counter to section 65 of the Work Act. The learned senior counsel submits that the scheme of administration was submitted for its approval by the subsisting managing committee. The same was, no order was passed on the said proposal that was sent to the first respondent board. The order appointing the administrator on 22/9/2025 comes about, and immediately 3 days after the order of appointment of 3 days after the order of appointment of the administrator, the scheme of administration is approved. The learned senior counsel submits that the administrator so appointed has not yet assumed charge.
No, he has assumed charge, my lord.
Where is the gazette notification?
Not just now I received.
Lordship, this is a report, Lordship, from the district.
Where is the
office-
gazette notification? Section 65 prakara, how has he assumed charge?
Yes, the assumed charge is reported, gazette notification I will get it, my lord.
Where?
Time may be gone. I have yet to appear in this matter and
But why did you appear? So
I will produce.
the learned senior counsel submits that the administrator, even if has assumed charge, is not in consonance with section 65, as there is no gazette notification of such appointment. Counsel
No,
Muhammad Ali,
Sorry, my lord.
Muhammad Ali,
Sorry, my lord.
who volunteers to represent the first respondent board, submits that the gazette notification is published and would produce it on the next date. Therefore, in the event the administrator has not assumed charge in terms of section 65 of the Act, he shall not assume charge. In the event the administrator has assumed charge pursuant to a gazette notification as obtaining under section 65, the same shall remain subject to the result of the petition. List the matter.
My lord, I may be corrected, my lord. He has already assumed charge, is functioning in Tahsildar.
In terms of, where is the gazette notification?
Gazette notification is published government ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಟೈಮ್ ತಗೊಳ್ತದಲ್ಲ ಆಮೇಲೆ that is why, because there is a vacuum, my lord, there is nobody to manage, that's why they has been done.
No, that's what I was submitting.
Therefore,
We sent our managing committee for approval.
ಇಲ್ಲ ಅದಕ್ಕೆ
is already
ಚಾರ್ಜ್
assumed
ಅಸ್ಯೂಮ್ ಮಾಡಿದ್ರೆ ಸಬ್ಜೆಕ್ಟ್ ಟು
status quo ಇರ್ಲಿ ಮೇಡಮ್, my lord.
ಅಲ್ಲ ಚಾರ್ಜ್ ಅಸ್ಯೂಮ್ ಮಾಡಿದ್ರೆ
Let there be status
ಅದನ್ನೇ ಹೇಳಿದ್ ನಾನು. If he has assumed charge, it will continue. That will be subject result of the petition. List the matter on 18th.
that will create a lot of confusion in this matter, my lord. If
Confusion.
it is status quo ಇದ್ರೆ ಒಳ್ಳೆದು, my lord. That is how.
ಈಗ ಸೆಕ್ಷನ್ 65
That will create more confusion.
ಕೊಡಿ.
He has already assumed charge, my lord. That is why my humble submission is to maintain the status quo, my lord.
Section 65, my lords, is saying.
Assumption of direct certain.
No, this is a vacuum, my lord, in this.
ಇದರಲ್ಲಿ vacuum ಇದೆ.
ಅಲ್ಲ,
Can I
management
submit there?
ಇದ್ರಲ್ಲಿಲ್ಲ.
It's a vacuum created by the board. When I send my managing committee approve on 3rd of May, they keep it pending and then they appoint. So it's not. And can I just submit one more point on
I call for records and pass such orders. Property pass such orders as a thing, and state government shall be final and shall be published in the manner specified in
subsection 1, subsection 1 noting.
If you leave 65(2), my lord, even they have to go before the government actually, my lord. They cannot come in the writ petition. If you read section 65(2),
I'll take it on 5th.
65(2), my lord.
I'll take it on 5th. You get me.
Yeah, all those I will get it, my lord, no problem. But only thing is the status quo, maybe.
ತೊಂದ್ರೆ ಇಲ್ಲ. ಅಲ್ಲಿ ಗಲಾಟೆ ಮಾಡಬೇಡಿ.
No, Lordship, that is not an
ಅವ್ರನ್ನ
issue.
ಕಳಿಸಿ ಇವ್ರನ್ನ ಕಳಿಸಿ.
Lordship, what happened? Lordship, our proposal has been pending before the
Correct. ಅದು
court,
ಹೇಳಿದ್ರು, senior
they have not
counsels.
considered it also. Thereafter,
I've
no
given reasons
official
anyway.
order
List
is
the-
also published.
List the matter on 6th in fresh matters list. 6th November.
Sixth is next
week.
Thursday. Ma.
Next Thursday.
Next
ಅಂದ್ರೆ
Thursday.
ಸ್ವಲ್ಪ ಇನ್ನು
ಈಗ ಪ್ರಿಪೇರ್ ಮಾಡ್ಬೇಕಾ ರಿಸಲ್ಟ್ ಇಲ್ವಲ್ಲ?
ಇಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ತರಿಸು.
ಎಲ್ಲಿಂದ?
ಬ್ಯಾಂಗ್ಳೂರಿಂದ ಬರ್ಬೇಕು ಮಿಲನ್.
ಬ್ಯಾಂಗ್ಳೂರಿಂದನಾ? ಬಾಸ್ಟನ್ ಇಂದ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರೆ ನೋಡಿ. ಎಸ್.
Grateful.
32 KL Patil.
Yes, sir.
These two matters.
How is it maintainable?
There is a division bench decision of dishonorable court.
ಈ ನರೇಂದರ್ ಅವ್ರದ್ದು. Justice ನರೇಂದರ್ ಅವ್ರದ್ದು.
Yes. It says that this court has jurisdiction. And then that, my lord, without any issuing notice, anything, without issuing notice, not even the agenda item is there for that. I have been expelled for having filed the suit. I have produced the agenda notice also.
What is the action taken now?
They were expelled. One, the person.
Expelled why?
Expelled by the Bar Association membership. One person who has filed the suit against the Bar Association, he is expelled, expelled, and thereafter the wakalats filed by on his behalf, the advocates, they are also expelled. And then the earlier president, in third resolution, the president is also expelled. And those are not the agenda items at all.
Where is the agenda?
Agenda, your lordship may please to take.
Because Tharavu Eradu is where you are expelled.
Pardon?
Tharavu Eradu is where you are expelled. Where is the agenda for that?
One, your lordship may find it. The page 40, your lordship may take 7982.
ಅದೇ ಯಾವುದು?
2 is it?
7982. 10 common ಅಲ್ಲ. Sorry. Yes.
Here, page number 43.
I am there only. I am at 43 only.
Yes. This agenda, ಸರ್ವ ಸದಸ್ಯರ ಸಭೆ 24-25ನೇ ಸಾಲಿನ
ಲೆಕ್ಕ ಪರಿಶೋಧಕರು ನೀಡಿದ ಲೆಕ್ಕ ಪರಿಶೋಧನೆ
ವರ್ಷಾಂತಕ್ಕೆ ಜಮಾ ಖರ್ಚು ಕುರಿತು ಅನುಮೋದನೆ ಸಹಜ ತರಬಹುದಾದ ನಿರ್ಣಯ ಅಪ್ಪಣೆಯ ಮೇರೆಗೆ ಬಂದ ವಿಷಯಗಳು. In this, the second item itself.
What is second item here? ಲೆಕ್ಕ ಪರಿಶೋಧಕರು.
ಲೆಕ್ಕ ಪರಿಶೋಧಕರು. ಇಲ್ಲಿ ಠರಾವ್ ನಂಬರ್ 2ರಲ್ಲಿ next page. They say he has filed the suit against the Bar Association, so he is expelled. And Tharav number 3, they have appeared for him and filed the wakalat.
Expelled.
And Tharav number 4, the president.
ಈಗ ಇದಕ್ಕೆ ಠರಾವ್ ಕೊಡಬೇಕು ಅಂತ. Yes. They heard the learned counsel KL Patil appearing for the petitioner. The petitioners are advocate. Petitioner is an advocate and a member of the Bagalkote Advocates Association.
Yes.
The issue is with regard to their, issue is the expelling of the petitioner. The resolution, the learned counsel for the petitioner submits that there was no agenda for a resolution to expel the petitioner. The resolution of the said date before the committee is as follows. Page 43. In the resolution, in the list of agenda, there is no resolution with regard to the expelling of the petitioner or any other person. But the resolution expels the petitioner on the strength of the agenda, on the strength of an imaginary agenda. Same goes with the resolution number 3 or even 4. The agenda is different, resolutions are different. Therefore, the petitioners are hit bolt. Therefore, there is blatant violation of law in expelling the petitioner as observed herein above. In that light, there shall be an interim order of stay. Interim order as prayed for till the next date of hearing. One, the first respondent was served by way of hand summons. Srimati Archana Magdum accepts notice for the second respondent, registry to print the name of so and so as appearing for the second respondent.
33 also.
Same, adene, same
And
order.
one more matter which I moved at 2:30, my lord, that is.
Bandre adunu same, 33 no same order. 30 ಇನ್ನೊಂದು ಮೂವ್ ಮಾಡಿದ್ ಬಂದ್ರೆ ಅದನ್ನ ಟ್ಯಾಗ್ ಮಾಡ್ಬಿಡಿ.
Yes, obliged.
Yes, next.
Number 66.
For withdrawal is filed.
ಎಲ್ಲಿ ಸರ್ ಬನ್ನಿ. ವಿಡ್ರಾವಲ್ ಏನ್ ಪ್ರಾಬ್ಲಮ್?
ಇನ್ನೊಂದು ಬರ್ತಾ ಇದೆ ಬೋರ್ಡ್
ಬರ್ತಾ ಇದೆಯಾ?
ಅವ್ರದ್ದು ಆಮೇಲೆ 230 ಬಂದಾಗ ಕರಿತೀನಿ.
ಆಯ್ತು 230.
66 days.
Please.
6 ಮಲಡ. Vacating entry ಮಾಡಿದೆ.
ಅಲ್ಲ ಇದು ಇನ್ಫ್ಯಾಕ್ಟ್ ನೋಟ್ ಎಂಟ್ರಿ ಮೋಡ್ ವಾಸ್ ಮಾಡಿಫೈಡ್. It is a case of GVP, Grama Vidyut Pratinidhi, on contract basis for 1 year. They used to collect incentive basis appointment. Then some mishap was committed. The notice was issued and he has been removed. Then the present writ petition is filed. The interim order was obtained by my land fund the writ petition, referring to the order passed by the principal bench, which was stayed by the division bench in the writ appeal. So therefore, the
what
order
has
was
happened to that now? Writ
So
appeal ಏನಾಯ್ತು?
subsequently, the writ appeal has been disposed of.
Disposed by what method?
The learning disposed of confirming some portions of the order passed by the learning single judge. The learning single judge
So far as
issued a direction to the government to frame
Sanjay Gowda order ಅಲ್ಲ?
His Lordship Justice Dixit's order, my lord, was taken in writ appeal. There was a direction by the learning single judge to the government to frame certain guidelines with regard to GVP workman who was appointed.
ಈಗ ಇದೇನ್ are they identically placed? Are they identically placed?
So far as malad the
ಇದ್ರೆ ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ, ಅದು ಯೋಚನೆ ಮಾಡೋದೇನಿದೆ?
ಅಲ್ಲ, so far as annexure A is concerned, malad is a stigmatic malad removal from service. That has been malad that portion of the order malad passed in writ petition is also been upheld by this the division bench.
ಈಗ ಏನ್
Malad, stigmatic removal malad without malad holding any inquiry.
What is the judgment of?
Malad, he is malad annexure A. Annexure A.
Annexure A. Order ಅಲ್ಲ sir.
May I pass it on the operative portion? It is a very long judgment, my lord, 800 pages.
ಇದೆಲ್ಲ ಮನ್ಮನೆ ಆದಂಗಿದೆ.
ಅದೇ ಮನ್ಮನೆ ಆಗಿದೆ. But operative portion I have taken the whole 800 pages.
Operative portion ಇಷ್ಟೊಂದಿದೆಯಾ? ಕೊನೆಗೆ ಏನ್ ಮಾಡಿದ್ದಾರೆ?
Stigmatic malad removal is concerned, malad it is
circumstance in agreement.
Removal notice.
Contract of 1 year service.
Para 26-27, my lord, I think my lord can. In this paragraph, 26 is complied. Notice was ordered. Given to the present petition.
ಇದ್ರ ಬಗ್ಗೆ ಎಲ್ಲಿದೆ ಶೆಟ್ರೆ?
in fact your lordship may kindly see the allegation.
Where is the observation with regard to stigma?
It is malad page number
26.
Therefore appealed. Page number para 26 malad in fact.
26 ಅಲ್ಲೇ ಇದೆಯಾ?
26 ನಲ್ಲಿ. Further, in the facts and circumstances of the case, we are of the agreement with the findings of the learned single judge that contract being one of service, it can be terminated on allegation of mispresence or mispresence only after issuance of due notice in that regard. The direction in this.
That is upheld.
Upheld. So malad this.
We'll follow this sentence.
Malad, your lordship may kindly see the
notice was given
order passed by the learned single judge.
Several notices were given to the petitioner. In this note,
page 63 malad.
So far as 26 is concerned, complied.
No, it is
complied.
Yes, my lord. DB, my lord, this honorable court, my lord, says, my lord, termination only after giving notice. Annexure A, your lordship kindly see, my lord, several notices were given to the petitioners.
No.
Annexure A. Lord, may I request Lord page 13.
one ನಿಮಿಷ. Where is the order, sir?
Annex A, my lord. Page 13 is the Lord removal order.
Several notices ಕೊಟ್ಟಿದ್ದು ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
Yes, yes.
Otherwise, all other findings of the single judge is set aside, is it?
So far as that stigmatic, my lord, removal is concerned, my lord, the order passed by the single judge. In so far as
Single judge ಅಲ್ಲಿ stigmatic removal ಎಲ್ಲಿದೆ ಹೇಳಿ?
page number 63, my lord. 1 minute.
63 regularization.
65, my lord, 65. Stigmatic removal of GVPs and non-renewal of so-called service contract.
ಇದ್ರ ಬಗ್ಗೆ ರಿಟ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ?
ಅದರಲ್ಲಿ ಕನ್ಫರ್ಮ್ ಆಗಿದೆ. That portion has been confirmed. Para 26.
Olga tell us ಎಲ್ಲ. Yes.
Para 26.
What is the direction now on this? Functions.
Committee constitute ಮಾಡಿ guidelines issue.
That is, my lord, in respect
Opportunity
of
of hearing in so and so. Same order will pass.
So far as notice, my lord, he cannot be continued because my lord, termination, my lord, para 26 is complied, my lord, the DB order, my lord. He has to be removed, my lord, only after giving notice because it's appointment on contract
No
basis.
problem, but the order casts a stigma. Stigma iದ್ರೆ notice ಅಲ್ಲ enquiry ಮಾಡಬೇಕು.
Enquiry ಮಾಡಬೇಕು.
Opportunity of hearing should be there.
Several notice was given, he remained absent, he did not give a reply also, Lord. He did not appear
How
also.
he will give? Reinstatement will depend upon what order you pass.
My lord, there is a interim order was in post. Interim order was in post, my lord, not to remove. But
You are
not
continuing, is it?
It is modified.
Notwithstanding the
Interim
interim order
modified.
passed by the Assam court, they are not allowed me to continue. In fact, he is entitled for back wages also, but for that reason. But he is not allowed in spite of the order passed by the Assam. Writ appeal ಅಲ್ಲಿ pending ಇದೆ. That's why.
Contempt ಆಗ್ಬೇಕು. The ಎಷ್ಟು petition ಇದೆ ಇದು?
Lord, the second case, Lord, the labor court, Lord, he had Lord, filed, Lord, section 10 petition, Lord, before the labor court. So labor court, Lord, dismissed, Lord, the petition.
ಅದನ್ನ
Lord,
challenge ಮಾಡಿದಾರಾ?
ಬೇರೆ ಕೇಸ್ ಇದೆ in fact.
ಅಲ್ಲ 66.1 ಇದೆ ಇಲ್ಲೊಂದು. What is that?
The labor court order, Lord, same Lord, GVP ne, but
ಅದು will delink this.
Delink
Let it go before the regular court. Delink 66.1 post the matter before the bench having roster. The petitioner, ಇದು 66 ಮಾತ್ರ. The petitioner is before this court seeking the following prayer. Heard so and so. The petitioner is appointed as a Grama Vidyut, ಏನಿದು?
Grama Vidyut
Grama Vidyut Pratinidhi, GVP for short. His services come to be terminated on account of certain misconduct. The coordinate bench of this court, in identical circumstances, considering the termination orders passed by the respondent corporation on against several employees, in terms of its order dated 31st August 2020, disposed the petitions by the following order. Page 67, 68. The order so passed was tossed by the corporation before the division bench. The division bench, in terms of its order dated 24th January 2025, has not disturbed the findings qua the termination orders on stigma. The foundation for passing the order of the learned single judge, insofar as it depicts stigmatic removal, is found in clause H of the order of the learned single judge. It reads as follows. Eager. Extract number 2. Illi. Aita? This is extract number 1. This is extract number 2. The coordinate bench clearly holds that that on stigma, without notice or without opportunity of hearing, the services of those petitioners could not have been dispensed with or terminated. The petitioners in the case at hand are similarly circumstanced. Their orders of termination is dated 2nd August 2024. The order
2021, my lord.
2021. The order reads as follows, page 1450. The order, perusal at the order would clearly indicate that it does cast stigma upon the employee. Therefore, the finding rendered by the learned single judge quoted supra would become applicable to the case at hand as well. The division bench has not disturbed the said finding at clause H, which speaks of stigmatic removal of the GVPs. The petitioner similarly placed is entitled to a similar order at the hands of this court. The learned counsel V.S. Kamte submits that the notice as observed by the learned single judge is already issued to the petitioner, and the petitioner has failed to appear before the competent authority to submit his explanation even. Be that as it may, the order quoted supra undoubtedly casts stigma, which could not have been passed without at the outset issuance of notice and rendering an opportunity of hearing. In that light, the petition deserves to succeed, albeit in part. The order said so and so stands quashed. The respondent shall issue a notice to the petitioner seeking to show cause as to issue a notice to the petitioner upon notice to the petitioner's Asako. The petitioner shall submit his reply to the said notice, and the proceedings be taken to its logical conclusion by the respondents. All consequential orders would depend upon the orders that would be passed as directed herein above, ordered accordingly. Yes.
But he is not in service from to the 2021. Plus.
89, Saurabh Sandhu, SM Chronic.
On all these matters, may I submit one synopsis?
ಏನಪ್ಪ ಇದು? Tender. ಕೊಡಿ.
That's what has happened is this was a tender for construction of canal work. If your lordships could kindly take for a moment annexure G, starts from 236.
Amount is withheld, is it?
10% of the bill amount is withheld.
Why?
On the ground that I should have collected 10% of the cost of the work from the beneficiaries of the project.
What is the tender condition?
Tender condition, that is why 247 page number, if your lordships could kindly take in the first petition. Page 247.
First petition for 902.
Allah, 2554.
I filed objections in 105732. If may request to take that.
Objections ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ
2554. Page 247.
ಅದು ಬಂದ್ಬಿಡ್ಲಿ objections.
5732. 8.89.9. 105732. ಹಾಕಿದ್ದೀನಿ.
Common stand. Their only contention is that there is 6 years delay in completion of work.
That only that.
That has been condoned by extension. In page 247, if your lordships could kindly take in 2554, note number 1. Note number 1 anta ide kelage. As per revised order.
ಯಾವ petition ಅಲ್ಲಿ sir?
2554. 2554. 247 page number. Note number 1. As per revised government order of Government of India dated so and so, the beneficiaries of the project have to borne 10% of the total cost of work. Therefore, successful contractors have to arrange collection of 10% of work cost from the beneficial and to remit the same to the Nigam before commencement of the work. Now, this 10% of the work, which the 10% of the cost which they seek to impose is nothing but the betterment charges, which is governed by Karnataka Levy of Betterment Charges Act of 1957. If your lordships could kindly take the synopsis, I have produced that act. Act provides an elaborate procedure. There has to be appointment of betterment levy officer who should notify what are the rates at which amount is to be collected. And ultimately, if those beneficiaries don't pay it, that is to be recovered as a land revenue arrears.
No. What is this 12/1/2009 government order?
That is the corrigendum which was issued.
How do you say this betterment charges?
There is no other basis as otherwise for them to impose this. There is no other basis. 10% of the charges, because adike on ಸ್ವಲ್ಪ if that act is taken, if your lordships, betterment charges are defined there.
1 minute. Yes, sir. What is this?
My lord, may I just take your lordship attention to note number 1, wherein this is of government of India, central government regulation, which was imposed as a part of this tender condition.
ಅದನ್ನೇ ಕೇಳಿದ್ದೇನೆ 12/1/2009 ಏನದು?
It is by the central government, my lord.
Where do you get that?
My lord, this is issued by central government of.
As per revised order of Government of India, date 12/1, the beneficiaries of the project shall have to borne 10% of the total cost of work. Betterment charges ಅಂತ ಯಾರು ಹೇಳಿದವರು ನಿಮಗೆ?
There is no other basis as at all apart from this one provision.
ಆಮೇಲೆ
that is why
this is what tender condition.
But the tender condition does not say that if the 10% is not collected, amount will be withheld from our bills which are payable. That is why, my lords, what I am submitting is, if your lordships could kindly take page 25 of the synopsis. Betterment charges are levied on the person whose land appreciates because
not betterment charge, sir. It's your imagination that it is betterment charge, not a betterment charge. How is betterment charge levied?
That is why. Section 4, if your lordships could kindly take. Amount of betterment contribution. Adrakina, section 3, levy of betterment contribution. There shall be levied a tax called betterment contribution in accordance with the provisions of the act from the landholder or the holder of any land which is benefited by construction, restoration, expansion or alteration of any work by the government, whether after the commencement of this act or at any time before commencement, but not earlier than so and so. This is Karnataka Irrigation Levy of Betterment Charges Act. Irrigation work madidale where the property value enhances. There they impose this 10% as a betterment charges. Adikke section
Government of India ellide gottilva?
Notification even they have not produced.
Central government has to answer it.
Central government is a party here?
No, central government is not a party.
Amount is withheld by KNNL.
ಆಯ್ತು, ಅದು ಯಾವ್ದ್ರಿಂದ ಅಂತ ಹೇಳಿದಾರಲ್ಲ.
Funds ಅಲ್ಲಿಂದ ಬಂದ್ರೆ the conditions imposed by the central agency is to be incorporated in the tender condition. And it's from the year 2010, my lord. It was before tender negotiations. It was before bid, way back in the year 2010. He participated in the bid inquiry.
Why did you accept this, sir?
He voluntarily accepted it.
Yes, I have accepted. I have performed my condition. If your lordships could kindly imagine a canal.
So why did you accept that 10% is to be paid at the time of accepting the tender?
Allah, it is not to be paid by me. They say I have to collect it from the beneficiaries.
Whatever it is, why did you accept that condition?
Allah, even assuming for a moment, my lords. Allah, even if that condition is valid, how is that condition to be carried out by me? Where is the guidance for that? If your lordships could kindly see.
ಯಾಕೆ ಕೇಳಲಿಲ್ಲ ಅವರು ನೀವು?
Allah, that is why this act comes into picture. Unless they notify all these things, they cannot say that I should have collected.
Why did you accept, sir?
Allah, if your lordships could kindly appreciate on this.
It is a contract.
Yes.
That's an offer.
That is why that is also challenged.
That's a contract. It's an offer. You have accepted. The consideration is what the tender conditions are.
Yes.
One of the tender conditions is this. In a contract where there is an offer and acceptance, where is the interpretation with regard to bringing in some other enactment which you yourself not said?
One submission. They have not even taken a stand as to what these charges are. That is the whole issue in the statement of objections.
Yes, sir.
Next, on this count.
What charges, sir?
Well, these are the charges as levied under clause note 1. 10% of the charges.
Clause 2(1), which is that? ಈಗ ಓದಿದ್ದ?
247, page 247.
ಈಗ ಓದಿದ್ದ?
Please, my lord. On that count, he had already approached this honorable court to make a endorsement or consider this case. Thereafter, endorsements are issued, which is challenged before this honorable court now.
Which is that?
Page 252, annexure H is the writ petition that was to consider representation to pay the amount. Beyond all this, annexure L 262, if your lordships could kindly see. 262. One sarti adon nodi bidi swami.
Yes.
There the chart is there. 262. Guttige oppanda prasanke so and so. Then Guttige motta. Next, fourth column. ಗುತ್ತಿಗೆ ಒಪ್ಪಂದ ಪತ್ರದಲ್ಲಿ ರೈತರ ವಂತಿಗೆ ಕಡಿತಗೊಳಿಸಲು ಕರಾರು ಇದೆಯೋ ಇಲ್ಲವೋ? ಇಲ್ಲ. ನೋ ಕಂಡೀಷನ್. ನೆಕ್ಸ್ಟ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್. ಟೆಂಡರ್ ನಲ್ಲಿ ರೈತರ ವಂತಿಗೆ ಕಡಿತಗೊಳಿಸುವ ಕರಾರು ಇದೆಯೋ ಇಲ್ಲವೋ? ದಟ್ ಈಸ್ ವೆದರ್ ಅಮೌಂಟ್ ಇಸ್ ಟು ಬಿ ಡಿಡಕ್ಟೆಡ್ ಮೈ ಬಿಲ್ ಫ್ರಮ್ ಮೈ ಬಿಲ್ ಆರ್ ನಾಟ್, ವೆದರ್ ಕಂಡೀಷನ್ ಎಕ್ಸಿಸ್ಟ್? ನೋ. This is how the chief engineer writes, seeking guidance on whether I should deduct the bill or not, because there is no such condition in their contract anta. And in my humble submission, this squarely covered by one of the decision of the apex court. Yes. In my synopsis, if your lordships kindly take.
Page.
Yes, my lords, page number 65.
Uniteka.
Alla UP Power Transmission Corporation Limited. Page 65. Para 44. Para 44. The High Court accepted the submission of respondent number 1 that absence of levy and assessment under Cess Act and the rules made thereunder, the letters of UPP TCL were not sustainable in law. Cess could only be recovered in manner stipulated in the Cess Act and rules framed. The High Court observed that if cess were leviable under the Cess Act, it would be necessarily for the authorities concerned to take the exercise of assessment and levy of Cess Act as amended, so and so. High Court found that in absence of any order of levy and assessment under the Act, recovery could not be made pursuant to audit objection of CAG. Next, there does not appear to be any provision in the first contract, second contract, third contract, or fourth contract, or in special condition of contract or GCC for supply of plant so and so to withhold any amount from the bills raised by the respondent on UPPTCL towards any taxes, cess, or any other statutory dues to the contractor. Nor has the UPPT.
That is statutory dues. What is this? What is 10? What is the 10%?
When I tried to take out the circular which is mentioned therein by the issued by government of
objections hakidira.
Hakidin.
No stand is taken regarding what is that charges. Nothing.
It's a contract.
It's a
understood.
It's not a statutory charge at all.
If your lordship could kindly see the prayer, I have also impugned this.
It may be compulsory exaction on the contract, but not.
Only issue is this, my lords, whether they can recover it from me unless there is a condition in the contract.
It's a condition in the contract.
Unless recovery is condition in a contract.
No, recovery, there not be explicit clause with regard to that, my lord. And moreover, my lord,
this is not a statute, sir. It's a tender document.
My only submission is this, my
lord.
lord.
My friend is telling that it takes the color of its cess. If it was really a color of cess, it would have not been put in a note. It would have been.
What is it? What is the amount of 10%?
Even I tried to take out.
10%, why is it withheld?
That is in terms of the circular issued by the government of India. I could not trace out that particular.
It's all right. Now 10% madid yake?
The logic of the percentage is even fixed in that circular. It is not the.
Sir, what is that 10%?
The word used is, my apologies for not assisting the court by and large, but the word used is only the work. Not for what object it was put for 10% is not disclosed therein.
What happens is, my lords, when there is irrigation work, 40% of the cost is supplied from the central government. 50% cost is supplied from the state government. 10% they should recover it from the beneficiaries as a betterment charge. How the betterment charge? There is nothing else. Or else there is no provision of law which authorizes such. And lordships may kindly appreciate this. Corrigendum is also challenged as being repugnant to this act. How my prayer is to.
You accept everything, sir.
If your lordships could kindly appreciate one aspect.
Purely on contract.
Kindly appreciate one
accepted
aspect.
the terms of contract, you can't now turn around.
Kindly appreciate one aspect. What happens is, a canal passes through, say, 10 fields. From whom I should collect how much of amount? There is nothing, no guidance at all.
Why did you accept a tender that was so
Yes.
nebulous?
Yes, that is where this act comes into picture. That is
According
where
to you, it comes into picture. Why did you not raise that then itself?
the only expectation.
Work ಎಲ್ಲ ಆಗಿ ಎಲ್ಲ ಆದ್ಮೇಲೆ ಈಗ ನಿಮ್ಗೆ ಹೊಸದಾಗಿ
And even the condition says before commencement of work we should remit. Now after completion of work they want to deduct it.
Before commencement of work, you have not remitted.
Yes, we have not remitted.
So they have withheld 10% in terms of
Whether
the
I am
contract.
liable to pay that whole amount is the issue. And what is the nature of this amount unless that is brought on record? How its validity could be decided?
No, sir, nothing. Contract.
And I do appreciate, my lords, it is contract. Even in the judgment which I have quoted.
You should not have.
Yes, yes. Even in the
done that at
judgment
all.
which I have
You
quoted
should
of the
not
apex.
accepted that condition in the tender.
Even in the judgment.
Pre-bid meeting, he did not raise it. He would have qualified at that time, in the year 2010 itself.
Even in the judgment of apex court which I have quoted, there also this tender condition existed. Still the apex court said, though there may be that condition,
So that was
but
the
there
issue of
is.
cess, my lord, sir.
No, that is cess under the cess act.
Yes.
ಇಲ್ಲಿ betterment ಅಂತ ಏನಿಲ್ಲ under the betterment
Aitu,
act.
cess aitu, betterment aitu, condition exists in the contract. Therefore, I cannot go beyond this. But the question is whether they have right to withhold this amount from my bills. Clause 3, clause 4 are the only clauses under the
ಯಾಕಂದ್ರೆ you have to
contract.
comply it even before the commencement of work.
Clause 3 and clause 4 under the contract are the only grounds on which amount can be withheld. Bill amount can be withheld.
This is a condition of tender, sir, already.
Condition of tender, but not for recovery. That is my whole submission.
Recovery ಎಲ್ಲ ಅಲ್ಲೇ ಇರಬೇಕು ಅಂತಿಲ್ಲ.
Or else they'll have to take a stand. What is this 10%?
ಕಷ್ಟ ಸರ್. Contractual difficult.
ಅಲ್ಲ.
If you're regulated under a statute, it's a difficult.
Your lordships may kindly appreciate the absurdity. Why I'm saying this is.
Why did you take it?
It is not just me.
There
my
is
lords,
no
there are-
estoppel against a statute, understood, not against this contract.
As far as the contract is compliant with the act, my lords, yes. So long as it is non-compliant with the provisions of the
Why
act.
you should have challenged it long ago, sir.
And even if your lordships could kindly appreciate, collection of these amounts is an executive duty which they cannot delegate upon a tenderer.
Anything else? Sovereign function.
Let them take a stand on this. That is what I am
No,
submitting.
no,
my
no,
lords.
I will not pass an order, let this state take a stand, and I will take my stand.
My only submission is this, unless this is appreciated what it is. This 10% of the betterment contribution.
It's a part of the contract. Judgment alli cess, the word cess existed.
Yes.
Cess can be levied only under the Cess Act. Cess Act itself had recovery measures in it. So Supreme Court says that could not have been withheld because Cess Act is a separate enactment. What was collected, to be collected in the tender was a cess. Illi language ಏನilla ಇಲ್ಲಿ.
Apart from this 10%, how, what is the, under which provision this is being levied? Nothing is there on that regard.
Oh, sir. The petitioner is before this court seeking the following prayer. The prayer in all these cases are identical, as the issue projected before this court is also identical. The petitioners in all these cases are participants, heard so and so. The petitioner, facts in brief, germane are as follows. The petitioner and others are participants in a tender notified by the Karnataka Niravari Nigam, the hereinafter referred to as the Nigam for short. A tender notification is issued on 15/2/2010. The petitioners emerge in the tender as successful tenderers and the work order is issued to them. The work is executed and at the time when amount had to be paid to the petitioners, 10% is withheld on account of the condition of tender. The petitioners aggrieved by the withholding of 10% of the amount by the respondent are before this court in the subject petition. The learned counsel Saurabh, right?
Yes.
Saurabh Sundar, appearing for the petitioner in all these cases, would vehemently contend that the condition in tender which imposes payment of 10%, a recovery of 10% from the beneficiaries of the project and to be remitted to the Nigam cannot but be construed to be a betterment charge. If it is construed to be a betterment charge, it is the recovery of amount should be only under the act.
Karnataka Irrigation Levy of Betterment Contribution. And
Para
what?
20 of the petition.
So and so act. The learned counsel would further submit that the petitioners, though have accepted the conditions of tender and have participated in the tender, the recovery is not the mode, one of the mode that is recovery by withholding of 10% is not one of the mode by which the tender condition could be, by which the amount could be recovered from the hands of the petitioner. He would submit that if it is construed to be a betterment charge, it shall be only in terms of betterment, in terms of the act which is to be recovered as arrears of land revenue. He would seek to place reliance upon the judgment of the apex court in the case of UP so and so. Let's synopsis. UP Power Transmission Corp. 2021 6 SCC page 15 to buttress his submission that the amount should be recovered only by way of by the method prescribed under the statute, i.e. the act, and not withholding of the amount that is payable to the petitioner. The learned counsel appearing for the respondent would submit that the condition of tender was made known to the petitioner even in the pre-bid meeting. Knowing full well the petitioner accepts the tender, accepts the contract, performs the contract, and after the performance of the contract is now before the court challenging the said clause on the score that there is no method of recovery in the tender condition, in the recovery in the tender document, and therefore it has therefore the recovery cannot be made. The learned counsel submits that the condition was that it even before the commencement of work 10% ought to have been deposited to the Nigam. That had not been done even after completion of work. Therefore, there is no choice but to withhold the amount of 10% in the bills that are to be paid to the petitioner. The afore narrated facts, I have given my sounds. The afore narrated facts are not in dispute. All these petitioners are successful tenderers who have secured work order at the hands of the petition, at the hands of the respondents. The issue is not with regard to the quality of work or otherwise. Which is that tender condition?
Page 247.
The tender so invited by the respondent to which the petitioner applied and secured the work order had a condition. The condition was a postscript by way of a note. The condition reads as follows. The condition is indicative of the fact that as per the order of the Government of India, the beneficiaries of the project have to bear 10% of the total cost. Therefore, successful contractors will have to arrange the collection of 10% of the work cost from the beneficiary and remit the same to the Nigam before commencement of work. The work commences, work in terms of the work order issued to the petitioner commenced on 6/8/2010. Sorry, 10/12/2010. The work also gets completed. Sorry, 21/12/2010. The work gets completed and the deduction has happened on the score that it is a tender condition which the petitioner has accepted and participated in the tender, executed the work. In fact, as a tender condition, the before commencement of work 10% ought to have been deposited before the Nigam, which was to be paid to the beneficiaries of the project. Which is paid by the beneficiaries of the project. The amount is not not recovered from the beneficiaries of the project before commencement of work. Therefore, the gap is 10%, as 40% is funded by the Government of India, 50% by the state, and 10% comes in the manner that is depicted here in above. The petitioner participates in the pre-bid meeting is not in dispute. The petitioner accepts the offer, not in dispute. The petitioner executes the work, not in dispute, but does not remit 10% of the total cost of the work by recovering the same from the beneficiaries of the project. This failure on the part of the petitioner or the successful tenderer has resulted in 10% withholding of 10% from the hands of 10% in the bills that are to be paid to the petitioner. The learned counsel for the petitioner tries to bring in bring in the provisions of the act to contend that except this there cannot be any name rendered to the 10% withholding of 10% of the amount. The said submission is unacceptable as issue between the two is a matter of contract. The petitioner, with eyes wide open, participates in the pre-bid meeting, does not point a finger at the 10% amount that was a condition in the tender. They accepts the tender in the teeth of the said condition, secures a work order, completes the work all 15 years ago, and today points a finger at the respondent that the 10% that they have indicated in the tender document as a tender condition is a betterment tax, and that the betterment tax has to be recovered in terms of the aforesaid act. The submission of the learned counsel of the petitioner, as observed here and above, does not merit any acceptance in the light of the issue being contract between the parties. If the contracting parties have agreed to certain terms and conditions, this court, though the contracting party is a state under Article 12 of the Constitution of India, this court would not step in and interpret the contract or telescope its imagination to the fact that the 10% levy can only be a betterment tax and nothing else. If it were to be emanating from, if the charge was emanating from any statute, it would have been altogether a different circumstance. The learned counsel for the petitioner seeks to place reliance upon the judgment of the apex court in the case of UP so-and-so. The said judgment is distinguishable to the facts obtaining in the case at hand without much ado, as the facts before the apex court was the indication of a cess in the tender document. Cess admittedly was regulated under the Cess Act of Uttar Pradesh, of the state of Uttar Pradesh. Therefore, the indication of cess was clearly relatable to the Cess Act. The apex court therefore says cess cannot be recovered by withholding the amount from the hands of the petitioners. In the case at hand, there is no statutory payment that is sought to be recovered from the hands of the petitioner. The amount that is indicated was in the contract. It is in the contract, and on account of default of the petitioner of not making good the payment before the commencement of work, the respondent has withheld the amounts after the completion of the work. In the matters of contract, this court would not step in and annul the action of the respondent, leaving open all the remedies available in law to these petitioners without interfering with the impugned order. The impugned action, the petition stands disposed.
Please, obliged.
These petitions stand disposed.
Seek for individual orders.
ಆಯ್ತು, separate orders ಮಾಡ್ಬಿಡಿ ಎಲ್ಲ. ಈ ತರ ಮಾಡ್ತೀನಿ ಸೌರಭ್, ಇದರಲ್ಲಿ ಫಾರ್ ದ ರೀಸನ್ಸ್ ಇಂಡಿಕೇಟೆಡ್ ಇನ್ ದಿ ಆರ್ಡರ್ ಸೋ ಅಂಡ್ ಸೋ
ಪ್ಲೀಸ್
ಡಿಸ್ಪೋಸ್ ಅದು ಸಪರೇಟ್ ಆರ್ಡರ್ ಇರುತ್ತೆ. ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿ, ಮಿಕ್ಕಿದ್ದು ಫಾರ್ ದಿ ವೆರಿ ರೀಸನ್ಸ್ ಇಂಡಿಕೇಟೆಡ್ ಇನ್ ದಿ ಆರ್ಡರ್ ಇನ್ ಪಾಸ್ ಅಂಡ್ ಸೋ ಅಂಡ್ ಸೋ the subject petitions are also disposed with the same observations made.
Please.
Yes.
Note 8, Rajshekhar Burji, DM Bandi.
This matter was heard for some time, my lord. Petitioner is, my lord, seeking, my lord, time-bound increment, my lord, for service rendered, my lord, for the period of 25 years, my lord, without there being any promotion.
Yaar, madam.
Mr. Dayanand Bandi.
ನೀವೇನಾ?
ಅಲ್ಲಲ್ಲ. He was working, my lord, with the
230 ಮೂಡ್ ಮ್ಯಾಟರ್ ಬಂದಿದೆ ಮೇಡಮ್.
Yes.
ಹೇಳಿ.
Lord, petitioner, my lord, was working, my lord, with the respondent number 4, my lord, office, my lord, and he retired on 31/8/2012. My lord, he was working as a first division assistant, my lord, and on 4/3/2008, my lord, he was promoted as a superintendent, my lord, by the first respondent. My lord, since, my lord, his wife was suffering from brain hemorrhage, my lord, he made a request to the department, my lord, saying that, my lord, since his wife is working, he's suffering from brain hemorrhage, and in pursuance of the promotion, my lord, he was transferred to Belgaum to Dharwad, my lord. So he requested, my lord, to requested them to permit him to continue in the same post, my lord, and thereafter, my lord, his request was also forwarded to the department also, my lord. Now, my lord, on 31/8/2012, my lord, he came to
Respondent till urban water supply. ಯಾರು ದಯಾನಂದ್ ಬಂಡಿಯ?
ಹೌದು, ಅವರೇ ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕು.
ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅಷ್ಟೇನಾ? ಇಲ್ವಲ್ಲ?
ಇಲ್ಲ, ರಿಪ್ರೆಸೆಂಟೇಷನ್ ಇಲ್ಲ. They have passed an order saying that you have denied the promotion, therefore you are not entitled. Annexure A, my lord, is the
import ನೀವು ಬೇಡ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ?
ಅಲ್ಲ, there, my lord, we have requested them, my lord, saying that since because of the health condition, I have requested them to consider it in the next promotion care.
Next promotion is ರಿಟೈರ್ ಆಗ್ಬಿಟ್ರಾ?
ಅವಾಗ ನಮ್ದು ಕನ್ಸಿಡರ್ ಮಾಡಲಿಲ್ಲ. All of a sudden, my lord, they cancelled my promotion, my lord, in the year 2012, whereas the promotion was, my lord,
2013.
ಹೌದು, endorsement after retirement, my lord, endorsement is
matter on Friday in fresh matters list.
Please
ಖಾಲಿ ಮಾಡಿ.
Please.
Note 9, Srivatsa S. Hegde, BS Kamte.
ಇದು 13.
Yes, my lord.
Yes, sir.
The petitioner, my lord, is aggrieved by the endorsement dated 7/11/2013, stating that an amount of rupees 10,000 would be deducted from his salary towards ESCOM, my lord.
Inquiry ಮಾಡಿಲ್ವಾ?
Inquiry, my lord, several notice, my lord, I filed detailed objection statement, my lord. Several notice, my lord, I think this will be an exceptional case, my lord.
Exceptional case.
No reply and no regularization, my lord, no steps were taken to return the materials. And 2-3 times, my lord, he has committed a mischief, my lord, in the,
No,
he
my
was
lord.
working.
The
Several notices were given.
inquiry found that I am liable to pay sum of 82,012 rupees.
Where is that? Page.
Lord,
Page.
Annexure E, page 14, my lord.
Where is the finding?
Kindly see, my lord, page number 58.
14 ಇಂದ 58 ಹೋಗ್ಬಿಟ್ರಿ?
ಇಲ್ಲ, sorry.
ಹಂಗೆ ಇರೋದು ಅದು? I am at 58.
ಪೇಜ್ ನಂಬರ್. ಆದ್ದರಿಂದ ಕಂಪನಿಗೆ ಆದ ಆರ್ಥಿಕ ನಷ್ಟ 9,86,898 ಹಾಗೂ 69 ಪೈಸೆ ಮಾತ್ರರಲ್ಲಿ ಈಗಾಗಲೇ ವಸೂಲಿ ಮಾಡಲಾಗಿರುವ 82,012ಗಳನ್ನು ಕಳೆದು ನಿಮ್ಮ ವೇತನದಿಂದ ಮುರಿದುಕೊಳ್ಳಬೇಕಾಗಿರುತ್ತದೆ.
ವಸೂಲಾತಿ ಮಾಡಬೇಕಾಗಿರುವ ಕಂಪನಿಗೆ ನಷ್ಟ ಸೋ ಅಂಡ್ ಸೋ ಮಾತ್ರ ಅಲ್ಲಿ ಈಗಾಗಲೇ ವಸೂಲಾತಿ ಮಾಡಲಾಗಿರುವ 82ಗಳನ್ನು ನಿಮ್ಮ ವೇತನದಿಂದ ಮುರಿದುಕೊಳ್ಳಬೇಕಾಗುತ್ತೆ. ಎಷ್ಟು ಮುರಿದುಕೊಂಡಿದ್ದಾರೆ ಈಗ?
ಈಗ 10,000 rupees ಪರ್ ಮಂತ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಬಟ್ ದಿಸ್ ಹ್ಯಾಸ್ ನೋ ಬೇಸಿಸ್, ಮೈ ಲಾರ್ಡ್. ದಿ DE ಫೌಂಡ್ ದಟ್ ಐ ಆಮ್ ಲಯಬಲ್ ಟು ಪೇ ಓನ್ಲಿ 82,012 rupees.
ಈಗ 82,000 ರಿಕವರ್ ಮಾಡಾಯ್ತಾ?
ಆಗಿದೆ.
ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ ಟೋಟಲ್ ಆಗಿ?
ಈಗ now they say that there is a balance of 10,98,000 rupees.
ಅದ್ಯಾಕೆ ಕಾಮಟೆ ಸರ್?
For that, my lord, he relies upon, I'll take, my lord, to the contention in the statement of objection.
ಈಗ ಇದು ಎನ್ಕ್ವೈರಿ ರಿಪೋರ್ಟ್ ಅಲ್ವಾ? Page 57 ಏನು?
This is the notice, my lord, for making payment, my lord, actually by him, my lord.
ಅಲ್ಲ ಸರ್.
Pursuant to the, my lord,
Page 57 ಏನು?
Lord, 57, my lord, your lordship kindly see, my lord, the annexure F.
ಅದೇ ಅಲ್ಲೇ page 57 ಆದ್ದರಿಂದ
Notice, or this is notice pursuant to, my lord, the inquiry proceedings concluded, my lord, actually. He has not questioned those proceedings.
It's all right, sir. ಈಗ ಎಷ್ಟು liability fix ಮಾಡಿರೋದು ಎಷ್ಟು?
ಇದನ್ನ ನಾನು ಓದ್ತೇನೆ. ನೋಡಿ,
ಇಲ್ಲ liability fix ಮಾಡಿರೋದು ಎಷ್ಟಿದೆ?
Exactly, my lord. Actually, your lordship kindly see, my lord, the upper portion of the, my lord, the.
ಅದರ ಬಿಟ್ಬಿಡಿ ಸರ್, ಈ portion ಗೆ ಬನ್ನಿ.
ಅಲ್ಲ, ಇಲ್ಲಿ ಮೇಲ್ಗಡೆ ಏನು ಒಂದು ಪಂಚನಾಮೆಯಲ್ಲಿ ಕಂಡು ಬಂದ ಕೊರತೆಯ ಸಾಮಗ್ರಿಗಳು, my lord, one portion, my lord, one paragraph, my lord, he has left out, my lord. ಮೌಲ್ಯ 27,95,000 ಹಾಗೂ ಹೆಚ್ಚುವರಿ ಸಾಮಗ್ರಿಗಳ ಮೌಲ್ಯ 10,04,591 ಕುರಿತು ಒಂದೇ ಬಗೆಯ ಸಾಮಗ್ರಿಗಳು ಹೊಂದಾಣಿಕೆ ಮಾಡಿ ನಿವ್ವಳ ಕೊರತೆ ಮೌಲ್ಯವು 10,08,10,000 ಮಾತ್ರ ಉಳಿದಿರುತ್ತದೆ. ವಿವರಗಳನ್ನು ತೋರಿಸುವ ತನಿಖೆಯಲ್ಲಿ ಪತ್ರಕ್ಕೆ ಲಗತ್ತಿಸಲಾಗಿದೆ. Then, my lord, the operative portion he has read it, my lord. So 9 lakh.
Against how many the allegation was, or only you?
Yes, my lord.
Yes, ಅಂದ್ರೆ
My lord.
ಎಲ್ಲ ಎಷ್ಟು ಜನದ ಮೇಲೆ ಇತ್ತು? ಎಲ್ಲ ಬರೀ ನಿಮ್ಮ ಮೇಲೆ ಇತ್ತು?
I was the lone person, my lord.
Lone person.
Yes. Now, I will take, my lord, to.
If you are the lone person, then 82,000 ಅಲ್ವೇ ಅಲ್ಲ.
Allah, my lord, kindly see page number 6 of statement of objections. What is stated is, I will just take a minute, my lord. Thereafter, inquiry was concluded and the order dated 15/7/2009 was passed, stating that rupees 82,012 to be recovered for shortage of materials from the salary of petitioner and to withhold 2 annual increments. The chief engineer, electrical O&M zone Behescom Belgaum, as per his letter dated 27/8/2013, opined that the order dated 15/7/2009 is not in order and the same has to be withdrawn and proper steps to be taken to pass final order for the excess and shortage found during the year 2005. The true copy of the same is herewith produced at Annexure R15.
Yes, sir.
Then another notice was issued, my lord. That was not the, there was no proper.
ಕರೆಕ್ಟ್ ಆಗಿ ಏನು ಮಾಡೋದೇ ಇಲ್ವಲ್ಲ?
ಇಲ್ಲ, ಇದರಲ್ಲಿ, my lord, actually the action was taken, my lord, after issuing notice, my lord. Several times notice were issued right from 2007. Lord, I have, lord, filed detailed object statement.
We'll take it on Friday. It's on Friday in the fresh matters list.
Next week, my lord.
Next
Friday ತುಂಬಾ cases ಇದೆ.
Next Friday.
Next, please.
Next Friday ನೇ ಹೇಳಿದ್ದೆ, 7th. 7th is next Friday.
7th, please.
2:30 ಮೂಡ್ ಮಾಡ್ರಿ. ಏನು ಇಷ್ಟೊಂದಿದೆ?
Mood list.
20 matters.
Number 1, Sridhar Prabhu.
This matter, my lord, is.
Copy ಕೊಟ್ಟಿದ್ದೀರಾ?
ಹೌದು, ಕೊಟ್ಟಿದ್ದೀನಿ. ಅವರು ಶಾಬಾಜ್ ಹುಸೇನ್ appears, my lord. And
Your
in
Lordship, I appear for respondent number 3 and 4 on behalf of Shahbaz Hussain in this matter, Your Lordship.
identical matters, interim orders have been passed. I have served a copy on the other side also.
ಅದು entry ಮಾಡೋ ಕಾಪಿನ ಕೊಟ್ಟಿದ್ದೀರಾ?
Yes, yes. He knows, my lord. We have, there are 20 such matters, my lord, which.
Tag the petition along with so and so. Learned counsel same ಇಲ್ಲೇ ಹಾಕಿದೆ.
Page.
ಯಾರ್ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗಿದೆ?
He appears, my lord, for
3 and 4, Your Lordship.
Shahbaz
Respondent
Hussain
number-
for 3 and 4.
Yes.
2 BN Prakash.
ಅಲ್ಲ, ಅದು that is, my lord, lordship may see, ನಾನು ಹೆಸರು ಕೊಡ್ತೀನಿ ಸರ್. BN Prakash doesn't appear for KPT.
ಎಲ್ಲಿ ಕೊಡಿ, ನಾವು ಏನು
ಅಲ್ಲ, ಕೊಡ್. BN Prakash ಅಂತಾನೆ ಹಾಕಿ. I'll serve the copy.
BN Prakash 2, 3 and 4 Shahbaz Hussain. 5 ಏನು?
Yes, 5, my lord, is I'll give the names. 2 names I'll give.
ಎರಡು ಕೊಡ್ಬೇಕು.
Yes, 2
ಇದರಲ್ಲಿ ಏನಿದೆ?
2 and 5 I'll give the names.
Same order. Next.
Till number 2, BN Mulimani.
Great.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ? Guest lecturer. List tomorrow, fresh matters list. Saurabh.
Till number 3, Saurabh.
Oh, ಇದೇನಾ 2:30 ಮ್ಯಾಟ್ರು? Saurabh Hegde. Withdrawal.
ಅಲ್ಲ, withdrawal ಗೆ ಏನು ತೊಂದರೆ ಇಲ್ಲ, but facts will narrate.
Lord,
The petition before my lord is alleging violation of Rule 14R, my lord, of the Karnataka Cooperative Society's rules, wherein secrecy of the ballot paper should have been maintained. And what happens here is the returning officer prints such ballot papers which contain the serial number on the ballot paper as well as on the counterfoil. Now, the allegations, reported allegations are, my lord, that there has been widespread horse trading, and therefore the identity of the voters has been compromised.
Right, we'll consider it.
My lords.
Copy kotilva?
My lords, it is a
Copy
dispute.
kotilva?
Copy kotiyaru. My lords, it is a dispute, my lords.
Ah.
Yes, my
Election,
lords.
my lord.
Election is over, my lords.
Oh,
There is
before
a
the-
dispute.
I will not examine.
Results are not announced, my lord. But then, my lord, yesterday, my lord has entertained a petition and
You know,
ballot papers were summoned, my lord.
ballot papers were
Adu,
summoned.
that is different matter, my lords.
ಯಾವ್ದ್ರಲ್ಲಿ ballot paper summoned?
It's not a related case, my lord, but in such a situation.
I have not passed any order of ballot paper summoning till now.
This is a dispute regarding.
Oh, how can I sit and examine everything, sir? It needs evidence.
Now, the thing is, my lord, this has been seriously compromised. The returning officer.
Sir, you challenge it.
Now, the jurisdiction of the registrar would be extending only to the disputes between the members and the employees, my lord, not the returning officer.
Election.
Election,
petition
election. My lords. That is dispute, any dispute regarding
There
election.
won't be an election petition before, my lord, the registrar of cooperative
Allah,
societies.
any dispute concerning elections,
Please.
we will direct the registrar to go into these allegations also and examine it.
Now, the reason why I was raising an objection for withdrawal of that petition is, my lord, because the withdrawal would pave the way for declaration of results tomorrow.
No. Several repeats.
Now, with the kind of interim order obtained by them, I was asked to, cast my vote, and that has been preserved in a separate ballot box.
That will be taken note of.
Now, the thing is, my lord,
ಸೇರಿಸ್ಬಿಟ್ಟು ತಗೊಂತಾರೆ ಈಗ.
no, my lord, since this is violation of the rules directly and admittedly, my lord,
You challenge everything before
Yes.
the registrar. Section 70.
Please.
the time frame may be fixed, my lord. I would be presenting an election petition, there was no sooner the results are announced.
Cooperate ಮಾಡಲ್ಲಲ್ಲ?
ಇಲ್ಲ, ಅವರು they wanted to withdraw, apprehending, my lord, that there was going to be an order here.
Yes. Order here for what, sir?
No, they were apprehending that ballots could be summoned for, and that would be, yes, that was their apprehension.
Ballot summon ಮಾಡಿದ ಏನ್ ಮಾಡೋದು?
Allah, that was their apprehension.
No.
Heard
And
the
my
Senate
hope.
counsel appearing for the petitioner. First ಅದೆರಡು withdraw ಮಾಡಿ. 46, 47.
My lord, with a direction to result the result, my lord. My lord, several petitions were pending, my lord. My lord, this matter in
ಸಿರ್ಸಿದ ಇದು.
ಹೌದು, KDCC bank sits.
The petitioner is before this court seeking the following prayer. The heard so. The learned counsel appearing for the petitioner would contend that the process of election is seriously compromised in the case at hand, as there is serious malpractice with regard to depiction of the ballot paper, which according to the learned counsel Srivatsa Hegde is contrary to Rule 14
L and R.
L and R. The said provisions read as follows. The learned counsel appearing for the learned AGA Ramesh Chigri and the learned counsel Vishwanath,
R7.
counsel for the seventh respondent, would vehemently refute the submission in contending that this court, in exercise of its jurisdiction under Article 226 of the Constitution of India, once the elections are over, would be loath, LOATH, would be loath to interfere unless the arbitrariness is palpable and demonstrable. The learned counsel submits that the issue with regard to the compromised ballot paper during the election has to be adjudicated on the strength of evidence, which this court is not equipped to do so. The submission of the learned counsel appearing for the petition respondent would merit acceptance, as the issue revolves around the conduct of elections. Malpractice during the conduct of elections with regard to the ballot paper. Therefore, all these disputes with regard to the conduct of elections will have to be thrashed out before the concerned authority by raising a dispute under section 70 of the Cooperative Societies Act. The Learned Counsel Srivatsa submits that the registrar,
Yes, the returning officer.
the Joint Registrar of Cooperative Societies will not go into the matter with regard to the ballot paper or the ballot box and would only consider the issue on its periphery. The said submission is unacceptable, as the dispute with regard to these elections will undoubtedly have to be gone deep by the registrar, by the Joint Registrar of Cooperative Societies, as he is the one who would decide the dispute under section 70 of the Cooperative Societies Act. In the light of the said circumstance, without interfering with the order impugned, reserving liberty to the petitioner to knock at the doors of the appropriate fora, petition stands disposed. All contentions of all the parties shall remain open.
Lord, the ballot box and the ballot papers counterfoil shall be preserved by the returning officer.
ಇರುತ್ತೆ ಎಲ್ಲ ಅದ್ರಲ್ಲಿ ತಗೊಂಡೋಗ್ತಾರೆ.
1 year ವರೆಗೆ
One year ವರೆಗೆ ಇರುತ್ತಲ್ಲ. Any further order with regard to the ballot paper or the ballot box or its preservation can be projected before the Joint Registrar of Cooperative Societies.
Time frame, my lord, time.
Act ಪ್ರಕಾರ ಎಷ್ಟು ದಿನ ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ಮುಗಿಸ್ಬೇಕು ಅಂತ?
Allah, there is no such
ನೋಡಿ,
no stipulation.
My lord, in those 46 and 47 matters, my lord. My lord, by way of interim order, my lord, the vote cast by the respondents number 8, 15, 8, 12, 15 and 18, my lord, kept in a separate cover, my lord. My lord, that can be counted and the result can be announced.
Only time frame, my lord. The provision, there is no such time frame.
Since it is election, since the issue concerns election and the malpractices of the conduct of election, the Joint Registrar of Cooperative Society shall endeavor to conclude the proceedings as expeditiously as possible.
Lord, that would take longer, but then, I mean,
it's difficult to fix. Yes,
as early as the expediency, that is sufficient, my lords.
Term ಎಷ್ಟು?
Term 5 years.
5 years as expeditiously as
That is proper.
at any rate within 1 year from the date of receipt of the copy of this order.
6 months, my lord. They will come up with another writ petition for extension.
That is
again.
to be, opportunity has to be given, my lords. Opportunity has to be given notice.
After so and so, in accordance with law, after affording opportunity to all the stakeholders.
Please, please.
ಕೊಡಿ ಅವ್ರಿಗೆ
46 ಅಲ್ಲಿ
ಯಾರ್ಯಾರಿಗೆ ಅಂತ ತಗೊಂಡ್ಬಿಡಿ. With the aforesaid petition stands disposed. 47, 48 close.
ಅಲ್ಲ 46 and 47 ಮೇಲೆ
46 and
46 ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 8 ಮಾತ್ರ, ಬಟ್ ಅವರು ವೋಟ್ ಕಾಸ್ಟ್ ಮಾಡಿ
ಯಾರ್ಯಾರಿಗೆ ಅಂತ ಬರ್ಕೊಡಿ, ಗೊತ್ತಲ್ಲ ಮೇಡಮ್? ಹಾ ಸರಿ.
ಪ್ಲೀಸ್
ಬೆಳಗ್ಗೆ ಸುಮಾರು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದಿಲ್ಲ.
ಹೌದು,
46 and 47 they are withdrawing.
ವಿಡ್ರಾಯಿಂಗ್
Simple withdrawal.
ಅಲ್ಲ ಅದೇ
Memo may be accepted.
ಮೆಮೋಲ್ ಏನಿದೆ ಅದು
ಅಷ್ಟೇ ಪ್ಲೀಸ್
ಇದು ರವಿ 46 and 47 withdrawn in terms of the memo.
Yes, great.
Bill number 4, Rahul S. Kuntoji.
Please, my lords, for petitioner, my lord. Petitioner is the contractor, my lords. From 2009, my lords, he is working as the carrying the solid waste management, my lord, in the ward number 61 of.
ಈಗ ಏನಾಗಿದೆ?
My lords, in the recently, my lords, in finally annexure up, my lord, page number 39, my lords. From tomorrow onwards, terminating my contract, my lord, without any notice or anything.
Why terminating?
On the basis of the, my lord, notice issued.
Annexure F is under.
Why?
Annexure up, my lord, page number 39.
ಯಾರು? HDMC ನಾ?
Please, my lords, HDMC.
The learned AGA accepts notice for the first respondent. 2 and 3 ಯಾರಿದ್ದಾರೆ?
Irangoda Kabur, my lords.
ಅದ್ಯಾರು? So and so accepts notice for respondents 2 and 3. The contract of the petitioner, if not terminated as on today, shall not be terminated till the next date of hearing.
Please.
List on.
May I seek for hand delivery?
ಹಿಂಗ್ ಬರ್ಕೊಳ್ಳಿ. The learned counsel for the petitioner submits that the respondents 2 and 3 are now wanting to terminate the contract of the petitioner without issuance of any notice whatsoever. In the light of the said submission, the contract of the petitioner shall not be terminated if it is not terminated as on today. List on 17th.
Seal number 5.
In terms of.
Number 6, Venkatesham Kharvi.
Only one
Disposed,
contention. ಅಲ್ಲ ಅದರಲ್ಲಿ ಏನಾಗಿದೆ?
ಇಲ್ಲ ಇದರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ.
So what happened, my lord? One writ petition.
ಮೂವ್ ಮಾಡಿದ್ರಿ ಇದನ್ನ?
My lord, urgency is, my lord, one writ petition is filed by the my learned advocate, that is Sadiq Kodwa, in 107760.
ಆಯ್ತು, ಏನ್ ಹೇಳಿ?
In this case, my lord, this court was granted interim order. Subsequently, my lord, what happened? The CEO executive officer ran away from the office. So out of 10 directors, my lord, he called notice only 5 directors, and 5 director has passed the resolutions in the first writ petitions.
ಈ ಮೂವ್ ಮಾಡಿದ್ ಯಾಕೆ ಸರ್?
Now, urgency is, my lord's kind, date may be fixed, my lord, because in execution
230 ಮೂವ್ ಮಾಡಿದ್ರ?
ಅಲ್ಲ ಅದರಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ಮುಂದೆ ಆಗಿತ್ತು ಸಲುವಾಗಿ ಅರ್ಜೆಂಟ್ will take notice to the respondent number 6, my lords. In writ petition number 1077.
ಯಾರಿಗೆ?
My lord, I am appearing for the bank.
R6 ಯಾರು?
Yes, you are.
R6 ಯಾರು?
R6, my lords, in separate, my lords. R6 will take the notice.
ಯಾರು ಸರ್ ಅದು?
That is chief executive of the society, my lords.
Society.
ಅವ್ರ ಇಂಟರ್ನಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಅವ್ರವ್ರ
ಇಲ್ಲ ಅವನು ಓಡೋಗಿದ್ದಾನೆ.
ಓಡೋಗಿದಾರ, ಮತ್ತೆ ಎಲ್ಲಿ ಇಟ್ಕೊಂಡ್ ಬರ್ತೀರಾ?
That is, my lords, we file a complaint to the deputy registrar and also police, because, my lord, without calling the other directors, he passed the resolutions. And he sought for injection. President has sought for injection.
ಅದೆಲ್ಲ ಮಾಡಿದ್ಮೇಲೆ
ಓಡೋಗ್ಬಿಟ್ಟಿದ್ದಾನೆ. That is, my lord.
If he is on the run, where will you serve him?
We'll take one chance.
No, if he is on the run, how will you serve him?
ಅಲ್ಲ ಈಗ ಬಂದು ನಾನು ಎಲೆಕ್ಷನ್ ಮುಗಿತಲ್ಲ,
ಈಗ ವಾಪಸ್ ಬಂದ್ರಾ?
That's why we'll take notice and hand summons are ಕೊಡ್ತೀನಿ sir.
Learned the respondent number 6 be served by way of hand summons.
Please.
ಅಷ್ಟಕ್ಕೆ 230 ಮೂವ್ ಮಾಡಿ, ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡ್ತೀವಿ.
Please.
Yes.
Any date, my lords?
List on ಯಾವತ್ತು ಹಾಕಿ?
5th or 6th ಏನಿದೆ?
ಬೇಡ, 10th ಹಾಕ್ತೆ.
Please.
10th.
And connected to the another. Connected ಅದು ಎರಡು ಕನೆಕ್ಟ್ ಆಗಿ.
ಎರಡು ಕರೆಕ್ಟ್.
Please.
Avinash Mangdi.
Maintainability.
Senior counsel is appearing.
Maintainability ಯಾಕೆ?
Please, please.
PP ಹೆಗ್ಡೆ ಸರ್.
Serial number 9.
ಬಹಳ ದಿನ ಆಗೋಗಿದೆ.
Please.
48 ಕೂತಿಲ್ಲ.
Please, my lords. Please, my lords, we are grateful, my lord, getting an opportunity to submit before my lords after a long time.
Yes, sir.
My lords, the maintainability is this, my lords, that the beneficiary, that's the petitioner, has not been made parties in the land acquisition enhancement proceedings. And the Honorable Supreme Court Constitution Bench has said, my lord, if any enactment or award is passed without notifying the beneficiary, that's null and void. A writ petition is maintainable. Constitution bench decision, my lords. UP Awas, I may pass on to the kind consideration of this honorable court, my lords. And in view of that, its writ petition is maintainable. In fact, my lord, the same question was raised, my lords, by the registry in many of the.
Office objections overruled. Come on,
and after hearing, my lord.
Office
please,
objections overruled.
Merits, my lords. I am so great. Yes. So grateful, my lords. We have not been made parties. Orders have been passed. Enhancement orders have been passed. Enhancement, my lords, in many cases, in 10 times, 20 times more than that, without notice to us. Therefore, my lords, this honorable court to coordinate benches, my lords.
Hearing to the petitioner, accepting the submission of the counsel to the petitioner, office objections, maintainability stands overruled in the light of the judgments rendered by the apex court on the issue. The learned counsel for the petitioner and senior counsel for the petitioner submits that 20-fold enhancement is made of the compensation to be awarded to the land losers without even making the beneficiary of the acquisition a party. In the light of the said submission, as also the said submission being as also the act of the yaradu respondent.
Respondent number private respondents.
Yaar order sir.
LAC judgment has been challenged.
In
My lord, judgment by
in the
lord,
light
the
of
impute
Judgment of the
judgment.
reference court.
in the light of the reference order with, which enhances the compensation 20-fold without making the petitioner the beneficiary a party, there shall be an interim order of stay as prayed for till the next date of hearing. The land losers be served, the claimants be served by way of hand summons and an acknowledgement of such.
Emergent.
And also through the learned advocates appearing with the trial court, my lords.
The
learned
claimants be served through the councils representing them before the reference court, apart from taking out first emergent notice in Barbudi. Emergent notice to the respondent shall be served also through their advocates, apart from taking out steps to serve them. List the matter on 18th in
That's
fresh
1 and
matter.
2 government.
1 and 2 AGA. List the matter on 18th in fresh matters list.
Yes, serial number 7,
Most
9,
most grateful, my lords.
7,
9, 10, 11, 13 and 14.
Same matter.
Same. 7, 9. Ella
Same,
PP.
please, my lords.
Yes.
Please.
Senior counsel PP evidence.
Please.
Yes, next.
Grateful. Please.
Bill number 8, VN Molimani.
Madam, copy kotilva? Guest lecturer idunu. Tomorrow. Fresh matters.
Bill number 9, Avinash
They were taken tomorrow, my lord.
ಅವರೇನಾ ಅವ್ರೇನು ಪಿಯಾನೋ ಮುಂದೆ ಕೂತಿದಾರ ಕೀಬೋರ್ಡ್ ಮುಂದೆ ಇರ್ಲಿ ಬಿಡಿ. ಮೇಡಮ್ ಗೆಸ್ಟ್ ಲೆಕ್ಚರರ್ಸ್ ಇದೆಲ್ಲ ಕವರ್ಡ್ ಮ್ಯಾಟರ್. ಸೂರಜ್ ಗೋವಿಂದರಾಜ್ ಒಂದು ಆರ್ಡರ್, ಆಮೇಲೆ ಅದೊಂದೇ ಆರ್ಡರ್ ಪ್ರಕಾರ ಇವರು ಫ್ರೆಶ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಆಗೋವರೆಗೂ ದರ್ ಸರ್ವಿಸಸ್ ವಿಲ್ ಕಂಟಿನ್ಯೂ ಅಂತ ಕ್ಲೋಸ್ ಮಾಡಿದೆ. ಅದೇ ತರ ವಿಲ್ ಕ್ಲೋಸ್ ಇಟ್. ನಾಳೆ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ.
Furuj Ahmed.
What's the petitioner is tomorrow, my lord.
Petitioner is a contractor who is
Bill number
eligible.
12.
Sorry, my lords, please. He's
Office objections in 52.
lords, office objections are in regard to the legible copies of.
Office objections, accepting the submission to counsel to the petitioner, office objections overruled. Yes.
Yes. Please,
What's the
my lords.
matter?
Petitioner is a contractor, my lords, who is eligible under reserved category, my lords. My lords, subsequently on 39/2025 at Annexure A, the impugned tender notification has been released. Lords, if your lordships may kindly come to page number, my lords, 30 of the impugned annexure, impugned tender notification, my lords. There, my lords, at serial number 3, my lords. I'm challenging this one, my lords. My lords, this reads as follows: successfully completion at least one similar work of value not less than estimated cost and 2 years maintenance in previous 3 years equal to the estimated quantity. The necessary work done certificate. My lords, my submission is that as per Annexure P, my lords, if your lordships may kindly come to page number 101, the government of Karnataka has already modified, my lords, and subsequently, my lords, at page number 102, if your lordships may kindly come. At serial number 2,
you have not participated.
I have participated in the tender, my lords. It has been rejected. Now they have recalled the tender, my lords, because there were only 2 participants in the tender.
Right. Now participate in the new tender.
I will participate in the tender, my lords. But subsequently, what will happen is, my lords, again that will be rejected. The impugned tender.
Let's see. Secure instructions. Learned AGA to secure instructions, make his submissions, list on Tuesday in fresh matters.
Meanwhile, my interim prayer, because my lord, 31st is the last date for the tender bid, my lords. My interim prayer is that, my lords, I may be permitted to.
The counsel for the petitioner shall submit his bid, which shall be considered separately, and shall not, which shall be considered separately. The petitioner shall not claim any equities on the direction for submission of his bid. List the matter.
No work order may be issued.
No.
Lords, if your lordships may kindly peruse, my lords.
No.
My lords, because my lords, as per the
bid submit madilla inno adikke ಒಂದು ಆರ್ಡರ್ ವರ್ಕ್ ಆರ್ಡರ್ ಇಶ್ಯೂ ಮಾಡಬಾರದು ಅಂತ.
My lords, my submission is that as per the government order, they have modified it, my lords. They have extended this relaxation even to the category to be
on 18th. Yes.
Highly obliged.
Too far-fetched to seek no work order should be issued to anybody.
My lords, because my
By a
lords, if-
person who has not yet submitted his tender.
My lords, if I will submit it today itself,
Yeah,
my
you
lords.
submit.
Please, my lords.
ನೀವು examination ಗೆ ಕೂತಿಲ್ಲ ಇನ್ನು ರಿಸಲ್ಟ್ ಅನೌನ್ಸ್ ಮಾಡಬಾರ್ದು.
No, my lords, only two bids, two people had applied for the tender. Both of them have been rejected on this.
Examination. ಆಮೇಲೆ ರಿಸಲ್ಟ್ಸ್ ಬಗ್ಗೆ ನೋಡೋಣ. List on 18th.
Please, my lords. Highly obliged, my lords.
Girish V. Bhatt.
18.
Please, my lord, the petitioner's petition, your lordship will please to grant interim order on 30th January. And the subsequent dates early extension was not sought.
ಅದಕ್ಕೆ ನೀವ್ ಯಾಕೆ ಬಂದ್ರಿ?
ಅಯ್ಯ ಹಾಕೊಂಡಿದೀವಿ.
Extension of interim order, sir.
If in case your lordship wants
Will
to hear
dismiss
the
it ಅಂತನಾ?
hear
ನೀವು
the matter,
ಬಂದಿರೋದ್ರಿಂದ dismiss ಮಾಡೇ ಮಾಡ್ತೀನಿ.
please.
ಹೇಳಿ. ಈ extension of interim order ಗೆ.
My lord, the husband of the petitioner died a death under suspicious circumstances.
What?
Died under suspicious circumstances. His body was found
Circumstances.
half hanging, partially hanging.
Half hanging.
ಅಂದ್ರೆ ಮೊಣಕಾಲಿಂದ ಕೆಳಗಡೆಗೆ ಬಾಡಿ ಟಚ್ ಆಗಿತ್ತು ಅಂತ. And for that, my lord, the complainant gives a complaint in writing that there is a clear suspicion in the death of my husband. But respondent number 8 PSI registered the case as a UDR.
ಆಮೇಲೆ
My lord, they approached the higher authorities. An inquest is conducted. In the inquest Panchanama also, my lord, he, before postmortem, he mentions
inquest, sir. Inquest Panchanama.
Inquest Panchanama is conducted.
Interest Panchanama ಯಾವುದು?
Inquest, his
yes.
dead body's Panchanama. That has been, the cause of death is mentioned even before receipt of a postmortem report. That death is due to hanging. It's a suicide. For these, my lord, they approach higher authorities. At which time, my lord, this particular respondent number 8, the whole episode, my lord, circles around the complainant, one Manjula Churi.
Churi?
Yes, that is her family's name. The allegation, my lord, the suspicion is that this deceased had an affair with her.
Churi?
Yes. And then on the date of incident, in the afternoon, both of them found talking near
306 ಇದೆಯಲ್ಲ?
Correct, my lord. 306 ಆಗಿಲ್ಲ. 306 ಅಂದ್ರೆ there is nothing to suggestive of averting the suicide. It was a clear case of murder. There are witnesses to this.
Murder 302 ಬೇಕಾ ನಿಮ್ಗೆ?
For this, my lord, I take your lordships to the petition that I have submitted. And my lord, even we approached the higher authorities, wherein an inquiry has been conducted by the Human and Rights Enforcement Directorate against respondent number 8 PSI, wherein the allegations of him are proved. He acted with purpose, dereliction of duty in not conducting the investigation. And the provisions under SA were attracted. For that, my lord, initially DOSP Bagalkot is appointed as IO by the Superintendent of Police. And on our suspicion that he may join hands with the PSI, we requested. The next day, my lord, another IO is changed. He too submits the charge sheet on the similar lines. And hence, my lord, when I approached by way of a petition,
ಈಗ that the court is hearing the matter. This court ಅಲ್ಲ. Now I have stated it's a different thing.
How?
Special case 36 of 24 is registered.
Please.
ಅದರಲ್ಲಿ 306 is the case.
ಹೌದು. But ಏನಾಗಿದೆ ಅಂದ್ರೆ, my lord, I submitted a petition. Again, a complaint is issued from me.
The complainant's husband dies.
ಹೌದು.
Husband had an affair with someone else.
ಅಲ್ಲ, ಈ ಪಿಟಿಷನರ್ ಹಸ್ಬೆಂಡ್ ಕಂಪ್ಲೇಂಟ್ ತಗೊಂಡದ್ದು ಇನ್ನೊಬ್ಬ ಹೆಣ್ಮಗಳ ಜೊತೆಗೆ.
ನೀವೇನು ಅಕ್ಯೂಸ್ಡ್?
No. In fact, this particular complainant and her husband and others were supposed to be the accused because I have given a complaint. For a minute, my lord, I will take your lordships to.
Complainant ಯಾರು sir?
ನಾವು ಕೊಟ್ಟ ಕಂಪ್ಲೇಂಟ್ ಅನ್ನು UDR ಅಂತ ಮಾಡ್ಕೊಂಡ್ರು.
Complainant ಯಾರು?
ರಿಜಿಸ್ಟರ್ ಆಗಿರೋ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಕೇಸ್ ಅಲ್ಲಿ ಮಂಜುಳಾ ಚೂರಿ
ಕಂಪ್ಲೇನೆಂಟ್.
ಹೌದು. ನಾವು ಕೊಟ್ಟಿರೋ
your husband had an affair with ಮಂಜುಳಾ ಚೂರಿ.
ಹೌದು. For this, my lord, again, ಒಂದು ನಿಮಿಷ ನಾವು ಅದನ್ನ ಕೊಟ್ವಿ 46 to 49. May I take your lordships to page 200.
I will not extend the interim order at all. ಸುಮ್ನೆ ಅವ್ರು ಬಂದಿದ್ದಾರೆ extend ಮಾಡ್ತಾ ಇದ್ದೆ.
ಇಲ್ಲ, my lord, is covered by the judgment of the Honorable Apex Court.
ಹೌದಾ?
ಹೌದು. Similar
Covered,
circumstances. Similar circumstances. For a minute, my lord. Before that, my lord, I want to take your lordships to Annexure A, page 200 for a minute. Let's para 15 and 16. And my lord, may I take your lordships to page 200?
Yes, AG, please look into it.
On this for, this is for extension.
List the matter on 18th. Interim order subsisting, interim order granted earlier. Oh, ಯಾವಾಗ extend ಆಗಿಲ್ಲ?
My lord, that was granted on 30th one. No. Subsequently, my lord, 2 times the matter was listed your lordship only for disposal. Adu times alilla anta it was adjourned.
ನಾನು extend ಮಾಡಿದಕ್ಕೆ ಸಾಧ್ಯವೇ ಇಲ್ಲ.
It was listed on
11/2025. I granted the interim order.
Howd. And 11 to 25 it was
yes
listed. 20 11
to yes
21 2 my lord, it was adjourned.
3 ಯಾರಿದ್ರು?
The lordship Justice Jyoti Mulimani. Justice Jyoti Mulimani, my lord.
List the matter. Interim order granted on 30/1/2025 shall stand extended till the next date of hearing.
The 16 BN
And synopsis have been filed as per your direction lordships for disposal. Open court will
We'll
continue.
take it on 18th and
Please.
Yes.
18th, lord.
No, 18th.
Please.
Supreme Court and illala nimge avatu.
Please, deeply obliged.
Number 16 BN Molimani.
16 ನಾಳೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲಲ್ಲ ನಾಳೆ
17
Yes,
Sridhar Prabhu.
professor.
Yes, the meter was recording fast.
ಅಲ್ಲ recording fast
Fast. They
faster
came,
than
usual. They come and acknowledge that and correct the meter, my lord. And the matter is done and dusted. After 1 year, they say, "You the back billing katti, adu idu katti." Avre, then my lord, I approach the ombudsman. He rules in my favor. But only thing is, my lord, he
Remanded
says,
the matter to the respondent AW.
remanded back. What? There is
Remanded
no
back to the
right.
AW lords.
Lord, ombudsman cannot remand. Only the judicial authorities can remand is one. Secondly, my lord, when they themselves have corrected it, what is there to remand to the same authority? My lord? That's all.
heard the learned counsel. B group ಅಲ್ಲಿ ಇದೆ ಇದು.
That interim order was not considered and it went to B group, my lord. It was to be posted for consideration of interim order by Honorable Justice Suraj Govindraj ಅವ್ರ ಮುಂದೆ ನೋಟಿಸ್ ಮಾಡಿ to be heard on interim order ಅಂತಿತ್ತು. ಆಮೇಲೆ ಅದು ಸೀದಾ B group ಗೆ ಹೋಯ್ತು, ರೀಚ್ ಆಗಲಿಲ್ಲ. Then, my lord, they are taking the meter now, saying that the matter is relegated. I'll take the meter for test. Allah, he is not to be
They are
fault.
taking the meter, you moved the matter.
Allah, disconnection ಮಾಡಿದ್ರು ಒಂದು meter ತಗೊಂಡು ಹೋಗಿ.
They heard the learned counsel Sridhar Prabhu appearing for the petitioner. The issue is with regard to
17 ಅಂದ್ರು ನಮ್ದು 18
speed running of a meter installed, electricity meter installed in the
17 ಅಂದಿಲ್ಲ 17
Nanda. Meter installed in the premises of the petitioner. The learned counsel for the petitioner submits that the mistake in the meter is acknowledged by the respondent.
ಇಲ್ಲ ಸ್ವಾಮಿ ಅಲ್ಲಿ ಏನಾಗಿದೆ
Corrected.
ಮ್ಯಾಕ್ಸಿಮಮ್ ಡಿಮಾಂಡ್ ರೈಸ್ ಮಾಡಿದ ಮೇಲೆ
Acknowledged and a maximum demand was raised.
ಪ್ಲೀಸ್ ಲಾರ್ಡ್ಸ್
The petitioner pay ಮಾಡಿದ್ರಾ?
It was, they said, my lord, that they said, they themselves came and said, when I raised the objection, they repaired the meter and withdrew the demand.
Page number 136.
The learned counsel submits that when the mistake was projected to the respondents, they rectified the meter.
Yes, rectified the meter,
and withdrew the demand. Then why did you go before the ombudsman?
No, again, after 1 year, my lord, they raised the demand again.
After expiry of about 12 months of the aforesaid withdrawal of the demand, again a demand was made of back billing. It is then the petitioner approaches the ombudsman under the KPTC ಅಲ್ಲ ಇದು?
Yes,
CGRF ಗೆ ಹೋದ್ರು.
Section 42 of the Electricity Act.
Under the constituted under section 42 of the Electricity Act. The ombudsman has now remitted the matter back to the hands of.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಸ್ವಾಮಿ ಅವರು CGRF ಹೋಗಿದ್ರು, ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಅದು ಮುಗಿಲ್ಲ, ಅದೇನು ದಟ್ ಇಸ್ ಇಮ್ಮಟೀರಿಯಲ್.
ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಆಯ್ತು ಇರ್ಲಿ, ಸದ್ಯಕ್ಕೆ ಮೀಟರ್ ತಗೊಂಡ್ ಹೋಗ್ಬೇಡಿ. ಪ್ಲೀಸ್ ಮ್ಯಾಟರ್ ಮುಗಿಯೋವರೆಗೂ ಮೀಟರ್ ಮುಟ್ಬೇಡಿ.
ಪ್ಲೀಸ್
ಡಿಸ್ಕನೆಕ್ಷನ್ ಕೂಡ ಮಾಡಿ.
ಮೀಟರ್ ಮುಟ್ಬೇಡಿ ಅಂದ್ರೆ ಅದೇ
ಅಲ್ಲ ಮೀಟರ್ ಮುಟ್ಬೇಡಿ ಅಂದ್ರೆ ಡಿಸ್ಕನೆಕ್ಷನ್ ಕ್ಯಾನ್ ಬಿ ಡನ್ ವಿದೌಟ್ ಟಚಿಂಗ್.
The learned therefore, in the light of the said circumstance, till the during the pendency of the subject petition, the electricity of the petitioner shall not stand disconnected.
Please also.
Covered by a judgment. Anyways, I will not insist.
That is.
Decision bench covers the whole issue.
1978.
Yes. I have the judgment.
You could. Ramajayasra.
Yes. Topasa, my lord, is the judgment, and para 7 covers the whole issue. Para 7.
1990, sorry.
Yes. Para 7.
Justice Ramajayasra.
Yes. Which is not last but one page. That when they don't dispute that, they can be correct.
We'll post it on next yavag barta idira.
16th, 15th, any date. Lordship's date, no, I'll accommodate. Any date.
After 2 weeks, Lordship. I will
any
get
date.
instruction also, Lordship. Instruction ತಗೋದಿ sir.
19 halda.
Please, Lordship.
20 days ಕೊಟ್ಟು instruction.
Please, Lordship.
Yes.
Number 18, Girish Dharwad.
Please.
Then dispose ಎರಡು ಸೇಮ್ ಶ್ಯಾಮ್ ಪ್ರಸಾದ್ ಅವರ ಆರ್ಡರ್.
Result may declare. Please.
ಅದೇ ರಿಸಲ್ಟ್ ಮೇ ಬಿ ಡಿಕ್ಲೇರ್ಡ್, ಅದೇ ತಾನೇ.
Voting rights, my lord.
Result will be declared.
Declared.
And
To
all
count these votes and declare.
All rights.
Count the votes of the petitioners also and declare.
ಜಸ್ಟಿಸ್ ಶ್ಯಾಮ್ ಪ್ರಸಾದ್ ಅವರ ಆರ್ಡರ್ ಅದೇ ತಾನೇ.
Very.
ಎರಡು ಮೇಡಮ್. ಕೂಗ್ಬಿಡಿ ಕೆತ್ತವ. ಅದು ಕರೀರಿ, ಡಿಸ್ಮಿಸಲ್ ಇತ್ತಲ್ಲ ಬೆಳಗ್ಗೆ, ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್.
Dismissal, number 49 needful done.
No, 49 needful done, office to verify. Next.
50 needful done.
Same.
51 needful done.
ಅವ್ರು ಹೇಳ್ತಾರೆ ಬಿಡಿ ಎಲ್ಲ ಮೇಡಮ್, ಅವ್ರು ಕೇಳ್ಕೊಂಬಿಡಿ ಯಾವ್ದು ನೀಡ್ಫುಲ್ ಡನ್ ಯಾವ್ದು ಡಿಸ್ಮಿಸ್. ಎಸ್, ಆಮೇಲೆ ಡಿಸ್ಮಿಸ್.
My lord, serial number 56, my lord.
ಕಂಪ್ಲೈ ಆಗಿದೆ ಅದನ್ನ. ಎಸ್.
Serial number 56, my lord.
What sir?
We have completed all the appeal subjection.
Comply ಆಗಿದ್ರೆ comply. Yes.
And one council submission, they are posted for council submission with regarding to specification of interim prayer.
ಬರ್ಲಿ ಅದು. Yes.
118, your lordship's is a match covered by your lordship's judgment.
No, wait. We'll just fix the dates for other things. ಕೊಡಿ, ಕರೀರಿ ಬಿ ಗ್ರೂಪ್ ರಿಮೈನಿಂಗ್ ಪೇಜ್ ವೈಸ್. We'll fix it on Monday, all the matters.
174 there is some.
ಒಂದು ನಿಮಿಷ, ಅಂದ್ರೆ ಯಾರಿಗೆ ಬೇಕು ಅವ್ರಿಗೆ.
110 to 113.
ಒಂದು ನಿಮಿಷ, ಪೇಜ್ ವೈಸ್ ಕರೀತಾ ಇದ್ದೀನಿ ನಿಮಗೆ.
Page number 26, 110 to 113.
112 and 113, my lord.
ಏನ್ ವಿಜಯ್ ಕುಮಾರ್ ಇದು?
Lord, first one relating to imposing the penalty, my lord, pursuant to the departmental inquiry. He was acquitted honorably in the first matter, my lord. And
ಆಯ್ತು, 113 we'll take it on Tuesday. 4th.
Can it be on Wednesday?
ಆಯ್ತು, Wednesday. Yes.
Please.
ಆಮೇಲೆ
interim order be extended.
Interim orders will continue, sir. Yes.
Please.
Page number 27, 116 and 118.
118, your lordship.
Bullets, serial number 114, bullets.
ಒಂದು ನಿಮಿಷ, 18 ಮುಗಿಸ್ಮೇಲೆ 20 ಬರ್ತೀನಿ.
Covered by judgment.
ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು?
Respondent is government law.
ಯಾವ್ದಿದು? 118.
Please, your lordships. I have filed NOC wakalat in that matter, your lordships. And your lordships have followed the judgment wherein the same order has been set aside.
ಇದು ಯಾರು ನಿಮ್ದ? ಇದು ನೋಡ್ಬಿಡಿ. ಲಿಸ್ಟ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಇನ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ 119, 120 ಏನು ಗಿರೀಶ್?
129, my lord, I am at 120.
ಅಲ್ಲ
114 my lords.
114, very sir.
114
may be taken upon.
ಮುಕುಣಪ್ಪ ಸರ್ ಏನು
My lords, may be taken up on Tuesday or Wednesday, my lords.
ಯಾವ್ದು 114
14, my lord.
Please, my lords, I appeal for the
Resignation, conditional resignation was accepted, my lord, that.
ಎಸ್ ಯಾವತ್ ಬೇಕು ಗಿರೀಶ್
My lords, Tuesday or Wednesday, my lords.
ವೆಡ್ನೆಸ್ಡೇ 6th ಸಾರಿ 5th
Please, my lords. Much.
ನೆಕ್ಸ್ಟ್
Page number 28, 119 and 120.
Number 120 lordships.
126 ಗೆ ಬಂದಿದ್ದೀನಾ ಈಗ 116 ಏನು ಟುಮಾರೋ ಡೇ ಆಫ್ಟರ್ ಇಲ್ಲ ವಿಲ್ ಟೇಕ್ ಇಟ್ ಆನ್ ವೆಡ್ನೆಸ್ಡೇ ನೆಕ್ಸ್ಟ್
Number 120 lordships.
119 120 ಏನು
120 lordships. Wednesday, Thursday lordships.
ವೈ
Challenging on the recruitment notification lordships.
ವಾಟ್ ನೋಟಿಫಿಕೇಶನ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ನೋಟಿಫಿಕೇಶನ್ ಅದೇನೋ ಸರ್ವೆ ಆಗಿಲ್ಲ ಎಲ್ರಿಗೂ
ಆಗಿದೆ ಎಲ್ಲ ಆಗಿದೆ.
ಎಸ್ ಅದು ವಿಲ್ ಟೇಕ್ ಇಟ್ ಲೇಟರ್
Wednesday, Thursday lordships.
ಮೇಡಮ್ 120 ವಿಲ್ ಬಿ
Service ಎಲ್ಲ ಆಗಿದೆ.
20th ಎಸ್
Preliminary list lordships.
20th ಎಸ್ ಅಪೀಲ ಏನ್ ಮೇಡಮ್ ಇದು ಅಪೀಲ್ ಲಿಸ್ಟ್ ಆನ್ ಫ್ರೈಡೆ ಇನ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್ 119 ಎಸ್
My lord, 111. 111.
11
111.
wait I have to go back wait next period
Page number 36, 123 to 129.
123 ಏನು what's the matter ಆಯ್ತು ಲಿಸ್ಟ್ ಆನ್ 7th ರೆಗ್ಯುಲರೈಸೇಷನ್ ರೆಡಿ ನೀವೇ ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ ಕರೆಕ್ಟ್ ದಿನೇಶ್ ಕುಲಕರ್ಣಿ ಫಾರ್ R3 ಅದನ್ನೇ ಕೇಳಿದ್ದು ಎಸ್ ಲಿಸ್ಟ್ ಆನ್ 6th ಎಸ್
124 my lord.
120
124 my lords, covered by the decision, my lord.
covered
Yes.
ಏನು
Lord, the matter pertains to my lord work property. Once the land tribunal granted occupancy rights, work have no authority. Yesterday your lordships had disposed.
yes list on Tuesday
Please.
Tuesday in preliminary hearing
Please.
yes next
Interim order may be extended.
interim order will continue
129, my lords. Petitioner's house got submerged. Only that was valued. But at the time of passing award, 2 other houses have been included for the same amount.
list on
Taking a mandamus
6th
in preliminary hearing or fresh
matters
Please.
My lord, serial number 125, my lord.
120
5, my lord. Seeking a direction to register FIR, my lord.
ಅಷ್ಟೇನಾ
Yes, madam.
ಯಾಕೆ ಮಾಡಿಲ್ಲ what's the crime about
My lord. Offense, cognizable offense, my lord.
ಏನು
That is molestation and
molestation
yes, and assault, my lord.
The petitioner is before this court seeking the following prayer. The learned counsel for the petitioner is at the doors of the court on the score that notwithstanding the complaint registered before the jurisdictional police of offences which are on the face of it cognizable, no crime is registered. The learned AGA on going through the papers should submit that action would be taken in terms of the judgment of the apex court in the case of Lalita Kumari versus State of Uttar Pradesh 2014 2 SCC page 1 and consequential action would be taken in terms of law. Recording the said submission, I deem it appropriate to dispose the petition with a direction to the respondent state to act in terms of the judgment of the apex court quoted supra. Yes, ordered accordingly. Amala, yes.
Page number 37, 135.
Serial number 132, my lords.
ಏನು ಆಯ್ತು 6th 6ನೇ ತಾರೀಕು ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ 130 ಇದು ನಿಮ್ದೆ
132.
135. Dinesh Kulkarni ta?
I'm respondent.
ಹಾ
Yes, ma'am.
ಆಯ್ತು 6th 6ನೇ ತಾರೀಕು 6th in preliminary hearing.
My lords, serial number 132, my lords, have challenged compromise decree, my lords.
ಇದು ನಾನೇ ಸ್ಟೇ ಕೊಟ್ಟಿರೋದು.
Yes, my lords.
Yes.
My lords, any date, my lords.
We'll see. We'll take it on 18th. ಸರ್ವ್ ಆಗಿದೆ ಎಲ್ರಿಗೂ?
Yes, my lords. They have appeared, my lords.
List on 18th in preliminary hearing. Yes.
Interim order.
Interim model will continue in all the cases. Don't worry. Yes, next.
Page number 38, 136 to 142.
142, my lord.
Caste certificate.
Yes, my lord. On Monday, my lord. I am contesting respondent, my lord.
You want to contest elections, sir?
Yes, I am the contesting respondents. I am belongs to A category.
Contesting respondent.
Yes, my lord. Actually, the post was reserved for A category, my lord. Who is belongs to 3rd B category, Jain Digambara, falsely obtained caste certificate and elected as a president, my lord. And due to his illegal acts, we have suffered.
List on.
Already he has completed 26 months, my lord. Remaining 4 months is there.
4
my
months
lord.
ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ ಸ್ವಾಮಿ.
ಜನವರಿ ತಗೊಂಬೋಣ.
ಅಲ್ಲ ಸ್ವಾಮಿ. ಅಲ್ಲ injustice person.
Injustice person.
Sorry, my lord.
ಆಯ್ತು, we'll
Ineligible candidate is
ಅದು okay.
occupied the president post. my
Justice
lord.
candidate ಅಂದ್ರೆ.
Sorry, my lord.
ಎಲೆಕ್ಷನ್ ಇವಾಗಲೇ ಮುಗಿಸ್ಬಿಡ್ಲಾ?
Yes, my lord.
ಎಲೆಕ್ಷನ್ ಪಿಟಿಷನ್ ಹಾಕೋಬೇಕು.
ಸ್ವಾಮಿ ಅಲ್ಲ ಈಗಾಗಲೇ ಅವರು ರಿವಿಷನ್ ಪೆಟಿಷನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಅಲ್ಲಿದೆ DC. ಆಸ್ ಪರ್ ಇದು ಏನಂದ್ರೆ ಅವ್ರಿಗೆ ರೈಟ್ ಇಲ್ಲ, my lord.
Yes, list on 10th.
Please, my lord.
10th in preliminary hearing.
Yes, my lord. Please.
Page number 39, 143 to 147.
144, my lords. Lords, appointment of Anganwadi workers, I have got my 72%. The respondent number 5 has got only 63%.
List on Friday in fresh matters list.
Please.
Madam, ಇದು ನೋಡ್ಕೊಂಬಂದ್
Fresh.
ಅದನ್ನೇ ಅಪ್ಪ ಹೇಳಿದ್ದೆ. Fresh matters.
Sorry.
Page number 40, 151 to 153.
152, my lord.
150?
President is continuing illegally. My lords, the pleadings are complete. There is only one short question that is involved.
List on 10th in preliminary hearing. ಯಾಕೆ preliminary hearing ಬೇಡವಾ?
152, my lord. ಅದು ಪೆನ್ಷನ್ ಫಿಕ್ಸ್
ಪೆನ್ಷನ್ ಫಿಕ್ಸ್ ಮಾಡಿಲ್ವಾ?
ಮಾಡಿದಿರಿ?
ಮಾಡಿಲ್ವಾ?
ಮಾಡಿಲ್ಲ. ಕಂಟೆಂಪ್ಟ್ ಅಲ್ಲಿ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಮಾಡ್ಕೊಂಬರಿ ಅಂತ ಹೇಳಿದಾರೆ ಸರ್. ಕಂಟೆಂಪ್ಟ್ ಅಲ್ಲಿ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಮಾಡ್ಕೊಂಬರಿ ಅಂತ ಹೇಳಿದಾರೆ. ತಮ್ಮದೇ ಆರ್ಡರ್ ಇದೆ ಸಾಹೇಬ್ರೆ. Previous order, annexure G and
day after tomorrow in the fresh matters list.
Please, ma'am.
Serial number 154. The petitioner is, it is a GM police matter, my lords. The multiple cases are pending against the petitioner. With the cases which has been filed by the son-in-law, my lords.
Again challenge ಮಾಡಿರದೆ.
Passport, my lords. We are seeking for renewal of passport.
Short validity passport only, no regular validity.
List next week.
List please. On Friday in fresh matters list.
My lords, the matter
respondent ಯಾರು?
The government, my lords.
Government ಅಲ್ಲ ಸರ್, ಯೂನಿಯನ್ ಆಫ್ ಇಂಡಿಯಾ ಬರ್ಬೇಕು.
Yes.
GM police. 153 ಅದು.
Representation has been made, my lords, already.
Right, list day after tomorrow in fresh matters.
The matter was listed in B group, my lords.
Now it will be listed in fresh matters.
Please.
We'll close it on Friday. Yes.
Page number 41, 155 to 157.
My lords, 157, my lords, regarding, my lords, supergrade contractors. The class 1 contractors, my lords, without, my lords, amending the passing of the order by the government, has, my lords, trying to, my lords,
18th, yes.
My lords, fresh, my lords, the respondents, my lords.
18 preliminary hearing al tavalla.
Please.
164, my lord. But this in this case, 3 years back, my lord, October 22, they have illegally taken possession. That's Neeravari Nigam Limited. They have not paid any amount.
20th, yes.
20th of.
Mikidal all other matters. 20th.
Sir, 163, my lords.
Interim order may be extended.
Interim order will continue everywhere.
Serial number 170, my lord.
My lordship, 163.
Little early, my lord.
ಯಾವುದು?
That's 164.
No. 20th only.
Lordship, 163, my lordship.
ಇಲ್ಲಿವರೆಗೂ ತಗೊಂಡಿದ್ದೀನಿ ಮತ್ತೆ ನನಗೆ ಜಾಸ್ತಿ ಆಗುತ್ತೆ, ಮತ್ತೆ ಇದೇ ಕೆಲಸ ಆಗುತ್ತೆ.
Sir, it is service tax matter. It is already covered by judgment, my lord.
ಪರವಾಗಿಲ್ಲ, ಎಲ್ಲ on 20th. These are all 2025 matters. They will come only on 20th.
Serial number 182 is of the matter 2010.
ಅದು separate 230 ಇದ್ದಿದ್ದಲ್ವಾ?
180.
ಇರ್ಲಿ.
Separate it.
Wait.
I appear by petition.
Wait, sir, I'll take.
174 surfacey matter, I appear for the bank. No amount has been paid pursuant to the interim order.
174,
ಹೌದು.
List day after tomorrow in fresh matters list.
Please, serial number 170, my lord. The matter pertains to the election of Federal Bank, my lord. Though, my lord, new taluka has been made, my lord, that is not.
Mandamus, my lord.
We are only seeking a mandamus, my lord.
ಯಾವ್ದಕ್ಕೆ?
170, my lord.
Consider, my lord.
ಲಿಸ್ಟ್ ಮಾಡ್ಲಾ? ಆಯ್ತು, day after tomorrow.
170.1, that's a different matter, my lord. There the election to the federal bank is stayed.
Fresh matters.
ತೊಂದ್ರೆ ಇದ್ರೆ after 20th. ಇಲ್ಲಿ dispose ಮಾಡ್ಬೋದು ಅಂದ್ರೆ ನಾಡಿದ್ದಾಗ.
170.1 can't be because, my lord, the election to the.
Why is it tagged?
Because it pertains to the same Apex Society ಅಂತ ಇದಾಗಿದೆ ಅಷ್ಟೇ.
We'll take it on 18th then. Yes. All on 18th. Yes.
Seeking only mandamus, my lord.
ಅವತ್ತೇ ಕೊಡೋಣ ಬಿಡಿ. We'll take it on 18th. ಇಲ್ಲ 10th, list on 10th.
Please.
Monday. Preliminary hearing.
Interim order is there, my lord.
Interim order continue.
Serial number 210 read petition. Serial number.
ತಗೊಂತೀನಿ ತಾಳಿ ಸರ್.
Please.
Yes.
Page number 45, 177 and 188.
Serial number 181, RFA matter. Short
FA
matter.
ಇಲ್ಲ ಯಾಕೆ?
ಅದು by
ಜನವರಿಗೆ
special order.
ಡಿಸಬಿಲಿಟಿ ಇರಲ್ಲ ಅವಾಗ.
Partition suit ಮೇಲೆ that has been decreed.
ತೊಂದ್ರೆ ಇಲ್ಲ. ಲಿಸ್ಟ್ ಇನ್ ಜನವರಿ ಅಂತ ಆಗ್ತದೆ.
ಅಲ್ಲ ಬೇಡ.
ಅವಾಗ ಅನಂತ ಹೆಗಡೆ ಸಾಹೇಬ್ರು
Very
ಇರಲ್ಲ,
short
ವಿಶ್ವನಾಥ್ ಹೆಗಡೆ
matter is there. No, since junior was
ಅದಕ್ಕೆ ಸರ್ ಅನಂತ ಹೆಗಡೆ ಸಾಹೇಬ್ರು ಇದಾರೆ ಅಂತ ಇಲ್ಲಿ ಬಂದಿದೆ ಅಷ್ಟೇ.
ಹೌದು.
ಆ ಜನವರಿಗೆ ಡಿಸಬಿಲಿಟಿ ಇರಲ್ಲ. List the matter in the first week of December. Yes. 230 ಹೇಳಿ ಸರ್, ಏನಿದೆ?
Please. The petition, my lord, challenging the notification issued by the respondent, Buddha, my lord, wherein, my lord, 91 notification has been issued and subsequently 27, my lord, as per section 27 of the.
ಸ್ವಲ್ಪ ಹೇಳ್ಕೊಂಬಿಡಿ.
As per section 27 of the Urban Development Authority Act, my lord, the scheme has to be implemented within 5 years from the date of publication of the 91 notification, my lord. 91 notification issued in 2003, my lord, and till 2009.
ನಾನು ಹಾಕಿದ್ದೆ ಮೇಡಮ್.
As observed by the similar matter, my lord, in respect to very same project, this honorable court has held that, my lord, scheme itself is not implemented.
ಯಾರಿದ್ದಾರೆ?
My lord,
ಪ್ರಣವ್.
please, my lord.
Tell me. Yes.
My lord, a similar matter has been went up to Apex Court, my lord, and it is held that the survey number cannot be dropped from the acquisition, my lord, as it is for the public purpose, and the possession was also taken on that day, my lord.
No. That is
ಇವತ್ತಿಗೂ possession.
Position, my lord.
I have, the
Position.
government has produced the judgment along with
It
the
may
memo.
be listed in. Position is not taken.
List the matter on Tuesday in preliminary hearing.
Please.
230.
Preliminary hearing.
Please.
ನೀವು 2:30ಗೆ ಕೊಟ್ಟು ಬರೋದಾ?
ಇಲ್ಲ, please.
My lord, serial number 56, it is posted for dismiss.
ಅದಾಯ್ತು ಸರ್, ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈಡ್ ವಿತ್ ಅಂತ ಹೇಳಾಯ್ತು.
Yes, nice one.
Tuesday. Yes.
Court officer.
Sir, ಹೇಳ್ರಿ.
Serial number 56, it is, we have complied all office subjects.
ಇಲ್ಲ ಸರ್, ಒಂದ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಗೆ ಇದೆ ನಿಮ್ದು. ಪ್ರೇಯರ್
First list 116.
ಮೆನ್ಷನ್ ಅಂತ ಇದೆ ಅಬ್ಜೆಕ್ಷನ್. ಕಂಪ್ಲೇಂಟ್ ಆಗಿಲ್ಲ.
ಇದು ಕೌನ್ಸಿಲಿಂಗ್ ನಮ್ಮ ಕೌನ್ಸಿಲ್
ಅದೇ ನಾಳೆ next
ಇಲ್ಲ
ಬುಧ
ಸರ್, ಕಂಪ್ಲೇಂಟ್ ಆಗಿಲ್ಲ, ಅದು ಡಿಸ್ಪೋಸ್ ಆಯ್ತು. ನೀವು ರಿಕಾಲಿಂಗ್ ಐ ಹಾಕೊಂಡು ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಕೊಂಡು
ಅದೇ ಬುಧವಾರ ಅಂತ ಹೇಳಿದ್ರೆ ಬುಧವಾರ ಅಂತ ಹೇಳಿದ್ರೆ
ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೆ.
ಉಳಿದಿದೆ ಸರ್.
ಬುಧವಾರ
ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೆ.
5 ಗಂಟೆವರೆಗೂ ಟೈಮ್ ಇತ್ತಿಲ್ಲ ಸರ್,
ಮುಂದಿನ
ಕಂಪ್ಲೇಂಟ್
ಬುಧವಾರ.
ಮಾಡಲಿಲ್ಲ ನೀವು.
ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬಿಡ್ತಿದೆ, ಅದು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿದೆ ಮೇಡಮ್, ಅದು ಇಂಟರ್ವ್ಯೂ ಮಾಡ್ರು.